And we are live and we are back and we are back. We're back, but Detective Dennis is not back. Let me go ahead and get myself all set up here. Wait for all of my people to stream on in. Wait for my people to get up in here. Everybody who's joining me this morning, make sure you say good morning or grand rising if you prefer. If you prefer to say grand rising, let me get a grand rising from you. And we have Chanel Moorhead, morning. Hayden S, morning. Here's my people. Taylor Dutton. What's going on? Everything's good over here. Taylor, Karen Jones, Grand Rising. Latasha, is that Malette? Carmela, Jay Savage. Vibe in my lane. Good morning. So, y'all, this is the YSL trial. And this has brought us all together. Taylor, exactly what I'm thinking. Yesterday was wild. Yesterday was wild, a wild day in the YSL trial. And let me go ahead and put the law and crime up so we can be ready. Yesterday was a wild day in the YSL trial, and the interesting thing is I kind of feel like this trial, even though Judge Whitaker is determined to get this trial, seems determined to get this trial to a jury, I just keep getting the feeling that Judge Whitaker is not going to be able to achieve that because things just keep going wrong. I think I told my wife, was it every 10 days, week to 10 days, 7 to 10 days, you have something crazy happen here with this trial. Every 7 to 10 days, you have something crazy happen with this trial. Today is Monk Tonk. Karen Jones says today is Monk Tonk. It's not clear to me whether we're going to be able to see Monk Tonk. By the way, y'all, I'm going to go ahead and share my X feed. And let me go ahead and show you my X profile. Institute DC. I am putting it into the chat. Please follow us on X if you haven't already. There are different opinions as to whether or not today will be streamed. I was looking at Thugger Daily yesterday. I don't know if I'm going to be able to find it right now, but I was looking at Thugger Daily yesterday, and I'm not sure I'm going to be able to find it, but Thugger, I believe, and if I have this wrong, don't quote me, but I believe Thugger is of the belief that it's going to be streamed, but I saw that someone else said that they don't believe it's going to be streamed, so I don't think we know about that. I don't think we know whether Monk Tonk's going to be streamed or not. What I found interesting was, why did Judge Whitaker say we're going to stop at 4 because a juror has a flight when the Monk Tonk hearing is supposed to be at 4 anyway and Whitaker's presiding? I don't get that. They're stopping at 4 because a juror has a flight. Well, isn't Monk Tonk supposed to be at 4 p.m. anyway? Thank you. Love the title of the stream. Thank you. Love that you love it. Okay. So I do think that Montong's supposed to be today at 4 o'clock. I don't know if it's going to be in the same courtroom. I don't know if it's going to be televised or streamed. I don't know. Dana, or is that, excuse me, Donna Hallman says, pray for Montong. I don't think anybody, well, I'm not going to say anybody. I think of the people watching this trial, we don't want to see Montong go back to jail. We want to see Montong do the right thing. We want to see Montong have a positive future. We want to see Montong walk the straight and narrow, if you will, make a positive impact on his community. I don't think we want to see Montong go to prison for 30 years because of his testimony. Yeah, Montong has admitted to doing some pretty jacked up stuff in his past. The type of things that destroys lives, the type of things that cause people to be traumatized forever. So I don't want to sugarcoat the kind of things that Montong has done, that he's admitted to. They're terrible. However, he's out right now, and to see him go to prison because of his testimony or lack thereof in this trial, the way this trial is going, that doesn't feel right to me. So the crimes he's committed, terrible crimes. And they deserve prison time, to be honest with you. I mean, these are things he's admitted to doing. However, he didn't get prison time. And now if he is to get prison time, it's as a result, not so much of the crimes, but as a result of his testimony in this trial. And that is what I feel doesn't seem right. Yeah, I mean, so we could talk about second chances. We could talk about all that stuff. And I think most people agree you do deserve a second chance, so on and so forth. I'm focused more on what would be the reason he would go to prison. And the reason they want to put him in prison today is because of his testimony. Yeah, Kaiji, he did his time already, but he's part of this RICO, Kaiji. So this is the weird thing about the RICO. It's kind of the RICO is kind of a end around for the whole double jeopardy question. Because when you have a particular crime that you commit, you can be tried for that crime, but that crime could also be part of a RICO conspiracy, which is a separate crime. So even if you either do time or don't do time for the crime itself, if you're kind of lumped into a RICO, that will have its own judicial process where you could be sentenced. That's why, if y'all remember with Woody, they gave Woody immunity for the crime. They gave him Woody immunity for his testimony, but Hilton was also saying, well, you don't have to worry about those crimes because they're past the statute of limitation. And Brian still came up and he said, you might not get prosecuted for that crime, but you could still be included in this RICO as a result of that crime. Does that make sense? So it is very, this RICO thing is kind of like a Medusa, or what is that mythological creature where you cut off one of its heads and then two grow back? Not Medusa. I forget the name of it, but this RICO is like has tentacles everywhere, and you really can't get rid of the tentacles because they come out from all different angles. Hydra, that's right. This RICO thing's kind of like a Hydra. Yeah, Jamie got it. Dee Dee got it. Taylor got it. It's kind of like a Hydra. Like you could get rid of this crime, but the RICO will grow back. You can get rid of that crime, but the RICO will grow into all of the little places where you got rid of the crime. Oh man, okay, I'm all for that crime, but they can put that overt act into a RICO. All right, let's talk about love. Someone behind the scenes got rid of love. One thing that's clear since last Friday is that that love is diminished. They had love actually. I mean, I'm not laughing, but they had her doing like the mundane interview this week. They had love doing like the wiretap guy or something, was it the gun expert guy or something like that? And Hilton took Detective Dennis, and you have Abate in there now, who he was never really a big part of this case as far as questioning witnesses, etc. Abate is in there now. It seems like love got demoted on this case, at least. It definitely does seem like love has been demoted on this case. All right. See, sometimes y'all have to refresh. You see how I had to refresh to get this? All right. No sound yet, though. Make sure my computer sound is on. All right, I have sound on my computer, just no sound in court so far. So, yeah, definitely looks like love has been demoted. A lot of people are saying Love needs to be fired. Love's not going to get fired for this. So, though people may feel like she needs to be gone, they're not going to get rid of Love just because of this. But she does look like she's been demoted. Time says the state hasn't shown any evidence. It's very difficult to put myself in the position of a juror and imagine what the jurors must be thinking. Remember, the jurors are not even to speak to one another about this case as of right now. The jurors are not even to speak to one another about this case right now. So that means that if they have done their duty properly, they have not spoken to another human being about this case for a year. They've been watching this case. They've been following along this case. They've been thinking about this case in their own brains and minds for a year, but have not spoken to anyone about this case for a year. Okay? So we don't know what the mind state of a person who's seen all of this and who actually hasn't seen some of the things we've seen, because we saw what happened with Detective Dennis yesterday. The jury didn't see that. We saw what happened with Judge Glanville. The jury is not supposed to know. The jury is not supposed to know that Judge Glanville was recused. The jury, if they did their due diligence correctly, does not even know that Judge Glanville was recused from this case. They don't know any of that. They don't know what happened with DA Love multiple times with her being chastised by the court. They did see her get admonished in front of them once, but they don't really know everything that led up to it. So when we say that they don't have any evidence, okay, if we haven't seen evidence and we've seen much more than the jury's seen, then presumably from a juror's perspective, there really isn't any evidence because they haven't even seen as much as we've seen. Okay, so we can all agree on that one. But we can't put ourselves into the mentality of somebody who has not seen all of the things we've seen, and also who hasn't even discussed this trial at all with anybody else, who's had to stand up and leave out of the courtroom multiple times per day, even come into the courtroom after having left out, come back in, sit down for 5 minutes, and have the judge tell you, "Oh, I'm sorry. Will you please stand up and go back out of the courtroom because of some?" We don't have that perspective. We don't have that perspective. So my point is, when we say there's no evidence, we have a lot more information than the jurors do. And we have the ability to discuss this with each other, to influence each other, to be outraged together, to be surprised together, we just have this community aspect where the juror doesn't.
Yes, so we've got Suri Chada here for Mr. Nichols today. That's CHADA, is that right? SURI? CHADHA. Sorry. NEZ. Okay, good. Anybody else?
The full name is Surinder Chada Jimenez. That's SURINDER CHADHA JIMENEZ. Good morning, Your Honor.
Good morning. There was a motion for reconsideration filed by the state yesterday afternoon. Could the defense file whatever response they want to file before Monday at 8?
Good morning, Your Honor.
Morning.
I could do that, or we can just argue it now. I think the state's cases and facts are not lined up with the reality of what happened in our case, and I don't believe that. I think it's specious. So I don't think, if you want, I can respond in writing, but I don't believe that the state's motion in any way should affect our time in this case, and we should move forward. And that's my position. I put it in writing, but.
All right. Well, what I'd like is if there are any post new evidence code cases with similar facts to ours. So I'd rather have something in writing if y'all don't mind.
I will, but there's a ton of
All right.
cases.
Well, you don't have to give me everyone. Just.
So the state is wrong.
Okay, I don't want to argue it right now. I want a written response. All right, appreciate it.
Your Honor, may
Yes.
we approach about another matter?
Yes. So, hello, Mr. Armstrong. I suspect that's why you're here, but can you come back on Monday instead?
Absolutely, Judge.
Thank you. It seems to be going in and out.
All right, y'all. Got an ad?
Time to move?
All right, I'm not supposed to have an ad plan. What's going on with that? Y'all, let's get an approach counter today. Let's get an approach counter today. I need to switch over to my other YouTube premium. Give me a sec, people. I must be on the wrong YouTube account. Y'all, let's get an approach counter today. Yesterday, we might have had like 20 approaches. So that is approach number 1. All right, let's get back into trial. Here we go. All right, we're on a break anyway, people. All right, let's get an approach counter. Where are my mods at? Where are my mods at? All right, so we have approach. I don't know actually how to make it stream across the bottom. I know how to make the ticker go, but I don't know how to change the ticker. So let me just make approaches. I'm going to just make so far we have 1. I'll make a note here till I can figure out how to get this on my ticker. Is Miss Love off of the case? We don't know. We don't know if Miss Love is off the case. We just noticed her absence. Crystal, they have not made any kind of announcement so far, so I don't know what the deal is with that. Will Sledge's revocation be public, or will his hearing be public? We don't know that answer either. What we do know as of right now is it's supposed to be in Judge Whitaker's courtroom, and it's supposed to be at, I believe, 4 p.m. Aside from that, we don't know if it's going to be public. Certainly hope it will, but we don't know. Says finally protecting Love from Paige. Y'all wouldn't agree that taking Love off of this case is a huge demotion and kind of like, in a sense, putting her, I mean, I could put into words, but taking Love off of this case would be a huge demotion, y'all, in my opinion. Hilton is fumbling the case. You don't think Love was fumbling? I feel like Love was fumbling the case. But I don't want to say just because Love was fumbling, that means Hilton is not fumbling. Yesterday, what happened with Detective Dennis, that was not really Hilton's fault. It was her responsibility, but it wasn't her fault. So she did not cause that to happen. That's why I say it wasn't her fault. She didn't cause Detective Dennis to speak out of turn that way. So that's why I say it wasn't Hilton's fault. It was her responsibility because she put him on the stand. So everything that he said essentially reflects upon her having either prepared him or not prepared him, reflects on the type of questions she's asking him, etc. So while it wasn't Hilton's fault, it was her responsibility. And, you know, I thought Hilton saved the mistrial. Okay? Let's be honest, y'all. Hilton saved the mistrial yesterday when she argued that Diamante Kendrick is charged in the indictment as a felon in possession of a firearm. She argued, Your Honor, either way, we are going to speak about Diamante Kendrick's being a felon, which implies he went to prison. It's not necessarily it's not necessarily true that he went to prison, because I imagine you could be a felon who never went to prison. I imagine you could have pled guilty to a felony and gotten probation, so you didn't actually go to prison. Maybe in some world that could happen, but I think it's close enough where when Hilton says, Your Honor, look, no, that shouldn't have happened. Detective Dennis should not have said that, but we were going to present evidence on some fashion that Diamante Kendrick had gone to prison, because we're charging him as a former prisoner, as a felon in possession of a firearm. That is what saved the mistrial, y'all. So give her credit. Any reasonable prosecutor should have said that, so it wasn't like she came up with some genius argument. But she did hit the ball exactly. She got the layup is the point. She's in an NBA game. She had a fast break layup and she didn't miss. You got to give her credit for that. Okay? Because sometimes people will miss that layup and you'll lose the game. So she did hit that. And that's what saved the mistrial. With that said, if she had properly prepared Detective Dennis, it's possible he would not have said that. So you can say, look, it is her responsibility to make sure that he doesn't say that. So for anybody wondering what happened yesterday, Detective Dennis, who, remember y'all, let's set the scene. The original two investigators, let me show y'all. Detective Dennis and Gaither. The two original investigators investigating the YSL so-called street gang are these two people, Detective Dennis and Detective Gaither. When we heard "Steal is horrible," when we heard somebody mumbling under her breath that "Steal is horrible," this dude and all that stuff, that was Detective Gaither. That was this lady here. She was not on camera though. Okay? She wasn't on camera because she convinced the court not to record her. By the way, y'all, I do have my eyes on the trial. They haven't come back yet for people who are nervous. They're not back yet. I have it on a separate screen here, so don't worry. We won't miss anything. So Detective Gaither was on stand. She was the one saying, "Horrible." She was the one saying, "This dude." I don't know how that sounds on your end. So, sorry. So that was her. Now, her partner, Detective Dennis, was on the stand yesterday. So she made a huge faux pas last week or the week before last, with her horrible stuff. Huge faux pas. But now we had Dennis on the stand yesterday. He was talking about Diamante Kendrick. And when he was explaining a photo of Diamante Kendrick standing on not Yak Gotti, he is Yak Gotti, of Diamante Kendrick, who is Yak Gotti, standing on YFN Lucci's blue Mercedes. See if we can find that. This guy here, Dennis, was on the stand yesterday, and he was presenting evidence of Yak Gotti. I'm going to see if I can find a photo. See if we can find a photo of Yak Gotti. Okay, here we have it. Looks like we might be about to come back. This is Yak Gotti standing on Lucci's car. So Dennis is talking about this, and he mentions that Yak Gotti was like, he either says something like, yeah, he had just come back from prison, or he had been in and out of prison, or something along those lines. Now, that violates Rule 404A, and I would say probably 404B as well, which is an evidence rule. And you can't just blurt out somebody's criminal past in a criminal trial. You can introduce the evidence, but it has to be done carefully. It has to be done with notice. You can't just blurt it out. You can't just say, "Oh yeah, the guy on trial now for a crime, he's been to prison many times." You can't do that. You can't do it. It is a huge problem. It's not just like a little problem. It's a big problem. It's explosively big. It's so big that it can result in literally a mistrial and the trial being over. And that's what almost happened yesterday. Dennis casually mentions that Yak Gotti was either coming out of prison or had been in and out of prison or something like that. We don't have the audio because the audio's been jacked up, so nobody got to hear it. Miss Lily, good morning. Explaining what happened yesterday. But Dennis, as a seasoned police officer who is now retired, he mentions that yesterday. And Diamante Kendrick's attorney, Doug Weinstein, immediately gets up and says, "Your Honor, you can't fix this one. I'm moving for a mistrial. The jury cannot unhear what they just heard." And Weinstein was right. This prejudices his client, Diamante Kendrick. Why? Because Kendrick is on trial for a crime or for several crimes. And here we have a detective testifying that he has a prior criminal history. Again, you can do that, but you can't just do it haphazardly. You have to go through several steps and certain steps to present the evidence that somebody has a previous criminal past. That's not the way it was done yesterday. So Doug Weinstein moves for a mistrial, and we were this close to it. But Hilton, to her credit, this was a layup. This was not rocket science for a lawyer, but this is what she had to do, and she did it. Hilton argued, "Well, Your Honor, we are charging Diamante Kendrick in this indictment as a felon in possession of a firearm. Therefore, we are telling the jury in the indictment that he is a person who's been to prison. So the fact that the detective just said that does not unfairly prejudice Mr. Kendrick, because, again, this information was coming in during this trial anyway. And the judge agreed with Hilton and said we won't call a mistrial. But because Detective Dennis's role is not to make that determination, and he just blurted this out, she permanently barred Detective Dennis from testifying anymore in this trial and struck everything, eliminated, erased, got rid of all of his testimony from yesterday and his exhibits, or the exhibits that he was discussing. They're not his exhibits, but the exhibits that he was using as demonstrative aids to explain to the jury. And the funniest thing, the most interesting, the most ironic, the most, well, would you look at that type of thing, was that he had just finished qualifying himself as an expert. So he had just finished qualifying himself as an expert when he did the most rookie mistake. When he made the most rookie mistake. So he's like, I'm an expert. And then 5 minutes later, he does something that almost ruins the entire trial. Okay. So there was an actual debate, argumentation back and forth in court yesterday about whether he was an expert or not. Judge Whitaker says, all right, I will allow it. He's an expert. And the next thing he does is a rookie mistake that almost ruined the entire trial. Like, that's what made yesterday such a movie moment. That's what made yesterday such a movie moment, because they built him up. They built him up past just detective. They built him up past just investigator. They built him up to expert status. And then the first thing he does is to almost ruin the trial by saying something that a rookie police officer should know not to say. Okay? So anybody who's wondering about what happened yesterday, that's what happened. So I believe this motion that we just heard, let's just go back and listen to this real quick. Again, I do have the trial on a second screen here, so I will know when they come back. I think the motion that Brian Steele is talking about right now, he says reconsideration. I believe that the prosecution has probably come back and said, Your Honor, will you reconsider this ruling barring Detective Dennis? Y'all, Detective Dennis is part of the two detective duo. And then you got Detective Thorpe, who's like the third wheel. He's part of the two detective duo who kind of made this case, y'all. So if you get rid of Dennis, if you get rid of Dennis, then you get rid of a lot. Okay. And yes, Miss Lely, I know they filed the motion, and I'm going to play this again because Brian Steele actually is opposing the motion.
We can just argue it now. I think the state's case.
Again, I know when the trial comes.
Monday at 8.
Good morning, Your Honor.
Morning.
I could do that, or we can just argue it now. I think the state's cases and facts are not lined up with the reality of what happened in our case, and I don't believe that. I think it's specious. So I don't think, if you want, I can respond in writing, but I don't believe that the state's motion in any way should affect our time in this case, and we should move forward. And that's my position. I put it in writing, but.
All right. Well, what I'd like is if there are any post new evidence code cases with similar facts to ours, So I'd
Is it-
rather have something in writing if y'all
Okay.
don't mind.
I will, but there's a ton of
All right. Well,
cases.
you don't have to
post-
give me everyone. Just,
So the state is wrong.
okay, I don't want to argue it right now. I want a written response. All right, appreciate it.
Your Honor, may we
Yes.
approach about another matter?
Yes.
Okay, so that was the moment. That was the brief little discussion about this. I'm checking on. I tend to check two people, y'all. Give Thugger Daily his props, which he certainly deserves. He will usually have these types of motions first. Him and another guy. I don't see anything from him. I don't even see anything from him today, y'all. So that is unusual. But Thugger Daily is he's a regular guy. I mean, he's not a journalist, even though he probably should qualify as one. So he's probably at work. Let's wish him well. And Joseph, Joseph, Joseph Papp, he's normally in court, and he'll normally have things up early as well. Neither one of these guys have tweeted today, so I don't know what's up with that. Cat Williams on. Okay. Y'all, Cat Williams is my favorite commentator. When y'all see me do my thing, I'm trying to be like Cat. She's one of my favorites. AV as well, I think is excellent. Oh, look at that. Cat has it. Cat is excellent, y'all. So if I'm ever not here, Cat, she's the person to go to. She's great. Okay, so let's see here. So Kat's probably already been reading this. She has the motion to reconsider. Should we read this right now, or y'all want to wait for a while? I feel like if I start reading it now, court's going to come back. Let's wait a minute. So Miss Lely, yes, Kat does have it. We have it right here. So let's give thanks to Kat. Always give Kat her credit. According to herself, she's not a legal professional, but Kat has a very deep and very comprehensive understanding of everything that's happening. Absolutely love listening to her explanations. Also, AV to the seventh power as well. I tend to go with Kat, but AV is excellent as well. So I don't know. This is one of those weird moments where I feel like if I start reading it right now, the court's going to come back in 2 minutes and I'm going to have to stop. So maybe we'll just scan it. Let's just scan it. All right. So it's about Detective Dennis. Background: during investigator Dennis's testimony, he referred to actions Demonte and Kendrick performed immediately after his release. Defendant removed for trial with this court appropriate. Defendant Kendrick removed for mistrial with this court appropriately denied. Okay, as a sanction for this event, however, the court struck the entirety of Dennis's testimony, precluding him from testifying in the future, and struck scope of the state's claim. It is appropriate for the court to strike a witness's answer from the jury's consideration when it contains information, blah, blah, blah. The state submits, however, that the order striking the entirety of his testimony, precluding the witness from testifying in the future. That's why my thumbnail yesterday was permanently banned. I was telling my wife, y'all, it feels so good when you can just make a provocative title that is absolutely right on point. Juanita, can I answer your comment? I certainly can. Could you just copy? Okay, here we go. Would it be best for the defense to have acquittal, then a mistrial? So, Juanita, you would not get acquittal, then a mistrial. Yes, acquittal is better than a mistrial, 100%. Acquittal is better than a mistrial particularly because this is a RICO trial that includes all kinds of different charges and indictments. If they get off on, if this is like a true clean acquittal, it would be hard. The only thing that could happen after that would be federal charges, but the state would be pretty much 100% defeated if you get an acquittal. If you get a mistrial without prejudice, then the state could bring the charges back. If you get a mistrial with prejudice, then the state is also defeated. But I'm not sure if the state could appeal that to a higher court and maybe get it and maybe get the mistrial with prejudice overturned. I'm not sure of that. But in acquittal, that would be pretty much case closed unless the federal government wanted to then take up charges, which I imagine they don't. So yes, acquittal is usually going to be your best bet. Okay, so there you have it, Miss Juanita. Can you become a member now since we giving you special attention, since you demanding that I answer your comment? I need you to become a member, Miss Juanita. I gave you special individualized attention this morning. Okay, so we still are not back. I'm going to pop back over to the court just so y'all can see that in case you're getting antsy. Still are not back. We're live. Nothing's happening. So let's continue to read. I got to figure out how I can bring this up while still seeing court. Okay. So as an exclusion of evidence, which the law does. Oh, hold up. The state submits, however, that the order striking the entirety of the witness's October 17th testimony, precluding the witness from testifying in the future and excluding exhibits which had been admitted through that witness, was improper as an exclusion of evidence, which the law does not permit. The state, okay, so basically they just said to Judge Whitaker, you took an illegal action, unlawful action. I like to use illegal when it sounds like a crime and unlawful when it's something that is not according to the law, but it's not a crime. So Judge Whitaker did not commit a crime. She did an action according to the state, which the law does. It's unlawful. The law does not allow it. So then they go into some evidence rules. They go into some case law. The universe of specific exclusionary rules is limited by statute. First, Georgia Rule 402 explains that otherwise relevant evidence may be excluded based on rules grounded in constitutional blah, blah, blah. Okay, this seems like the key part here. While OCGA, this Rule 611, permits a court with control over the mode and order of witness examination, permits a court with control. I don't get that. That permits a court with control. Okay, it's a weird way of putting it. Rule 611 does not authorize an order excluding evidence and thus would not justify the order at issue here. Rule 611 mirrors Federal Rule of Evidence 611 as that rule reads in 2011, blah, blah, blah. Thus, Georgia courts look to federal authority, blah, blah, blah. Unlike the vast majority of other evidence rules, Rule 611 does not purport to regulate the admissibility of evidence. So it sounds to me like they're arguing that her order under Rule 611 is not lawful. But does that, let's just say they're right. Does that mean that there is no rule that allows her to bar evidence? Or are they just arguing that she cited the wrong rule? That would be my question. And this is why Brian Steele absolutely should put his response in writing, because what he just said when he stood up, I don't think goes far enough. Rule 6, he needs to show, I imagine, really, the weird thing is that they're really not going against the defense here. They're going against the judge here. So, you know, the defense is going to make a response, but it wasn't the defense that took this action. Okay, yeah, but it was a defense objection. But it was for a mistrial. The defense did not make an objection and request that Dennis be struck. The judge denied the actual mistrial motion. So that's done. And the judge took it upon herself to bar Dennis, right? So this prosecution motion for reconsideration really is against what the judge took it upon herself to do. She denied the actual motion but did Bryant still make a motion? I have to go back and review it. And see if this came from a motion from the defense. Unlike the vast majority of other evidence rules, 611 does not purport to regulate the admissibility of evidence. Instead, the rule gives trial courts broad powers to control the mode and order of what is otherwise admissible evidence. Although decisions that a court makes under Rule 611 may indirectly affect whether proof is admitted, the rule does not provide an independent ground for excluding otherwise admissible evidence. So the interesting thing about this, and I'm with you, Miss Lily, y'all, let's get some likes. I'm about to spam some likes in the chat real quick. Can we get some likes, please? Let me see. I got to find my like button. So the interesting thing about this is they're basically asking the judge to admit that she was wrong with how she went about handling the Detective Dennis situation. So I want y'all to all understand this. The judge, she's presiding over this case, and she's going to have to consider this motion. And this motion is essentially pointing, as Judge Whitaker reads this motion, the motion is pointing a finger literally to the person reading it, which is Judge Whitaker, and it's saying, you thought you could do this, but you can't, and I need you to undo it. You, the person reading this, Judge Whitaker, you thought you could do this, but you don't have that authority. Or if you do, you don't have it under this rule that you thought gave you the authority. Therefore, I need you to undo it. I don't know how that's going to fly. Because essentially for Whitaker to grant this motion, she would have to admit that she herself thought she could do something under Rule 611 that she couldn't do. It doesn't feel very likely that Judge Whitaker is going to say that. Everybody, do subscribe to us, please. Do subscribe to us. Y'all, in case you don't know, we are actually a paralegal school. Believe it or not, we're starting a new paralegal class soon. Usually I teach the classes, but I'm in here with y'all all day and all night now. So we'll be bringing in some different instructors for our class. We're nationwide, even though the name is Paralegal Institute of Washington, D.C. We are a national paralegal program, legit. We've been around for 20 years. Our program includes an internship, job assistance, and we work across the country. It's virtual, by the way. So if you're interested in that, I should probably put a link in the description or something so y'all can reach out. If you're interested in that, do reach out to us. We're not hard to find. I'll put a link in the description. Do hit the like, do hit the subscribe, please. Papa Bear says, but is her ruling part of her sanction? Correct. So Judge Whitaker made the ruling. Judge Whitaker, her ruling is the sanction, which is to, that's why yesterday people were like, oh, first when she said she's denying the mistrial, everybody was disappointed. But when she said what she was going to say about Dennis, I was like, y'all don't have any reason to be disappointed. She just went hard on Dennis. Let me get back to the trial. Still don't have any action, y'all. I was like, y'all don't have any reason to be, oh yeah, let me drop my link. Let me drop the link here. Very good, Papa Bear. I was like, y'all don't have any reason to be disappointed because Judge Whitaker just made the correct ruling, and she didn't go easy. That was a very powerful statement that she made. Y'all, I just dropped the link for the paralegal school. By the way, since we're not back yet, let me show y'all. This is the paralegal school, y'all. If you want a consultation, you can come here. We're national. We have testimonials. We have all kinds of stuff, y'all. So might as well give us a plug, right? We go over bankruptcy, civil rights, criminal law, contracts, all this stuff. All right. So if y'all are interested, I just dropped the link in the chat, and I'll be putting it in the description as well. So the link is in the chat at the moment. All right. So Max Shark said that it sounds like this, whatever they're talking about now, is probably unrelated. Kaiji, you want to know how much is our school? Our program is $19.99, so it's just under $2,000. This is what I think is going to happen, y'all. I think we're going to run a super sale coming up soon, going into the end of this year. And then I believe very strongly the price is going to go up significantly in 2025. The program used to be $4,000 before the pandemic, and it was only in person. So this program was in person. There was no online program. Just due to luck, pure dumb luck, we were making an online program in the few months leading up to the pandemic. We were just, hey, let's make an online program. And then the pandemic hit, and we were just close enough to having that done that we transitioned smoothly, and everything's been online since. But this started off as an online, as an in-person program from 2003 until 2020. And now it's online only because we figured out, we don't even need to have a physical office. But at the time it was in person, it was $4,000. Once we went online, the price has varied, but we have been at $2,000 for, I guess, a couple of years now. Okay. So I think we're going to run a super sale. Look out for that. It's going to be much cheaper. You know, I can't tell you the exact price is going to be, but it'll be cheaper coming up here in the next few weeks until sometime this year. Next year, it's almost certain we're going back to the 4,000. Okay. So anyway, I don't want to do too many commercials. Y'all are going to start seeing a few more commercials in the videos though, because we need to get the word out. But I haven't seen you this year. Yeah, pass on the info, y'all. Y'all, we do an excellent job. I think the most important thing is the internship. Y'all are going to start seeing more information about the paralegal thing. This is a very long break, y'all. They've been going for, let's see. Shark asked for that to approach
About another matter.
35 minutes ago. So yesterday, I don't think we had one approach that lasted 35 minutes. Andrea, I was just explaining to everybody that the reason the name of this channel is Paralegal Institute of Washington, D.C. is we are a literal paralegal school. If you look at some of our old videos, it's all paralegal related stuff. It's instruction, it's all kinds of stuff. So I was just explaining that to everybody. Let's do a poll. Y'all give me, I'm going to do a poll here. Miss Lily put me onto the polls yesterday. I'm going to do a poll. Give me some answers that we can put in here. The question is, what do you think this long aside is about? What do you think this long or approach? What should we call it? Bench conference is about. Give me some examples. Here comes a poll, but I need to put some answers in here. Max Shark asked for a long bench conference. Will we even, but the thing is, how will we even know? Like sometimes they come back from these bench conferences and now let's do something else. Let's do something else, y'all. Because it's possible that we won't even know about that. Let's just go with a yes or no. Will there be a mistrial? Will there be a will there be a mistrial motion today? Will there be a new mistrial? Will there be a new mistrial motion today? Okay. Will there be a new being a new issue that arises today for the first time? Not a renewed motion, basically. Okay. Will there be a new mistrial motion today? Not a renewed motion from previously, is what I'm saying. A motion for something that either happens today or that they uncover today or something along those lines. Papa Bear, this is approach number 1 as far as we can tell. They have not come back from the first approach, which started about 40 minutes ago at this point. 38 minutes ago. All right. Steele said we cannot cross-examine, so testimony and evidence must be struck. 100%. 100%. So the prosecution, have y'all noticed that the prosecution, their lawyering skills, the prosecution's lawyering skills, there's something to be desired. Let's go back to this motion real quick. Let's go back to this motion because court has not come back. Further, blah, blah, blah. There's no constitutional right for the same reasons, blah, blah, blah. Okay, let me tell y'all why I'm saying their lawyering skills leave much to be desired. I would say in this kind of motion, there are obvious defense, pushbacks, counterpoints, arguments that you can anticipate. Kat, you just said, Steele said, we cannot cross-examine, so testimony and evidence must be struck. If you have what I would consider high lawyering skills, you would anticipate that pushback in this motion, and you would present a pathway forward as to how the defense can have their rights assured if the judge were to give you what you're asking for. So you would say something like, we propose, or I don't know if the word propose would be the best word, but for lack of a better term right now, we propose that the defense can cross-examine Detective Dennis in this way, and the defense can have their rights guaranteed, their other rights guaranteed in that way. But here, it's like, if they don't want his testimony, his full testimony to be struck, that means whatever he did say will not be struck, right? And so then Steele's, well, we need to cross-examine him, comes into play. If you have high lawyering skills, you should resolve all of those problems and present that problem in your motion so that the judge doesn't have to think about it. So that the judge doesn't have to leave these kind of hanging open questions there. So that she can read this and say, okay, if I go with what you're saying, this is a way that it could work. Now, the defense could still argue it, but at least you've painted a picture for her. But instead, they're not considering any rebuttals. They're not considering the defendant's rights. They're just saying, hey, judge, will you give us what we want? Well, if you want to be persuasive, talk about how everybody can get something. Give the judge a picture that's painted so that she won't have to have these question marks in her head. Y'all see what I'm saying? But instead, they're just saying, give us what we want. Well, you're not anticipating what the defense, they already said to you yesterday what they're going to say. So you already know what they're going to say. So you could easily include that. But besides that, even if you didn't know what they're going to say, it's your job to anticipate it anyway. What would we say if we were on the other side? Let's address that in this motion. Let's present the judge with something that looks like we're trying to be fair to the defense. Do try to be fair to the defense. You know, I've heard rap music and watched movies. Yeah. I think Attorney Adams's challenge to the expertise of Dennis was right on point. Y'all, if you know what the butterfly effect is, the butterfly effect is that a small little thing happening over here can affect something over there due to small little changes in the environment and so on and so forth. And it looks like this big effect that you see over there, you would never think to connect it to this little thing that happened over here. You know, this thing, this little whatever this is, falls down, and then tomorrow somebody gets in a car crash. And you're like, well, you would never think that this thing falling had something. What am I getting at? Adams might have created that butterfly effect with Dennis. Dennis was pumping his chest up. Dennis was bigging himself up. Dennis was talking up his own expertise and his own expertise and experience, etc. That could have contributed subconsciously to him just blurting out something that he shouldn't blurt out. We can't prove it. It's just just talking, right? But Dennis was in a, I'm the man, I know what I'm talking about kind of mode. And particularly when Adams challenged him, Dennis had to assume that kind of mode. And that could have, due to hubris, contributed to Dennis saying something he shouldn't have said. Again, there's no way to know. Still can't believe that man's expert opinion was based off watching rap videos. Again, part of Whitaker's determination that he was qualified was that it appeared there was a previous determination that he was qualified. All right, so somebody's just throwing some news in. Thank you for that. I was expecting his expertise would be undercover police in the drug trade, former gang member, but nope, he watched movies, lives in the hood, and listened to rap music. So, y'all, let's talk about the university system. Let's talk about the school system. The reason we have a university system, reason we have a school system, the reason that there are things like the paralegal program that we offer is because we like, in this country, we want standardization. We want standardization, meaning that an expert in the field of rap lyric interpretation should be able to talk to another expert, and they should have had a common core of a common curriculum that at least is somewhat similar that they have both gone through. They both should have gone through a common or similar curriculum so they can say, oh yeah, I read that book. Oh, I didn't read that book, but I read this book. It would be like there would have been a curriculum that one expert would recognize another expert's curriculum because they both went through some kind of education and or training that, though maybe not the same, would be similar. That is what Adams was getting at. He was saying, okay, well, what curriculum did you go through? And Detective Dennis is saying, well, I had a lot of experience. Okay, that's fine. But in our country, typically to become an expert at something, there's a standardized curriculum that you have to pass through with certain learning points, with certain experience points, with certain tests that you have to pass, with a final exam, with a certification exam. These are the ways that we determine expertise in this country. So to say I'm an expert because I've been in it so long, that might work if it were a totally new field, something that you invented yourself. If you were the person who invented the first robot, 20 years later, you would be able to say, I'm a robot expert. I invented the first robot. Like, this is me. I made this field happen. Okay, then you get an exception. You invented the entire robotics industry. you get an exception, sir or ma'am. But aside from those kind of cases, we want somebody to go through a curriculum. We want them to have learning points. We want there to be some kind of syllabus. We want there to be grades on a paper. We want there to be research papers written. We want there to be tests taken, and we want a certification exam. Now you've passed the exam. You are now considered an expert in that field. Right? They should have gotten a reformed gang member to testify on gang activity if I was them. Well, remember, Papa Bear, the question at hand yesterday was about lyrics. And I would agree with Adams, because see, Adams, what he knows, I think intuitively, is that there is no gang, there is no expert at interpreting lyrics, rap lyrics, as it relates to gang activity. That person probably doesn't exist, because being an expert in gang culture does not mean you're an expert in interpreting lyrics. You would almost have to be both an expert at poetry and an expert at gang culture. Poetry as in rap poetry, rap lyrics. You would almost have to be an expert at both. And so you could maybe be an expert at gang culture, but that doesn't make you an expert at interpreting lyrics. Does that make sense? And I think you need somebody who melds the two. That person in a way that you would recognize them as an expert. You know how he would be considered an expert without having gone through a curriculum? If he wrote the book. If there's a textbook out there that people are using and he wrote it, then you could call him an expert. If his name is on a book that he didn't write, but he's a contributor, then he could call himself an expert. If there's how to interpret rap lyrics in gangland, how to interpret gangland rap lyrics, or something like that. He wrote the book. He's a contributor in the book. He was interviewed by the book's author for his contribution. Then he can make a reasonable claim to be an expert. No curriculum, no college, no university, but he's a contributor. Wouldn't they have to be an expert to the SIDS? Yes, that's the thing. That's the problem. Because how many of y'all have been watching this trial and they put on these jailhouse recordings? Some of these interrogation videos and whatnot, the audio is not so good. But haven't y'all heard some pretty good audio and you listening to these Atlanta guys talking? You like, yo, what are they saying? Like, I've been listening to hip hop. I've been listening to slang since I was a little kid. I didn't know what they were saying a lot of the time. Now, if you put on some DC guys who are talking, I'm going to know what they're saying. You put on some PG County guys, you put on some DMV people, even maybe some Baltimore people, I'm gonna be there with them. But the Atlanta cats, they were talking, I'm like, what? What? So it's not enough. But he is in Atlanta though, so that's to his credit. But it's not enough just to know about gangs. You need to know about the Atlanta gangs, and you might even need to know about the Cleveland gangs and the Mechanicsville gangs, because there's going to be differences. But maybe it's enough just to know about the Atlanta gangs, about their structure, about their slang, even about how they evasively talk on the phone. Because I'm going to tell y'all something. A lot of the reason we couldn't understand them talking on the phone is because they were talking, in my opinion, they knew they were on the phone. They wanted to communicate, but they weren't talking the way that they usually would just talk in person. So I think, Lexi Lynn, I think a lot of what we heard, even just regular conversations, is like, okay, this is what's going through somebody's mind. I'm on the phone. I might be being recorded. So I'm going to say what I have to say, but I'm going to try to put a little something on it just in case somebody's listening. Maybe they won't understand me. So I don't think that's how they literally would just stand and talk face to face. A lot of that. They were talking in codes. Almost every phone call, I think they were talking in codes. So it was so that somebody like you or I wouldn't understand it is the way that I understood it. Yes, Miss Juanita, Paralegal Institute of Washington, D.C. We are in the DMV, right? We are in the DMV. Amy, I agree. The music could be made up of fictional stories, how they're going to say what they should and shouldn't be using lyric wise. I don't get it. And I'm honestly, so y'all, let's be honest. A lot of these guys do talk about their crimes in their music. I'm going to put something on real quick. Again, everybody who's watching me, don't freak out. Don't kirk out. That's something we say here in the DMV. At least they used to when I was a kid. Don't freak out. Don't kirk out. Don't out, or any kind of out. I'm looking for right now. I'm not gonna play. I'm not gonna play the. I'm not gonna play the audio. I don't want to have a problem. But y'all, check this out. They played this in court. This is threat, y'all. This is somebody who Little Woody calls threat. This is the actual person. This music video came out during the pandemic 4 years ago. Donovan Thomas was killed 5 years before this. Okay. This is actually threat. Okay. That's the real threat. This is Lil Woody. Just so happens that I stopped, not on purpose, on a slat. Okay. This is Lil Woody. This is threat. Okay. The name of the song is Homicide. Y'all can't see it because of my head. Homicide. This guy, in case you don't know, take a look at this guy. Take a look at this guy. Look what's happening to him. There's money and it's being put on his head. Now look at this guy. Now, for people who don't know, take a look at a picture of Donovan Thomas. Take a look at a picture of Donovan Thomas, and now take a look at the person who they depict in Lil Woody's rap video, who they're putting money on his head. This is Woody right here. Now, I'm not snitching, y'all, because this music video has been shown during the trial, okay? So this is, people know this. So they're putting money on this person's head. Who is this guy? I don't know. But Threat is in the video. Woody's in the video. And somebody who looks an awful like somebody else has money being put on his head right here. And what do you think is going to happen? This is some light-skinned guy. I don't know who this is. This is Threat. What do you think is about to happen to this guy? Okay, well, let's see. That's what happens to this guy. This guy who looks an awful lot like this guy. Is it just by accident? Is it by accident that this guy resembles this guy in a rap video called Homicide featuring Threat and Lil Woody? In fact, it's not just featuring Lil Woody, it's actually Lil Woody's rap video. Am I saying Woody did something? I'm not saying he did anything. But what I am saying is, when we're talking about fictional stories, this could be a fictional story, right? So I'm certainly not in a position to say who did what. I'm not in a position to say who did what, but your name was in it. Your name was in this. You were arrested for this. You were charged with this, but they dropped the charges. You didn't have to go to trial for this. But 5 years later, when there's no smoke, you make a rap video, apparently, and I don't know what was in his head. I can't say what he was thinking, but it's called homicide. It has threat. Who Woody says he and this fella, who's now deceased, he said they went and shot up Rich Homie Quan's father's barbershop. Woody said that on the stand. So I'm not breaking any news here. He said that on the stand. This guy was murdered like 2 months ago, 2 or 3 months ago. Yeah, Threat was murdered 2 or 3 months ago. We don't know if it was. I never heard what that was about. So I don't know what actually happened with that. By the way, court is still not back for my antsy people. We're still not back. So we're just kind of filling in the time here. So Threat was killed a few months ago. Was it connected? Wasn't it? Nobody that I know of, unless somebody can drop some kind of information in the comments. I don't know. But this just goes to the people who say, is it just fiction? The funny thing is, this actually, I think, proves that it could just be fiction because, frankly, a lot of people are saying Woody did, well, the prosecution says Woody didn't do it. So imagine Woody didn't do it. Then this would literally just be totally fiction. But this is my question to you. I will answer this in a second. This is my question to you, y'all. This is my question to you. Before I ask the question, Silk the One, I agree with you. Please, y'all, hit that like button. We're keeping it moving while there's no court. Thank you, Miss Lily. Miss Lily got me if court comes back in. Pineapples. Okay. So this is my question to you. Pineapples, I'm going to ask this directly to you. Again, I'm not suggesting that anybody did anything. I don't know who did what. I'm just showing y'all a music video that was shown during the trial. Everybody knows everything that I just told you. The prosecutors know who Threat is. They seen this video. They showed it already. They know who Woody is. There's no new information. I'm just telling this to people on this stream who maybe didn't know. But this is my question to you, Pineapples, and to everybody else. If you thought Woody did this, if your job is a prosecutor, if you are a prosecutor, if that's your job, and you thought Woody did it, and I am not saying I think that. I'm just saying in the supposed pretend world where you, Pineapples, are a prosecutor, and it's your job to lock somebody up for this, and you think this guy did it, and you see this music video, are you telling me you wouldn't want to use this as evidence? That's my question. My question to everybody on this stream is, if your job were prosecutor, and if you thought this guy was responsible, which I am clearly stating I don't have any clue about, but we're in the pretend world of pretend. If you thought that and you saw this video, you telling me you wouldn't try to use this? Y'all would have to be loco to not use this. Heck yeah, I'm using this if I can. Heck yeah. I'm using everything. I'm using the title. I'm using all of the images, any of the lyrics that seem to line up with something. I'm using all of it if I can. I'm trying to get it in. If that's what I think, if I think this guy did it. Now, if I don't think he did it and I try to use this, now that is misconduct. Is it right? Yes, it's right. If you think he did it, Papa Bear, of course it's right. If you think he did it. If you don't think he did it, then it's wrong. If you don't think he did it, then it's wrong. If you do think he did it, then it's right. In other words, it's not a violation of his rights, of his First Amendment. People say, oh, what about the First Amendment? The First Amendment is you cannot be prosecuted for what you said. The First Amendment is not nobody can use what you said against you while prosecuting you for what you did. I'm going to say that again. The First Amendment is you say something, the government can't come up. You criticize Joe Biden, now they're going to lock you up for that. That's First Amendment. I'm going to go back to the trial. It's not back yet, but I'm seeing some movement. First Amendment is you criticize the president, they lock you up. No. You criticize the governor, they lock you up. No. You come out against a new law, they lock you up. No. You come out against a proposed law, the government gives you a fine. You can't do that. That's First Amendment. But can the government use what you said against you in a trial for what you did? Of course. That's what they do. That's what they do every day. You did something, then you said something about it. Now they're going to use what you said against you. Of course. Of course. So they can use what you said against your artistic sayings, your artistic expressions. Yeah, they can use that against you. So, but the key is, do they think you did it? That is the key. If they're using your artistic expression to make a case against you in something that they don't think you actually did, but it's convenient that you said this thing so they can get a conviction, then we have a problem because they don't actually have a good faith belief that you did this thing. Does that make sense? So for people who you shouldn't be able to use artistic expression against, why? Yes, you should. 100%. If you think the person did the crime. Yeah. Now, but see, Miss Lely, the difference is, First Amendment is you can't get in trouble for what you said by the government. But using your lyrics against you is not getting in trouble for what you said. Using your lyrics against you is you did something and now they're using what you said to help prove what you did. That's what that's what the wiretap is. You did something. Now you're on the phone talking about it. We're going to use your words where you talked about what you did against you in court. Same thing if you rapped about it. Same thing if you wrote it down on a piece of paper and passed it to your friend. Same thing if you painted a vivid painting of you in the act. Yes, I want that painting and I want to show the jury. We said he blew up the car and there were certain things that nobody could have known except the person who did blow up the car. And then he went home and painted this painting, and wouldn't you know, certain aspects of this painting match the actual event. And those are things that only the person who perpetrated the blowing up of the car could have known. I want to show that painting to the jury, even though it's a painting, even though it's a photo, even though it's a rap song, even though it's a whatever. I want to show all that stuff to the jury if I think you did it. Okay. Again, y'all, another disclaimer. I'm not suggesting that Woody did anything. So, I don't have any information. It's not my place. I just thought it was a convenient example because this was shown in court. So, and it has to do with this trial. Woody's interrogation videos were leaked online and Woody was going to plead the fifth. So I'm assuming that's why he was granted immunity in the ex parte with the understanding he can. Well, I think the main thing is Woody said he was going to plead the fifth. So I don't even know if the interrogation leaking had to take place for the immunity thing. Remember, they gave Quindarius Zachary immunity as well. They're talking about giving immunity to Duke. So the immunity is a ploy by the prosecution so that you cannot plead the fifth. So they can essentially make you answer, even if that answer is I don't recall. The immunity, the way we've seen it, because these are not deals. Every person on this stream, I imagine, has heard of immunity as a deal. Hey, I'll help you out, but I want immunity. So it's like a give and take. What we saw with Woody was not a deal. That was not a, hey, if you give me immunity, I'll talk. In fact, it was exactly the opposite. I won't talk, and because I won't talk, you're forcing me to have immunity so that you can force me to talk. So it's not a deal. It is a forcing action. It's not a willing, voluntary action between two parties that enter into an agreement. It is one party is obstinate and will not cooperate. So the other party with more power forces you to cooperate or puts you in jail. So that's what happened with Woody. I'm not sure that the leaked video really had much to do with that part. Pineapple says painters paint vulgar art. Does that make them criminals? Okay, so again, this is the part where I feel like there's a misconception. People say, is it a crime to rap? No. Is it a crime to rap about a crime? No. The crime that you rapped about is the crime. The rapping about it afterwards is just not smart. The crime that you rapped about is the crime. The rapping about it is the part that's just not smart. So, but it's not a crime in and of itself. So painting a vulgar picture or painting a vulgar painting probably is not criminal. But assaulting somebody and having them laying there on the floor, hurt and injured, and then saying, I'm a painter, I'm going to paint this scene of you laying there bleeding out. And then you paint it. The painting of it is not a crime, but you did just assault that person. So when they find a painting and it matches the exact person that they see on your floor, yeah, they're going to want to introduce that painting as evidence. You did not commit a crime by painting the painting. You committed a crime and then you confessed basically through your art. So your art, the artwork itself is not illegal. What you did that inspired the art is illegal. And the art is evidence of the act. It's not proof, it's evidence. It's not proof, it's evidence. So what would be the difference between proof and evidence? Evidence, you have this painting, I painted it, it matches the person who's on the floor, something happened to that person. So it's evidence that I did it, but it's not proof because somebody else could have done it. That person could have done that to themselves. They could have fallen over and hit their head and that was a true accident. And then I just painted it and I did nothing wrong. I was under no duty to help that person. So in that case, it's evidence. It helps to paint a picture about what I might have done, but it's not proof. Proof would be more like you have a videotape of me doing it. There's no doubt. It's proven. It's over. It's a wrap. We all get that I did this thing. Evidence would be, well, look, this coincides with that, but there's more that we need to know about the situation to prove it. Miss Lily says, I'm not going to repeat it, but y'all can all read it. Listen, honestly, I don't have an opinion. I don't have an opinion about that. Why don't they use movies? I'll tell you why they don't use movies, Papa Bear, because there are too many hands in the pot with a movie script. There are too many hands and too many variables with a movie script. When you think about a movie getting made like a true Hollywood movie, it's nothing like a song. A song, you could literally go into you could do something this morning and go and make a song about it this afternoon. And tonight that song could be out and being played on the radio or online or wherever, or in the strip club or whatever. You could do something this morning, make a song this afternoon about it, and then it could be released to the world tonight. There's a several hour turnaround for a song. It could take longer, but it could take that short amount of time. So the number of people who have their hands in getting a song from the lyric stage to the stage where we hear it could be one person. It could literally be the same artist who makes the beat, who makes the lyric, who writes the lyrics, who raps the lyrics, who mixes and masters the song, and then who releases it. That in theory could happen. And it has happened. That is not even potentially theoretically possible with a movie. So to reflect the artist's actual real life experiences in a rap song is incredibly easy because you don't have to have anybody else involved. You can write the lyrics and talk about the lyrics. You don't have to include anybody else in that artistic expression. When it comes to a movie, you need a cast, you need a crew, you need a director, you need finance people. So what crime is the movie representing? Who committed the crime? Who was the person who self-snitched in the movie? Was it the director who self-snitched? Well, they didn't write the script. Was it the script writer who self-snitched? Well, the script was altered during the shooting process. Was it the actor who self-snitched? Well, the actor was only reading the lines that the script writer wrote, but that the director and other actors modified significantly as the movie was being produced. Was it the producer who self-snitched? Well, the producer didn't write the lines, didn't read the lines, didn't direct the movie. So the point is, with a movie, there's way too many people involved for you to pin it on one person. Now, I imagine it could, in theory, be pinned on one person, but it would be much more difficult as opposed to a song where you're saying, yeah, I wrote the lyrics and I sang the song. You're just looking at the person who's totally responsible for the artistic expression. With a movie, he wrote the script along with her. Then as the movie was being produced, they modified the script. Then as the scripts were being read, this actor said, no, we're going to change this. That actor said, no, we're going to change that. That actor messed up on his lines, but they kept it. The producer came in and said, we need a complete rewrite of this section because I don't like it. So who expressed themselves? Whose expression is it? It's everybody's expression at that point. Whereas with a rap song, it's that guy. That guy wrote it and he rapped it. So we have one person that we can say this person, this is this person's. Does that make sense? So I just think with a movie, there's way too many factors to easily pin it on somebody. You can pin it on somebody, but it wouldn't be as easy. But most of the time, rappers have ghostwriters. So Kia, that's a good point. But what rapper is going to come to trial? And first of all, you would have to testify to that, or you would have to, if you don't testify, you would have to, in your defense, reveal that. So basically, you'd be killing your career. And you also have the ghostwriter who would be cross-examined. So Kia, think about this. You have a ghostwriter. Your ghostwriter wrote something for you to say that lines up in some way with reality. Now you're going to put your ghostwriter on the stand and you're going to examine your ghostwriter through your lawyer to bring out, no. The rapper didn't write this. The ghostwriter wrote it. Okay, first of all, you're telling the world you have a ghostwriter. Okay, that's one. So your career's over. One. Two, that's if you beat the charges, your career's done. Two, the prosecution is now going to get to cross-examine your ghostwriter and try to, hey, well, how did you hear about the thing that happened? You know, so now your ghostwriter is going to, if they're telling the truth, they're going to have to deal with the prosecution who's going to try to corral them and steer them in a direction where it sounds like you told them to write something like that. That's going to be the prosecution's motive. Even if this is not what actually happened in the real world, the prosecution is going to try to paint the picture for the jury that, yes, the ghostwriter may have written it, but you told them certain facts or you alluded to certain things for them to write this. So it still would come back to you as the artist. if you're the one on trial. So my point is, it's not impossible that you would be able to get a ghostwriter in. Of course, you could call your ghostwriter, but again, you kill your career. One, it's over, and two, the prosecution still has that ability and that opportunity to cross-examine your witness, the ghostwriter, and attempt, and that might kill the ghostwriter's career as well, by the way. But they would still have that ability to attempt to paint you as the person who told the ghostwriter what to say. Okay. Some script different, hood and cast. Breezy R, are you saying like some? Hold up, I got an airplane going on. So y'all, I'm just talking about movies that we typically think about. It would be tough to say who wrote the self-snitching or the snitching. And I'm only using the word snitching as a popular word, y'all. I don't use that word, okay? So y'all never gonna hear me say somebody snitched. I'm just using that because that's what was said in the popular discourse. But I don't care about snitching. I don't talk about snitching. It's not my thing. But with that said, it would be tough to determine in a movie script who did the snitching. I guess you could go back to the original script. You could see, was this originally written? But then you wouldn't be looking at pinning it on the actor. You'd be pinning it on the script writer, unless the actor directed the script writer to write these things. It would just be more difficult rather than just a song. Okay, so y'all see why with a song, it's easier to pin it back to the artist. And the artist has a vested interest in not pinning it on the ghostwriter publicly, because ghostwriter is a ghost. The ghostwriter is a ghost. Y'all, should we be getting concerned? We've been on this break for an hour and hold up. How long have we been on this break? Yo, have we been on this break for over an hour now? Yeah, we've been on this break for an hour and 20 minutes. Y'all give me a thumbs up for talking for an hour and 20 minutes and we're growing the audience. We're at 632 people. Hit the like button, please, if y'all haven't subscribed. I'm feeling good. I've been able to talk for an hour and change. Let's see what Rob Tyler says. States are watching this case looking at the usage of musical lyrics that might be associated with criminal acts. Y'all, I'm going to say this. Sometimes people, y'all are with me and I'm feeling this because I feel like y'all are vibing with what I'm saying. I'm not saying, one, that I think anybody's guilty of anything. First of all, that's number one. I am not saying I think anybody did anything. Number two, using your lyrics against you just makes sense. People say you shouldn't be able to do it, and I'm gonna be 100% honest. When I first heard of it, it struck me the wrong way. It wasn't. I don't believe it was in this case, but it's kind of a recent development, and I was like, that doesn't sound right. But the more you think about it, the more you say, but why not? Like, why couldn't you use somebody's lyrics if they line up with reality? And if you are using them in a good faith way. What do I mean by that? What I mean by good faith is if you're not purposefully misinterpreting the lyrics, if you're doing your due diligence to try to make sure that your interpretation of the lyrics is correct, if you're not just throwing stuff out there out of context, if you have a crime that happened on West 32nd Street, in December 2022, and somebody says slid on West 32nd 22, I do. Yeah, I'm gonna use it. I'm using it. Slid on West 32 22. You know how I do? Oh yeah. Yep. Cut, copy, paste. Boop. That's going in the trial, if at all possible. You would be crazy not to if you're a prosecutor. Now, if somebody can say no, I'm going to give you like you in a conference with the other lawyer, they say, no, we want to show you, and they can show you something convincing, like, no, this is actually about that. And you can see it and and it's clear. And then you decide to still go forward with it. Then you're operating in bad faith. And I call that misconduct. So my point is, okay, whew, we made it, y'all. We coming back. We coming back. What's going on? Okay. No sound yet, y'all. Oh.
All right. So for this morning's representation of I'm on. Mr. Nichols, we have Ms. Foster and Ms. Anderson. Thank you. All right. And somebody said there was something they wanted to put on the record before we started.
Yes, Your Honor. So in one of, and it's not being published today, but I had very fruitful conversations with Mr. Atkins and Mr. Abate. There is, in one of my clients' phone calls, there is a comment where he says, I just went to court and they let everything out. F him, and in the context, it's D, Woody, and the other D. In that context, he just came back from a prelim. So to someone that's not a lawyer that practices in Fulton County, you would get the impression that Woody and D and the other D let everything out in court, when I think it's pretty clear he's referring to the detectives the detective that testified at the prelim.
Okay.
So we're going to work on a stipulation that lets the jury know that a detective testified at a prelim on that date to add context to that statement, if it makes sense. Because otherwise, I would have a 403 misleading objection.
Okay. All right. Anything else before we get the jury in? All right. Let's get the jury in, and y'all can go ahead and be having your next witness make their way in.
And Mr. Tyler, Mr. Rob, I think that if it's used inappropriately, it should backfire. You know? I think if it's used inappropriately, it should backfire.
That's the one.
Yep.
Y'all, is this the one? Is this the lady that
Yeah.
QZ was trying to get at? Is this her? Oh, y'all can't see my mouse. This one over here with the green. I think that's the one QZ was trying to get at. I really thought it was pronounced. Is it Abate?
All right, thank you very much. Everybody can be seated, and I see we have Mr. Sprinkle back on the stand. Mr. Sprinkle, I'll just remind you that you are still under oath. Go ahead, Mr. Abadi.
Thank you, Judge.
Abadi.
Good morning. Good morning, Mr. Sprinkle.
Good morning. How are you?
Good, thank you. Can you tell the jurors, I know you have previously testified, and I know you spoke briefly about the fact that you had reviewed
Excuse me, Mr. Abadi. I'm
Sorry.
sorry. Could you use the mic?
Yes.
Y'all, this
Thank you.
guy's
And if
terrible
you
at
want to move
microphone
around,
use.
that's fine. There's a lapel mic somewhere if you'd prefer to
Like,
use that,
Mr.
or they
Abadi
can
can't
hold
use a
one of those
microphone.
mics.
Come on,
I
Abadi.
hate the sound of my own voice. The lapel mic really bothers me.
Okay.
So, Mr. Sprinkle, so you talked a little bit about the fact last time that you had, I guess, reviewed and gone through some jail calls as it related to the case involving the murder of Donovan Thomas. Do you remember that?
I do.
Okay, so I want to kind of start there and follow up a little bit about how you do that and what system you use.
Okay.
So could you tell me a little bit about the system that you utilize or are able to use in order to preview or listen to jail calls?
Well, in this case, the system would have been Securus. Securus is a private corporation based out of Dallas, Texas. At the time, at the time that's relevant here, they maintained the phones and the tablets that were issued to inmates, with which the inmates were able to place phone calls. And now it's another company, but that's not relevant for our purposes. At the time, the short answer to your question is it was Securus was the system.
Okay, and were you trained in using the secure system, and is it something that you use regularly as a part of your job roles and responsibilities?
Yes.
And can you tell the jurors when a call is made from the jail, is that call or is every call that's not to a privileged or is not a privileged conversation recorded?
Yes, it's an automated system, or it was, and well, it still is, but it's computers essentially automatically record the phone calls. They're voice over IP phone calls. So barring some sort of malfunction in the system, which I've not seen with the secure call platform, all calls are automatically recorded. There's no human input needed to ensure the call is recorded. It's a
Okay.
computer program.
And can you tell the jurors when a call, I guess when an inmate at the Fulton County Jail is making a phone call, can you tell the jurors a little bit about the recording that plays before the call is connected?
Well, over time, the recording has changed a little bit, but one thing that is consistent is that the recording, it's an automated recording, and both parties to the conversation are advised that the conversation is may be monitored, and it will definitely be recorded.
And can you tell the jurors, are, I guess, each call, I guess, made by an inmate, are they stored then after the call is completed?
They're digital recordings. They're stored on a server.
And is that by the company that you've referred to as Securus, at least back in 2015 and 17 and 18?
Yeah, it's a server that Securus either owns or leases. It's some sort of server that was for Securus's use.
And based on your training, knowledge, and experience with Securus, are those calls then stored in the regular course of business?
They are.
And can you tell the jurors how members of the district attorney's office or law enforcement have access to the recorded jail calls by different inmates?
It's a website, commandcenter.securustech.net to be exact. And I have a login and password. It's a derivative of my first name and my first initial and last name. And on logging in, there's a array of things from which I can choose, and one of them is just a search form where I input various values like phone number, date range, inmate name, inmate account number, etc. And based on those values that I enter into the search form, I can look for the jail calls that look for certain jail calls that meet those criteria.
Okay, and the login that you just described, is that unique to just you as the user?
Yes.
And when you are, in order to log in with your login, you have to, I guess, use a password.
I do.
And once you are able to log into the secure system, can you tell the jurors, I know you referenced searching for calls, and we'll get to there in a second, but if there's a call that you listen to and is of interest to you, are you able to then download that call?
Yes, I may.
And can you tell the jurors how, I guess, you are able to download calls that you intercept or that you listen to that are of interest to whatever you're working or investigating?
There's a variety of ways, but as I testified previously, they're just digital calls. They're either in MP3 format or WAV format, and I just ask the web-based software or the web-based platform to essentially compile the calls that I've selected for me, and I select a button to download them. And generally, there's multiple ways to do it, but the most common that I utilized with Securus was I would designate the calls I desire to download, essentially hit download, and then I'd get an email and that with a link that I would then download the calls and in what was an ISO format, which is essentially a zip file. And that would be how I would preserve the calls and place them in the case file.
And can you tell the jurors with the ISO format that you just described, can that format be altered or I guess changed in any way by you?
Well, no, not the ISO that I download from Securus. I'm not sure. There probably would be a way that somebody, if they wanted to be nefarious, would be able to unpack the contents of the ISO and then repack them. But I mean, I didn't do that in this case.
Okay. And can you explain a little bit to the jurors how an inmate who is in the Fulton County Jail is able to utilize the secure system and make jail phone calls?
They enter in their account number followed by a PIN, and then they put the phone number. And I'm not sure if it's in this exact order, but they, in order to place the call, they enter in their account number, then a PIN, unless they're in the booking area or the lobby area. And that's essentially it. They enter in some a numeric credentials.
Okay. And you talked a little bit about searching for calls. Can you explain to the jurors the different ways in which you search for calls that you're looking that it could be relevant to your investigation?
Sure. I search either by phone numbers, if there's phone numbers that I desire to find calls on, and oftentimes I'll do that if I think that there's multiple people that are calling a certain number. I think that there's a certain phone number that the certain inmate may be utilizing another person's credentials to call. Then I'll search by phone number only. I can also search by the inmate's account. So all calls placed from the inmate's account. And those are the two primary ways. There's also ways that you can search on all calls from a certain area of the jail. Like if I wanted to pull all calls from the booking area during a certain date and time, I could do that as well. But for the most part, on doing searches, and I guess I'll speak in the past tense since Securus is no longer the system that is utilized by the Fulton County Jail, I would just run phone searches by either the inmate's account or phone number.
Okay. If you'll do us a favor, I think Madam Court Reporter's fingers are going to break. So could you just slow down just a little bit when you're talking?
Yes.
Okay. Now, can you tell, I know you explained to the jurors when you testified previously about a number that you located after you reviewed call detail records. It was a number that you found in common with all those records. Do you remember talking about that?
I did.
Okay. And do you remember telling the jurors that the number through your investigation and through, I'm just trying to
I'm
set.
going to give him a little leeway on that.
Do you remember that you testified that through your investigation and after receiving the call detail records, that phone number belonged to Mr. Bradford?
I do.
Okay. And can you tell the jurors how you utilized that phone number that you found in common as it relates to the jail calls and the jail phone call system?
Well, so as I started to review the case, I found that the phone number 404-957-8008 could be found as a contacted number or a number that was contacted. It appeared in the phone logs of the records for Darius Zachary, Demise McMullen, Kenneth Copeland, and Kelvin Treadwell during the relevant time frame that I was looking at. And so on seeing that, common sense dictates this is whoever has this number, somebody that those four people know, or those handsets that contacted that number were nevertheless in the hands of somebody that knew that person. It was a number of interests, basically. So I ran 404-957-8008 through the Fulton County Jail call system to find any calls that were placed by anyone at the Fulton County Jail, anybody who was incarcerated at the
And
Fulton
when you
County.
did that, did you locate any calls that were relevant or of interest to your work on this case involving the death of Mr. Thomas?
Yes.
And can you tell the jurors the pin that you located as it relates to these calls? Who was the inmate in which the pin was assigned to?
Are you asking me which inmate placed the calls?
Yes, which pin number? Yes, which inmate who is, I guess, attached to the pin placed the calls?
It was Martinez Arnold.
And can you tell the jurors how many calls did you download any calls as it relates to inmate Martinez Arnold's pin number?
Yes.
And how many?
I don't recall how many.
Okay. And can you tell the jurors, were there any, I guess, how many specific calls did you listen to and that you determined were relevant as it relates to your investigation?
There to 404-957-8008.
Yes.
Well, there were two that were particularly relevant, two that were particularly relevant, and then there was a third that was also relevant, but there were two that particularly piqued my interest.
Okay. And can you tell the jurors the two calls that you located that were relevant to what you were investigating, what dates were those calls placed?
January 10th, 2015.
And what times or what time were both of those calls placed?
They're within an hour following the homicide.
Okay. And after finding those calls and listening to those calls, did you download them as you described earlier here before the jury?
I did.
Okay. And can you tell the jurors, as you continue to investigate this case, did you search, I guess, for any other calls related to Mr. Shannon Jackson or Shannon Stillwell?
I did.
And can you tell the jurors, were you able to locate calls in which Mr. Jackson's PIN number was being used to place calls?
Yes.
And can you tell the jurors how many calls, if you can recall, did you listen to and download as it relates to your investigation?
Well, as far as the number of calls I downloaded, it was over 700. As far as the number of calls I listened to, that I don't recall. I don't remember.
And can you tell the jurors when you download a large number of calls, like you just described, 700, explain to the jurors how you kind of narrow your search as it relates to such a large number of phone calls?
Well, there's a number of things that I do. For one thing that I do is I try to anticipate when someone may say something that would be relevant to me. If it's the call was placed at around the time of an event that would yield a relevant topic, such as, for example, calls made right after the arrest in the booking area, calls made right after a hearing where the case was discussed necessarily, that I would anticipate that perhaps the inmate would just like to discuss what happened that day with whomever they called. I also look for calls to numbers that aren't contacted very often, thinking that perhaps that indicates there's been some sort of that this is, if it's somebody that's not called very often, then the discussion may not be as mundane as it would be with someone that they speak to 5 times a day. And that's pretty much it.
And you, when you talk about hearings or things of that nature, is a prelim, for example, a type of hearing that you would use as a date for potential calls of interest?
Yes.
Okay. And is that something that you utilized in this case as it relates to phone calls that Mr. Jackson made?
I did.
And can you tell the jurors very briefly, at a prelim, is that a type of hearing in which the detective, typically the lead detective, is the only person who testifies about the facts and circumstances of the case during that hearing?
Generally, yes. It's hearsay is permitted, so generally that's the only witness that would testify at a
And
preliminary hearing, rather.
in your experience, as it relates to phone calls that you pull after the date of a prelim, is it common for you to find calls in which the inmate is describing what happened during the prelim and the facts and circumstances that the detective may have testified about?
Yes, it's very.
And is that something that occurred here, in this case, as it relates to Mr. Jackson after you pulled calls on November 19th of 2015?
Yes.
Okay. Now, specifically, did you also pull calls that relates to Mr. Kendrick?
I did.
And can you tell the jurors, did you utilize the same procedures you kind of just described to the jury when talking about the calls that you pulled and reviewed for Mr. Jackson?
I did.
And I want to show you State's Exhibit. This 590Y. Yes. Mr. Sprinkle, I apologize. Your Honor, may I approach the witness?
You may.
And Mr. Sprinkle, do you recognize State Exhibit 590Y?
I do.
And can you tell the jurors how you recognize 590Y?
Was my handwriting on the disc. I created yesterday. It's a selection of jail calls that I downloaded and listened to, and I put them on this disc so that they would be in tangible form for purposes of creating an exhibit.
Okay, and can you tell the jurors the jail calls that you've described that are on that disc, are those the jail calls that you have talked about today as it relates to Mr. Arnold, Mr. Jackson, and Mr. Kendrick?
Yes,
And you said you created the disc?
I did.
And can you tell the jurors, are the calls a fair and accurate depiction of the phone calls you listened to that you've described before this jury here today?
Yes.
At this time, Your Honor, the state would tender what's been marked as State's Exhibit 590Y into evidence.
Your Honor, just reasserting the prior objections that were made, I guess, a week or
Understood.
two ago. Thank you.
Those are admitted. Any objections are preserved.
And Your Honor, permission to publish,
You may.
just for the court's edification, counsel, and the jury. I'm not going to play all of the calls today, just a very small selection.
Okay.
And while Mr. Atkins is pulling that up, for the record, for counsel, the court, and for the jury, this is a call that took place on November 19th, 2015, as it relates to Mr. Shannon Jackson.
You may start the conversation now.
Hello.
Hello. When I was crying, the tears was on the screen. They kept pressing phone, so I hung up by itself. I asked the phone, but they kept pressing phone. Yeah, I'm gonna just wrote me said D said what's your number.
Fuck D, bro. Fuck them nigga, bro. Oh, just like that, bro. Fuck you. Straight up, huh? All that fake friend shit. So fuck these folks. Wish I get on tour. Fuck all that pussy ass nigga. I wish I get on tour. All these fuck niggas. Fuck all y'all rat ass niggas, man. Fuck that nigga, man.
I ain't able to D on the phone. He said, what happened to the SB in court because they just need more from charge. They didn't even take on the court.
That fuck nigga, you know what's going on. Pussy ass nigga.
Say it like that.
You fuck.
Okay.
Fuck you.
Okay. I said, fuck D. He, when he talked to the train.
What you all niggas got, bro?
I just said, she just read it. She look like she on it.
You text no with your number?
Huh?
I don't got your number.
Y'all been having enough when you said, what you say? Some old shit now. Wait, what happened to baby?
That fuck nigga rat. They just went till I went to court and they just let everything got to that fuck nigga rat. Him and Wu, they know what it is. I don't keep going with the folks. That fuck nigga know what's going on. Bitch, you in love with a rat hoe. Everything that came out. The shit they bring up, bro, that shit was just weak as fuck, bro. I'm talking like eating their ass up.
Man, do not leave her in here. This is not the time right now. Everybody get out. Everybody get out. Mom, can you get out too? Shut though. I don't know, call the phone. Young said, see, that's why I don't pick up my damn phone. People keep telling me that tell shut and keep your head up. He a real one for real.
That's all you hear. Oh, you're real. Man, that shit don't do nothing for a nigga. That shit don't make a nigga feel good. That shit don't do nothing for a nigga.
I really get out this house.
Oh, yeah. Talking about a do what name, nut name, yet name. So-called yet, yeah.
Yeah, get that shit on me, son.
Yeah. Okay, yeah, nut, do what. Oh, man. My head hurt, man.
I'm going to stop it there for the record. There's 41 seconds left in the call from November 19th, 2015. Mr. Sprinkle, are there 9 calls as it relates to Mr. Jackson on States Exhibit 590Y?
Yeah, 9, that sounds about right.
And as it relates to Mr. Arnold, are there 4 calls that were pulled that you downloaded on States Exhibit 590Y?
That sounds right, yeah.
And then as it relates to Mr. Kendrick, as we spoke earlier, are there 3 calls on 590Y as it relates to him?
Yeah, I think so. I think that all those numbers sound correct.
And when you, I guess, are listening to the phone calls from your computer, is the sound system a little better than what we have here in the great courtroom here in Fulton County?
Yes. So sometimes with jail calls, they've split the inmate side of the call. I don't know if that's what was happening here, but generally that's what happens. They split the inmate side of the call in one, like the right channel or the left channel, whichever one, and then the call party side and the other channel, so they're in stereo. And for whatever reason, the inmate channel is sometimes a lot lower than the called party channel. It sounds like that may have been what was happening just then, because I too was having difficulty hearing him.
And for the court, for counsel, and for the jury, the state's going to play the rest of the calls at a different time when we can utilize a better sound system that I'll bring
Okay,
in.
yeah, because
We were all struggling, I
I'm
think.
not sure anybody heard anything.
Now, Mr. Sprigg, I just want to ask you a couple questions about that call. As it relates to your investigation, was someone with the nickname Little Woody someone you investigated and was a part of this case?
Yes.
And did you hear his name during that call?
Yes.
And did you also hear Mr. Jackson reference doo-wop, nard, and yak?
I did. I heard that part, yeah.
And were those individuals that you also, through your investigation, I guess, were familiar with?
Yes.
Okay. Now, can you tell the jurors the nickname Little Woody, who do you know that nickname to belong to?
Kenneth Copeland.
Okay. And when you received the case file from the Atlanta Police Department, were there a number of recorded statements or interviews inside of the file?
There was.
And when you received it, and as you continued to work on the case, did you review those statements?
I did.
And did you receive a statement as it relates to Kenneth Copeland from June 10th of 2015?
I did.
And can you tell the jurors, did you review it in its full?
I did.
Okay. Now, during that statement, does Mr. Copeland provide his phone number as well as the phone number for his girlfriend?
I believe so, yes.
And can you tell the jurors what is Mr. Copeland's girlfriend's name?
Deshaun Quarterman.
Okay. And after receiving through the interview as well as and other means through your investigation did you request the phone records and receive them for Kenneth Copeland?
Well, by request, I didn't order his phone records. Someone with the Atlanta Police Department did, but I did review them.
Okay, and is it something that you reviewed as a part of this case?
Yes.
And this was previously admitted into evidence at State's Exhibit 533YA. See that? You see that, Mr. Stokes? All right.
Yes.
Now, can you tell the jury what was the phone number in the records that were related to the handset that was associated with Kenneth Copeland?
What was Kenneth Copeland's phone number?
Correct.
678-278-5991.
Okay. And after listening to the June 10th of 2015 statement with Mr. Copeland.
Hang on just a second. I know that stand isn't great, but I think the jurors in the back row are having a hard time seeing that.
And Mr. Sprinkle, while Mr. Atkins is putting up the board, can you tell the jurors, did you review Mr. Copeland's phone records in light of the statement from June 10th of 2015 that you listened to?
Yes.
And can you tell the jurors, when did, I guess, activity on Mr. Copeland's phone or through his phone records, when did it begin in the early evening of June 10th of 2015?
Well, I guess it would depend on what you define as early evening. For me, I started inspecting the records as at 6:20 p.m. Eastern Standard Time.
Okay, and can you tell the jurors, was that an incoming or outgoing call?
His girlfriend, Deshaun Quarterman, called him at 6:20.
Okay, and did Mr. Copeland?
Simply, who called? I understand the handsets.
Sustained.
Okay, did the handset of Mr. Copeland's girlfriend call the handset related or associated with Mr. Copeland?
Yes.
And did Mr. Copeland's telephone, the number that was associated with him, did he answer?
He did not at 6:20 p.m.
Okay. Can you tell the jurors when was the next, I guess, incoming or outgoing call that Mr. Copeland made and was connected or answered?
Well, his brother called him at 6:27 p.m.
Did the handset related to Mr. Copeland's brother call the handset related to Kenneth Copeland?
Yes.
Okay. And did Mr. Copeland's handset or telephone that's associated with him, did he pick up?
Well, it appears that he did. It was a 24-second conversation.
Okay. And do you recall during the interview that Mr. Copeland did on June 10th of 2015, what he described as it related to his activity in the early evening?
He said that he was at his house at 178 Maury Avenue. He'd been taking a midday nap at the time.
Okay. And did he indicate during that interview that when he, I guess, woke up, he called the handset that was associated with his girlfriend, Miss Quarterman?
He did.
And is that consistent with what the cell phone records, the call logs for the handset, Mr. Copeland, that you reviewed?
Your Honor,
Yes.
I'm going to object at this point. I believe this is cumulative to the information elicited from Mr. Bernie by Mr. Atkins last week. The cell records, the calls, the timing of the calls.
So my response would be Mr. Bernie, or Agent Bernie, as he testified, he didn't review any sort of statements, so he was not in a position to talk about the consistency of the statement as it relates to the records, which was the necessity. The whole reason we needed to call Mr. Sprinkle back was due to that unfortunate scheduling issue.
All right, I'm going to,
And Your Honor, I believe those would be juror issues. I don't believe it's Mr. Sprinkle's place to determine what is consistent and what's not.
Well, I'd also say this goes to Mr. Copeland was impeached on multiple occasions by multiple parties before this court and this jury, and this is a prior consistent statements and activity as it relates to his impeachment.
I'm going to overrule the objection.
You can answer the question. Let me ask it again.
Yes.
What Mr. Copeland, I guess, described during his interview as it relates to waking up and his phone activity to the detectives on June 10th of 2015, is that consistent with the activity that you reviewed and you've described here today as it relates to the handset of Mr. Copeland and his call log detail records?
We called the handset associated with Deshaun Quarterman at 6:58 p.m. So that was consistent with him talking about what he did after his midday nap.
Okay. And can you tell the jurors, did you also, as a part of your investigation, plot different calls as it related to the call detail records that you received with Mr. Copeland?
I did.
Okay. If you also had an opportunity to review similar, I guess, plotting of Special Agent Bernie?
I did.
Okay. Now, during the interview that day on June 10th of 2015, do you recall where Mr. Copeland described, I guess, he went next as it relates to his activities that night?
He went to the Green Store, which
Okay.
is, I believe, at 322 Glen Street. That's what he said, yeah.
And in your review of Mr. Copeland's records, can you tell the jurors, were his records consistent with him going to the Green Store shortly after he called the handset related to or associated with Ms. Quarterman?
Your Honor, I think that this is out of Mr. Sprinkle's expertise, and these are questions for Agent Bernie, which have been asked.
Okay, so if that may be true, if I'm understanding what it is that Mr. Sprinkle's testifying to.
I can lay a foundation.
Okay.
Mr. Sprinkle, do you utilize or do you review call detail records on a regular basis as a part of your job responsibilities and duties with the District Attorney's Office?
Yes.
And can you tell the jurors how often do you do that?
Multiple times a week. I don't want to go so far as to say every day. I'm sure there's days that I haven't, but it's thousands upon thousands of times, thousands of sets of phone record, at least over 1,500 sets of phone records, and that's a conservative estimate. So yeah, I look at phone records all the time and have been doing so since 2012.
Cell site location data related to the different phone calls within the call detail records?
Yes, depending on the type of phone logs, call detail records that I have or that they are, yes, they will sometimes have cell site location information.
And can you tell the jurors, as a part of your job responsibilities and duties with the District Attorney's Office, how often do you map or plot different calls as it relates to the cell site location data contained within the call detail records?
All the time. On
Another objection on foundation for this part of the testimony as it relates to mapping. Foundation for establishment.
As it relates to what, I really need y'all to use the mics. All right, so,
I'm laying the foundation.
okay, he's in the midst of it.
So how often do you plot and map different call detail records, cell site location data?
very, very often. Maybe not on every single case, but on many, many, many cases. How often? I would say at least once a week. Again, that's a very, very conservative estimate, but most cases have cell phone records, and I will generally, if there are cell phone records, want to look at those to make sure that the data is what we believe it to be.
Okay, and can you tell the jurors a little bit about your experience in the sense of how many years have you been utilizing cell site location information to map or plot different sets of phone records and specific phone calls within different sets of records?
Since 2012.
Okay, so roughly how many years? We're looking at what, over 10?
Yes.
And within those 10 years, can you tell the jurors how many sets of phone records do you believe that you have mapped or plotted cell site location information related to call detail records?
That would be hundreds. I don't keep a tally, but the number of cases that I deal with a year since that time, it would just be in the hundreds. A lot of cases.
Okay, and in the cases that you have done what you just described, do you often work in tandem or in conjunction with different members of law enforcement, such as the Atlanta Police Department or other agencies within Fulton County?
Yes.
Okay, and have there been times that you also have worked with members of the FBI or different task forces as it relates to mapping and plotting call detail records?
Maybe like consulted with. Work would imply that I was like part of the team, or with respect to the FBI, that is. No, I mean, I've consulted with them.
Okay, so as it relates to this case, did you utilize cell site location information to map different calls for Kenneth Copeland after you listened to his recorded statement on June 10th of 2015?
I did.
And can you tell the jurors, as it relates to the mapping or the plotting that you did for Mr. Copeland's records, were they consistent at times with being near the Green store?
Yes.
Again, Your Honor, I'm going to object. Cumulative, Agent Burney has already testified to these matters.
My response is these questions will be brief, but again, Mr. Sprinkle's analysis is related to the statement that Mr. Copeland was impeached with during his testimony for the statement he gave on June 10th of 2015.
All right, and can you clarify whether whatever this analysis is based on Mr. Sprinkle's own plotting or whatever Mr. Burney had already done?
Yes, the plotting that I've been talking to you about as it relates to Mr. Copeland is this plotting or mapping that you did yourself.
Yes.
And upon doing the plotting or mapping yourself with the cell site location information, well, let's start with, can you tell the jurors what information, I guess, are you inputting or using in order to get specific plots for specific calls?
So basically what I do is I'll have the phone records. So I'll have a set of phone records, and there will be some cell site location information that's in the same row as the date and time and the phone number's called. And I'll use Google Earth. Sometimes some phone records are real easy. If they're from AT&T or T-Mobile, they'll just have the latitude and longitude of the tower actually in the records. Other phone companies like Sprint at the time or Verizon, they just put some sort of number that's unique to them. Like it's a number that identifies the tower for them. It will be like 14732 or something. That's by no means a lot. That was just a number I just came up with out of nowhere, but it'll be some sort of number, and I'll have to cross-reference another spreadsheet where that spreadsheet will have the latitude and longitude. But long story short, though, I just take the latitude and longitude of the tower, I put it into Google Earth, and then I use a graphic plugin in Google Earth to create I get what I call a pie slice that represents the approximate area of coverage, or basically just points in the direction of the antenna or the azimuth of the tower.
Okay, so that was a long story.
Wow.
So can you tell the jurors, in your review of the phone records, what time, if any, was Mr. Copeland's handset in the area of the green store?
So his handset was consistent with was utilizing a tower that was consistent with it being in the area of the green store between 7:26 and 7:27 p.m.
Okay, and can you tell the jurors, through your review of Mr. Copeland's June 10th statement, did, I guess, the location, the McDonald's off of Cleveland Avenue, become a point of interest that was related to the investigation you were doing?
Yes.
And can you tell the jurors, in your review of did you review Mr. Copeland's call detail records and the cell site location information in regards to that interest point?
I did.
And can you tell the jurors, in your review, what time, if any, Mr. Copeland was in the area of, or consistent with being in the area of, the McDonald's off of Cleveland Avenue?
All right, so like I testified previously, his phone gets to the area or uses a tower in the area of the green store from 7:26, 7:27 p.m. It remained in that general area or the tower until about 7:47. And then 7:49, it pinged off the tower that serviced the general area of the McDonald's at Old Hayville and Cleveland Avenue.
And you said 7:49?
That's correct.
As you continue to review the records, can you tell the jurors, after continuing to listen to Mr. Copeland's June 10th statement, did the Sky House located in Midtown become a point of interest relevant to the investigation that you were doing?
The Sky House condominiums at 1080 West Peachtree Street, yes.
Okay, and can you tell the jurors why or how did that location become a point of interest relevant to your investigation?
It was the location, or a location, that Jeffrey Williams resided.
Okay. And in the time that you were reviewing the records related to Mr. Copeland and reviewing the statement, can you tell the jurors at any point did Mr. Copeland reference during his statement that he communicated with a handset that would be associated with Mr. Garlington?
He did.
And can you tell the jurors, was that something that you attempted to locate within the call detail records of Mr. Copeland as you reviewed them?
I did. I didn't find a number that I could conclude was Mr. Garlington's, though if I remember correctly, I also said he contacted him via FaceTime, so I wouldn't be able to see those calls and call detail records anyway.
Okay, and that's something you talked about and mentioned as to why previously when you testified before this court and jury, right?
I don't recall if I said that or not.
Okay. Now, can you tell the jurors, I guess, what you were able to determine, if anything, as it related to the call detail records being consistent with Mr. Copeland's handset being in the area of Sky House Midtown?
It was later that evening. His handset, from what I recall, from what I remember, it was after 11 p.m. when his handset utilized a tower that was near the Sky House. So it did utilize a tower at some point that serviced the area of the Sky House.
And can you tell the jurors, the Sky House Midtown, how was that building, I guess, related to or relevant to the investigation that you were doing as you continued to review the statement of Mr. Copeland and other materials that you received from the Atlanta Police Department?
That was the location that was said to be where Mr. Copeland and others converged later that evening on January 10th, 2015.
Okay. Now, I want to talk to you about other statements that you reviewed, do you recall also reviewing the statement for Mr. Quindarius Zachary from August 5th of 2015?
I do.
And can you tell the jurors, did you listen to that statement, I guess, in its entirety or in full?
I did.
And do you recall that during that statement, did Mr. Zachary reference any, I guess, rental vehicles?
He did.
And can you tell the jurors a little bit about what Mr. Zachary said during that statement as it related to a rental vehicle?
From what I remember, that he mentioned there was an Infiniti that was involved, and they believed that the manager for Mr. Williams rented the Infiniti.
Okay. And can you tell the jurors after getting that information from the statement, did you request anything from any rental companies here in the city of Atlanta?
Yes.
Okay. And did you?
Well, let me, it's a small clarification. I requested information from rental companies, and I didn't just specify from their physical locations only in the city of Atlanta. I asked from the rental car companies that they give me records of any rental cars that were rented by a list of people during a time, regardless of where the location was.
Okay. And did you do that in relation to Mr. Jeffrey Williams?
Yes.
And can you tell the jurors, did you receive any information back as it related to any rental vehicles in the name of Mr. Williams?
Your Honor, I'm going to object to asked and answered previously.
I don't know if it has been with this witness, but it's certainly been established.
I can move on.
All right.
Well, I want to show you what's been marked and entered into evidence as State's Exhibit 335Y. When it gets up there, page 7 of 335Y. And as what Mr. Atkins is getting to page 7, can you tell the jurors, do you recognize previously tendered and admitted State's Exhibit 335Y?
Okay, is the 335Y what's being displayed on these television sets behind me?
That's correct.
Yes, I recognize this.
What is State's Exhibit 335Y?
These are records that I received from Hertz Rent-A-Car.
Okay, and are these records, I guess, who are these records, I guess, related to and in reference to?
Jeffrey Williams.
Your Honor, I'm going to object. This is cumulative, and it
Sustained.
has been asked and answered.
Well, my response is the specific information as it relates to what's inside State's Exhibit 335Y was not elicited from any witness as it relates to the trial.
Okay, if there's something new on this exhibit, then.
I'll just cut to the chase. In State's Exhibit 335Y was a phone number that was associated with the rental for Mr. Jeffrey Williams located within.
There was a phone number located somewhere within there, yes.
Okay, and can you tell the jurors what that phone number was?
I don't recall. It's somewhere in the, I think, was it the one that ended in 3504 maybe? It should be in the business record though.
And do you see it on page 7?
Yes, 3904, 504-975, 3904. That's right.
And can you tell the jurors, after, I guess, receiving this document and learning of this number, was a request made or a search warrant done for the records as it relates to Jeffrey Williams?
Yes.
Okay, and did you receive those records back related to the phone number associated with the handset of Mr. Williams?
Yes.
All right. Now I want to ask you a few questions about other sets of records that you reviewed in relation to the information you had received from Mr. Zachary and Mr. Copeland after reviewing their statements, okay?
Okay.
Did you request either through search warrant or subpoena the records for Justin Cobb?
I don't know if it was me that did that, but yeah, we did obtain the records for Justin Cobb.
Okay. And
Actually, no, I believe it was. I recall drafting a search warrant on that, so yes.
okay. As well as did you receive either whether it was by you or another member of law enforcement you were working in conjunction with the records for Mr. McMullins?
That McMullen was somebody with the Atlanta Police Department, but I did receive them.
And did you review them?
I did.
All right. And regardless of who requested them, did you also review the records for Kelvin Treadwell?
Yes.
Okay. Now, I want to talk to you about specifically, did you review those records kind of how you've described today as it relates to January 10th of 2015?
Yes.
Now, I want to talk about some of the activity that you saw as you did the review of the records. Specifically, can you tell the jurors, you talked about you received records from Mr. Bradford based on the phone number being a common number called by Mr. Zachary, Mr. Copeland, and Mr. Treadwell, I believe you said, correct?
Yes.
And can you tell the jurors in reviewing the call detail records, did you review the records as it relates to the point of interest of the Texaco off of Cleveland Avenue?
Yes.
And can you tell the jurors, as you reviewed Mr. Bradford's records in relation to that Texaco, what you determined from your analysis?
What I determined from my analysis of Mr. Bradford's tower logs was that his handset utilized a tower that was in close proximity to that Texaco, and therefore 330 McDaniel Street, the incident location, between the hours of 7:11 p.m. to 7:19 p.m.
And I should have asked you this first, but as you were reviewing statements and call detail records, did you also receive and review any video surveillance?
I did.
And is that the surveillance that I think you briefly described previously as it relates to the Texaco off of Cleveland, as well as the barbershop not far from the Texaco?
Right, the barber shop, like between 60 and 100 yards, yes, away. Yeah, that too.
Okay. And I want to show you state's exhibits 591. 591Y through 598Y. And prior to your testimony, have you had an opportunity to review those photographs?
I did.
And do those photographs contained in State's Exhibits 591Y through 598 fairly and accurately depict the Texaco from July 10th of 2015?
January 10th, 2015?
Yes, I'm sorry.
Yes, they do. These are screenshots. It looks like they're screenshots I took, actually.
Okay. And Your Honor, at this time, the state would tender what's been marked as State's Exhibits 591Y through 598Y.
Admitted.
And while we're at it, Mr. Sprinkle, previously admitted into evidence was 292YL through N. Let's review those. Do you also recognize those as screenshots from what you've described from the Texaco that you actually took?
Yes.
Now, can you describe for the jurors in State's Exhibit 591Y what we're looking at?
This is a screenshot taken from the video from the Texaco. It was a surveillance camera that captured the exterior of the Texaco station. This would be the gas pumps that were closest to 330 McDaniel Street. The timestamp in the lower on the video is 6:41 p.m. and 58 seconds. Literally, it's 18:41:58, but that's 24-hour time, so it's 6:41 p.m. and 58 seconds.
Okay, and is there a vehicle, do you see the vehicle, I guess that's in the center of State's Exhibit 591, Y?
Yes, I do.
And through, I guess, your investigation, can you tell the jurors what you're able to determine what type of vehicle that is? 2001
Pontiac Bonneville, gray in color.
And in conjunction with all the things that we've described that you've reviewed, the statements, the call detail records, the video surveillance, I know you briefly spoke about it, but did you also review different social media accounts and photographs as it relates to some of the individuals, specifically here, Mr. Bradford, that we described previously?
Yes.
And can you tell the jurors in your review of Mr. Bradford's social media and contained in previously admitted exhibits, State's Exhibits 360Y through 363Y, what you found in Mr. Bradford's social media that caught your attention?
He often posed in photos with a 2001 Pontiac Bonneville. I mean, he'd be leaning up against it, et cetera. Looked like it was just a car that he was with frequently.
Okay. And prior to your review of Mr. Bradford's social media account and seeing these photographs with him with standing next to or near a Pontiac, had the Pontiac that's contained in State's Exhibit 591Y I guess been an integral part of your investigation at that point?
Well, not integral, no.
Okay. Was it something that you found or didn't find relevant until you reviewed Mr. Bradford's social media accounts?
Sustained. Can you?
Well, let me ask you this question. Just tell the jurors, after reviewing or finding these photographs of Mr. Bradford and the Pontiac, how you were able to use that to forward your investigation.
Okay, so I had the tower data for Mr. Bradford's phone that placed him in the area of the crime scene from 7:11 p.m. to 7:19 p.m. I had calls from the jail to Mr. Bradford. I also had these pictures from his social media that I found that showed him with a Pontiac Bonneville. Now, Bradford was not known. He was not in any of the documents that I obtained from the Atlanta Police Department. As far as I knew, he was unknown to the investigation entirely. So I was trying to figure out who this Mr. Bradford was. Why I had this data that this information was made it appear that he was somehow would at least know something about what I was looking into. And so when I went back and looked at the video and I saw this 2001 Pontiac Bonneville pull up to the gas pump, that's when it clicked. And I started paying particular attention to the surveillance video from the Texaco station.
Okay. And I want to show you, Mr. Atkins is going to put on the screen a State's Exhibit 598Y. Now, in State's Exhibit 598Y, can you describe to the jurors what they're looking at and the relevance it was to your part of the investigation working on this case?
So 598Y is a picture from Mr. Bradford's Instagram page, and it is one of a few photos that showed him next to a Pontiac Bonneville, like I testified to previously. And that was I obtained that photo around the time that I identified his phone number and got his phone records and tower usage data that placed him in the area. The crime scene, as I testified to previously.
And the photograph that's next to him standing in, next to the Pontiac, can you describe to the jurors where that's from? There's two photos contained within. How are they relevant to each other?
Well, the one on the right is a still shot from the surveillance footage from the night of the murder.
Okay.
From the Texaco station.
And can you tell the jurors in your review of the video surveillance, you said in States Exhibit 591 why that Pontiac arrived to the Texaco at what time?
About 6:41 p.m.
And can you tell the jurors in your review of the surveillance how long in total was that Pontiac seen on the video surveillance?
If I may refer to my reports, I get the numbers.
If it will help refresh your recollection, yes, just look up when you're done.
So it was there. The Pontiac was in view of the surveillance cameras at the Texaco station when it pulled up into the pump at 6:41 p.m. and until it drove away from the station at 7:17 p.m.
So fair to say, reviewing your report helped refresh your recollection as to how long it was there?
Yes.
Okay. And you said it was roughly 40 minutes?
Yeah, about that.
And can you tell the jurors in your review of Mr. Bradford's call detail records, was that consistent with him being, or were they consistent with him being in the area of the Texaco off of Cleveland Avenue for roughly 40 minutes?
Yeah, but his phone traveled to the Texaco off of Cleveland Avenue after it departed the area, or not, excuse me, are you talking about the McDonald's?
No, so you just described to the jurors, let me rephrase my question. So that's you saw the Pontiac remain at the Texaco for roughly 40 minutes. You remember saying that?
Yes,
41 to, I think you believe 7:17?
6:41 to 7:17, correct.
And can you tell the jurors in reviewing Mr. Bradford's call detail records and the activity on his phone during 6:11 and 7:17, were they consistent with him being in the area of the Texaco during that time period?
At the Texaco at Northside Drive and McDaniel Street, yes. His phone pinged in that area from 7:11 to 7:19. It utilized the tower, so it didn't ping at the tower that entire time. But the time frame that his phone did ping at the tower, off the tower and sector that serviced that general area, was encompassed, by the surveillance footage.
Let me ask you this question. Was his phone, or was there activity on his phone during that entire period of time, or were there times where his phone wasn't utilizing a tower?
Well, his phone, it wasn't connected to the tower the entire time, as if it was like streaming data or something like that. Or if it was, I didn't get any records that indicated that. It was only used, it only connected to the tower to when it sending or receiving a phone call.
Okay. And as a part of your investigation, did you also review or look into the social media accounts, or the Twitter account for Mr. Kendrick?
Yes.
And can you tell the jurors in States Exhibit I believe it's 524Y. Was this a photograph that you located from the Twitter account of Mr. Kendrick? But once it gets up there.
Oh, there we go. Yes, it is. There's a, and I don't know that's part of the exhibit because I seem to remember this gray bar going across the screen with the other exhibits as well. Yeah, now it's moved. But yes, I do recognize that. That's an image from Mr. Kendrick's Twitter account.
Okay. And can you tell the jurors, was there anything about the jacket that Mr. Kendrick is wearing in States Exhibit 524Y that you, after seeing this and also reviewing the video surveillance that was helpful to your investigation?
So yeah, the interior surveillance from the Texaco, at 6:41, the Pontiac 2001 Bonneville pulls up to a pump, and the front seat passenger exits the vehicle and walks into the convenience store attached to the Texaco, and in so doing, came in very close proximity to an interior surveillance camera. And so this footage revealed the outfit donned by the front seat passenger. And that image from the Twitter page that you just displayed on the monitor behind me, or the television behind me, that man, Mr. Kendrick from the Twitter page, was donning what appeared to be the same jacket as the man from the video, the surveillance video from the Texaco.
And is that what we're looking at? The comparison that you just described that you did in State's Exhibit 593Y?
That's yes.
And can you tell the jurors, the photograph, we're looking at it on the left-hand side from the convenience store. Can you tell the jurors the time period in which that photograph or that screenshot would have captured?
It was very shortly after the Pontiac Bonneville arrived on scene. If you would like the exact matter of fact, I've just looked at my report to refresh my recollection about this.
Okay.
It was actually at 6:42 p.m.
Okay. And can you tell the jurors in the photograph to the right from Mr. Kendrick's Twitter account what time that photo of Mr. Kendrick was posted and on what date?
It was posted on January 10th, 2015. As you can see there, because I testified about this previously, I moused over the date, and that made the time pop up, and the time is 7:35 p.m.
Now, as you continued to review the video surveillance, can you tell the jurors, did the individuals that you saw, I guess, exit and enter the Pontiac later interact with another sedan?
Yes.
And in State's Exhibit 594Y. And here I thought the screenshots would be less difficult than the freezing video.
Objection, Your Honor. This is cumulative of prior testimony that we've had at least once, if not twice, in this case.
Any response?
I mean, there's been no.
Is this going to be a comparison?
Yes.
Okay, overruled.
Now, can you tell the jurors, were you able to, I guess using your number of years of experience, able to determine the type of vehicle in which we're seeing depicted in front of the Pontiac in the middle of the screen?
The Volkswagen CC VR6 Sport.
Okay. And when you previously testified, you talked about someone you had, I guess, a name that you had come across during your investigation, Miss Ariel Bax.
Yes.
And can you tell the jurors, from getting her name, were you able to use public databases to determine any vehicles registered in her name?
Yes, I was.
And can you tell the jurors what type of vehicle was registered Ms. Bax's name during this time period of January 10th, 2015?
The Volkswagen CC VR6.
Okay. And in your review of the make and model and year that Ms. Bax had, was the vehicle consistent with what we're looking at in State's Exhibit 594Y?
Yes, it is.
Okay. Now, you also talked about previously an individual, Miss Kenya Morton.
Yes.
And can you tell the jurors why you looked into Miss Morton as it relates to this investigation?
I'll object to the reasoning behind what this witness is doing. Otherwise,
Sustained. Can you rephrase?
Yes. In the phone calls that you reviewed and have described today from Mr. Kendrick, did Mr. Kendrick place any calls to Miss Morton?
Yes.
And through your listening of the calls and your investigation, were you able to determine how Mr. Kendrick and Miss Morton were associated or knew each other?
Romantically involved.
It's a review of phone calls that are in evidence.
And also speculation, Your Honor.
Sustained.
It's,
Well, without telling me what the association was, were you able to see several calls between Miss Morton and Mr. Kendrick?
Yes.
Okay. And in fact, in one of the phone calls that you listened to and has been admitted into evidence as it relates to Mr. Arnold, did you hear Miss Morton in one of the phone calls?
Yes.
And can you tell the jurors the date of the phone call in which you heard Miss Morton in the background?
January 10th, 2015.
What time?
7:42 p.m.
Okay. And that time in relation to, how was that time, the 7:42 p.m. that you heard Miss Morton in the background, related to or the time in which Mr. Donovan Thomas was shot and killed?
Well, the 911 call is placed contemporaneously with the shooting, and that 911 call is placed at 7:22 p.m. So that call was 20 minutes after the 911.
Speculation, that's just a foundation.
On the what?
Contemporaneous.
Sustained.
I guess I need clarity. I'm not certain it's the contemporaneous. I know what it
I
means.
don't know if he is able to testify from anything that it was contemporaneous with the murder. I think that's what the objection is to. Is that right? Or he can testify to what time the 911 call was.
I'll rephrase.
Sustained.
Agreed. I'll ask a different question. Mr. Sprinkle, you said the 911 call was at what time?
7:22 p.m.
And the call in which you heard Miss Morton's voice and reference to her name was at one time. What time?
7:42 p.m.
Okay. And during that same phone call, was there reference to Miss Ariel or Ari?
That I don't recall.
Okay. And well, let me ask you this question. Shortly after the Volkswagen in States Exhibit 494Y arrived at the gas station, can you tell the jurors and previously admitted in, I believe they're before you, States Exhibits 292YL through 292N, can you tell the jurors what time another vehicle that you determined to be related to your investigation arrived at that same Texaco?
7:16 p.m.
Okay. And can you tell the jurors, based on the statement of Quindarius Zachary, why that vehicle was of interest as you watched the video surveillance from the Texaco?
Because it was an Infiniti Q50.
Now, can you tell the jurors during what time did that Infiniti arrive?
7:16 p.m.
Okay. And at the time that you reviewed the video surveillance, can you tell the jurors, did members from the Pontiac interact with the vehicle depicted in this state's exhibit?
Yeah. Yes. The man that occupied the front passenger seat and then entered the store at 6:42 p.m. wearing the coat, he interacted with the person or persons occupying the Infiniti.
And I apologize for the record, that's 292YL. Now, Mr. Sprinkle, can you also describe for the jurors, did an individual get out of the rear passenger area of the Pontiac?
Yes.
And can you explain to the jurors I guess, can you explain to the jurors what you observed that person, I guess, do?
Objection, cumulative, best evidence.
Sustained.
Mr. Sprinkle, how long, based on your review of the video surveillance, did the Infinity remain within the Texaco gas pump area?
About a minute, if that. It pulled in at 7:16 and pulled out at 7:17.
Okay, and can you tell the jurors, is that what we're looking at in State's Exhibit 596Y?
Yes.
I'm going to object. Can I maybe approach?
You may.
Well, I'll ask another question.
All right.
You know what? I know what your team was expected for all of them.
Abate tried to get our approach counter to stay at 1, but it's going to 2. But it's going to 2. Let's change the approach counter. Abate thought he thought that he could affect the approach counter and keep it at 1, but it was going to 2 no matter what. Yesterday, by now, we were at like 6 or 7, maybe even 8. All right, approach counter is at 2, y'all. The approach counter is at 2. Welcome, everybody, to the Paralegal Institute of Washington, D.C. live stream. Hit the like, subscribe, and join the chat. Thanks to our mods, Miss Lily 710 and Andre Ramtula, or is it Tuya? Approach counter is at 2. And we have on the stage Abate for the prosecution. And the whole defense team is there, except I think in the back we have a couple of subs in. Everybody join the chat, hit the like, subscribe, and let's get back to the act.
Now, Mr. Sprinkle, let me ask you this question based on your review of all the information you've kind of described here today. As it relates to times for when a 911 call was placed, times as it relates to, I guess, found within call detail records, and then times like the one you just referenced in the video surveillance for the Texaco. Can you tell the jurors, I guess, through your investigation, how you compared, I guess, times from the video surveillance to things like the 911 call and call detail records?
Well, your call detail records, that's the times in those are going to be pretty consistent with, the atomic clock,
Why is that?
Well, they're a cell phone provider and they're computerized records, and they're just going to be synced up because they're on a computer system with an internet time protocol, or which is synced up with the atomic clock. So that's a good gauge as to the exact time of something. Also, the 911 call system. I found in my experience that 911 calls, the timestamps on those are accurate. Surveillance videos can be a little less so. But what I found here was that knowing when the 911 call was placed, comparing all of that with cell phone records and tower logs and all that, when comparing, for example, the 911 call, the surveillance video from the Texaco in particular, you can see the events that are consistent with the shooting on the Texaco footage. People ran inside the store, if I remember correctly. I do remember correctly they did. And from that, you can place a pretty good timestamp or time when the drive-by shooting occurred.
Would it be your testimony today that all of the times are, I guess, synced up exact as it relates to each other? For example, the call detail records and the Texaco video surveillance.
No, I can say that they're linked up exactly. Surveillance videos, it's not uncommon for them to be a minute or two long.
I'm sorry, I didn't hear that last.
Can you speak into the mic?
It's not uncommon for surveillance videos to be a minute or two off. So I can't say that basically the watches of the surveillance video and the cell phone records were synchronized.
Okay. And we talked earlier a little bit about the phone records or the additional phone records that you reviewed. For example, Justin Cobb and Mr. McMullins. Do you remember that?
I do.
And can you tell the jurors upon receiving those records, however which way they were requested, did you utilize, I guess, reviewing those records as it relates to the things that we've described previously here today, the video surveillance as well as the statements of both Mr. Zachary and Mr. Copeland?
Yes.
And I want to draw your attention specifically to the time period, roughly 7:29 p.m. All the way, I guess, 10 minutes to 7:39 p.m. So that 10-minute period, okay?
Okay.
Can you tell the jurors in your review of that activity, was there any activity as it relates to the handset associated with Mr. McMullins and the handset associated with Jeffrey Williams?
Your Honor, this is cumulative. Agent Bernie already testified to all this.
Sustained.
Well, let me ask you this, as it relates to your review of the call detail record, specifically the call logs of between Mr. Williams and Mr. Treadwell, can you tell the jury how many incoming and outgoing calls there were between Mr. Treadwell and Mr. Williams?
Found the same objection.
Sustained.
The specific number of calls between Mr. Treadwell and Mr. Williams, I don't believe was ever discussed.
Pretty sure it was.
It all painfully regarding different ways.
All right, I'll ask you this question. As it related to your review of the call detail records for Mr. Copeland, okay? Did you, during that time period of 7:29 to 7:39 p.m., locate any calls, whether it be incoming or outgoing, between Mr. Copeland and Mr. Williams?
7:29 to 7:39?
Correct.
If I may look at the logs. No, my short answer is I don't believe so. And that remains my answers on reviewing the actual phone logs. There were no calls between Mr. Copeland and Mr. Williams. That would have been in the phone logs from the company. Again, during Mr. Copeland's statement, he said he called Mr. Williams earlier that evening on FaceTime. FaceTime calls are not going to appear in phone records from the phone company.
Okay. But from your review, is it your testimony you didn't see any calls between Mr. Copeland and Mr. Williams?
That's right.
How about as it relates to Mr. Copeland and Mr. Bradford, Mr. Cobb, Mr. McMullins, or Mr. Treadwell?
Not that I found, no.
Okay, and I'd ask you the same series of questions as it relates to Quindarius Zachary. Did you see any activity on Mr. Zachary's records between Mr. Williams, Mr. Bradford, Mr. Cobb, Mr. McMullins, and Mr. Treadwell?
All right, well, I'm reviewing, and I'm looking at his records right now too, just to make sure I'm not mistaken. What were the names that you just gave me again?
Mr. Williams, did you see any activities that relates to Mr. Zachary and Mr. Williams?
I do not.
And between Mr. Zachary and Mr. Bradford and Mr. Cobb?
I do not.
And were there any, incoming or outgoing calls between Mr. Zachary and Mr. McMullins or Mr. Treadwell?
Not that I see, no.
Okay. And I want to ask you lastly about Mr. Antonio Sledge and your review of his call detail records. Did you see any incoming or outgoing calls between Mr. Sledge and Mr. Williams between the time period of 7:29 p.m. to 7:39 p.m.?
Oh, here we go. No, I don't see any.
And what about between Mr. Sledge and Mr. Bradford or Mr. Cobb?
Between what time frame again?
7:29 and 7:39 p.m.
Justin Cobb called Javaris Bradford at 7:31 p.m.
And I'm sorry, I need to be more clear. Did you see any, was there any incoming or outgoing calls between Mr. Zachary and Mr. Bradford?
I'm reviewing Mr. Zachary's records. I do not see any.
And in your review of Mr. Zachary records, did you see any incoming or outgoing calls between Mr. Zachary and Mr. McMullen?
No, I don't see any.
And lastly, for that same time period, did you see any activity, whether it be incoming or outgoing calls between Mr. Zachary and Mr. Treadwell?
No, I don't see any.
And when you're reviewing Mr. Zachary's records, which are contained in State's Exhibit 517Y, is that correct? Is that correct? Is the records contained for Mr. Zachary, do you recall those being 517Y?
I don't know the exhibit number for the records.
Okay. Further questions pending redirect?
Anybody have questions for this witness right now that are going to last less than like an hour?
Less than an hour?
Yeah.
Oh, I hope so.
Okay. Come on.
If I'm not done an hour, start throwing things in.
Okay.
Can we,
Is that
can we
just
do
the
that even
court
if
or
it is less than
anybody
an
in
hour?
the courtroom?
Mr. Sprinkle, good morning.
Good morning. How are you?
I'm good. And of course, we know each other. You know who I represent, right?
Yes.
Okay. I want to start out by talking to you about the jail calls and specifically my client, Shannon Stillwell's jail calls.
Okay.
I believe you testified that you downloaded, you estimated, I believe, 700?
So, yes, the batch that I downloaded from 2015, maybe the calls descended into 2016 as well. I don't remember. I think it was around 700 audio files. So that would represent 700 calls. It's not 700 exactly, but that's what I remember.
I understand. And you, do you have a ballpark of how many you reviewed?
I didn't review all of them.
Okay.
And a matter of fact, I probably reviewed like maybe 50 to 75.
Okay. And regardless of how many you personally reviewed, when you downloaded them, they are saved onto your computer, your hard drive.
All of them are saved, yes.
Okay, and they would have been passed on to the prosecution team in this case, so they could review all of them, correct?
That's correct.
All right, cool. All right, I just want to, your job actually with the DA's office right now is you do prelims. You cover prelims for cases, correct? Amongst other things.
That's correct.
All right. And I just want to unpack a little bit about what you said about preliminary hearings, is when I say prelims, preliminary hearings. You said typically a lead detective testifies.
That's right.
Okay, and you said hearsay is allowed, meaning the lead detective is allowed to testify about what other people said.
That's correct.
Okay. And you are aware that jail call that was played that was tough to hear, a little bit low, that was from November 19th, 2015, correct?
That's right.
All right. And November 19th, 2015 is the day that Shannon Stillwell had his prelim, correct?
That's what I recall, yes.
Okay. And that's why you had interest in that call.
That's right.
All right. And that call was made later in the day after Mr. Stillwell would have returned back to the jail from his preliminary hearing.
That's right.
All right. In Shannon, in Mr. Stillwell's preliminary hearing specifically, I know you said lead detectives generally are the only ones that testified. Detective Thorpe testified in that preliminary hearing, correct?
Yes.
Okay. Kenneth Copeland did not testify.
No.
Demekion Garlington did not testify.
No.
Quindarius Zachary did not testify.
No.
Okay. And I know it's hard to hear, but we're going to bring some volume to it, okay? Mr. Stillwell on that call said, I just went to court and they let everything out.
That sounds right, yes.
Okay, and that was after Detective Thorpe testified, correct?
That's right, after he heard Detective Thorpe's testimony. Correct.
Okay, he said they threw out, and it was tough to hear, so I want to make sure we're clear. On that call, he said they threw out Yak, Duop, Nard, correct?
I don't recall that they threw out Yak.
And I'm not suggesting throughout the case. I'm saying throughout the names.
That sounds right. I definitely heard him mention those names.
Okay.
So I took it to mean maybe like their names were mentioned, maybe.
Right. And because it was hard to hear, I'm just trying to make it clear. He's not saying, and nowhere in that call did he say he was with those people or anything like that day.
No.
Okay. And again, those names were mentioned by Detective Thorpe, correct?
That's right.
All right, cool. And he was, well, you can't testify to his mind state, but in that call, he said F word D, Woody, and the other D, correct?
I don't know. Yeah, that's not a verbatim quote. It's pretty close. I mean, I think you the spirit of his comment was captured in your quotation there.
Okay, and then he said, them F N-words know what is going on.
Something along those lines, yeah.
And then that's the case that was That's the tape that was played in court today, but there are 8 other calls on that CD, correct?
Correct.
All right. You also listened in on another call that Mr. Stillwell had with that same young lady on November 23rd, 2015, correct?
I think so. That sounds right.
At 16:08, at 4:08 p.m.
That sounds correct.
All right. At 5:07 into that call, Mr. Stillwell says, N-words will say whatever, correct?
That sounds correct. I know that was the general spirit. I don't know if that's an exact quotation as to what he said.
Okay. At 5:15 in that call, Mr. Stillwell said, they just trying to get the heat off their ass.
Again, that sounds like the general, that was something along the lines of what he said, that was the topic of conversation. I just can't say if that was a verbatim quote or not.
And again, Mr. Copeland at that time was facing federal and state charges.
That's right.
And Mr. Zachary, the other D, was facing charges related to the April 28th, 2015 shooting of houses, correct?
That's right.
All right. Mr. Stillwell in that November 23rd, 2015 call said, people will say anything to save their ass.
What's the best evidence? Mr. Sharp would like to play the calls and
Sustained.
Okay. It is in evidence, trying to save some time, but
I appreciate that, but if there's a valid objection, I've got to sustain it.
okay. All right.
I'll withdraw my objection.
Thank you.
I twisted his arm. Also in that call, and this is just one more, and then we'll move on. Mr. Stillwell said, they will sit right there and lie.
I don't recall that exact utterance being made, but it wouldn't be inconsistent with the general tone and of the call and the other things that he was saying.
Okay, cool. All right. Regarding Mr. Copeland's cell records and the plotting you did, let me get this right. 722 is the 911 call.
Yes.
Okay. You said at 7:26, you have Mr. Copeland headset pinging on the tower. So 4 minutes later, he's pinging on the tower at the Green Store or in the vicinity of the Green Store.
That is correct. It had moved north to that tower. So it was actually south of that tower seconds prior to, but yes.
Well, you don't actually, cell phone records aren't like a chart where you see, for instance, a cursor moving through a map, are they? You don't see real-time movements during a call, do you?
No.
You just get spots in certain points in time.
Yes, that's
when cell calls are initiated.
That is, well, you get the tower and the antenna utilized by the handset at the time of the call. It's a very big area.
But just at the time, right, vague area, but also just at the time of the initiation of the call.
Correct.
Okay. And so 4 minutes after the purported time of the 911 call, that headset is utilizing the tower near the Green Store.
That's right.
Okay. And we also, the truth is, we can speculate. We don't know how much time passed. We know the 911 call was made at 7:22, but we don't know how much time passed between the shooting and the 911 call, do we?
No, I can't say exactly. From what I recall, it's pretty quickly, but I can't say the exact seconds.
Well, we don't, people, before they call 911, they can try to hide guns, right?
There's any number of things people can do before they call
Right, they can
911.
try to get guns before they call 911.
The possibilities are endless as to what somebody could do before
Right.
they call 911.
And some people will do certain things before they call the police to where they're at.
Speculation.
Sustained.
Well, the bottom line is we don't know how much time passed. So we're dealing with inexact times.
Yes.
Okay, great. And you would agree that the Green Store is within a minute drive of the barbershop?
It's pretty close. I don't know. I can't say if it's a minute, but it's less than a mile away.
Less than a mile away. Thank you. All right. Finally, I'm just going to ask you about one other matter. Javaris Bradford has come up, aka Tudor, right?
Yes.
Okay, he's the owner of, through your investigator, he's the owner of the Pontiac at the Texaco.
Yeah, from what I recall, he was the registered owner.
Right, and he came up in your investigation, and the fact that Pontiac was on the video piqued your interest.
That's what I said. Yep.
All right. At some point in November of 2018, he wasn't charged in 2015.
He wasn't.
Okay. In November of 2018, he was still in the community, correct? He wasn't in jail or anything.
That's right.
All right. And you determined that you wanted to speak to him.
I did.
All right. And did you reach out to him?
I don't think I reached out to him. It was likely a DA's office investigator. Somebody reached out to him.
Okay. And was he asked to come in? Was he compelled to come into the DA's office? How did that work?
I believe we gave him a grand jury subpoena, if I remember correctly.
Okay, you issued a grand jury subpoena for him to come in and speak to you?
Well, the grand jury was in session that day. Having never spoken to him, I wanted to speak with him before I potentially put him up before the grand jury, and I did end up speaking with him. And at that point, I determined that not to put him up.
Okay, that was November 13th, 2018, correct?
That's correct.
And you had a meeting with him in a conference room in the DA's office, correct?
Right, it was on video. I have it right here, actually.
Yes. And present were you, Investigator Thorpe, at some point came into the meeting, correct?
Investigator Thorpe, I think he was present the entire meeting.
Okay.
It's on video, but from what I remember, he was there the entire time.
Okay, and then I don't want to mess up the young lady's name, so I'm not even going to try, but there was an investigator with the DA's office. Could you say her name correctly?
Cynthia Nwakocha.
Nwakocha.
Cynthia, first name, last name, Nwokocha, I believe.
Okay, thank you. And Javaris Bradford showed up, correct?
That's correct.
He did not have an attorney.
He did not.
And he showed up to the conference room without an attorney, correct?
Sustained.
Okay. For this meeting, you had video from the Texaco, or was it stills or video?
There were definitely stills. I think it may have, I can't recall if I played motion pictures of the surveillance video or I just had stills. He was at the very least showed still images.
And you told him, in fact, that you were investigating the homicide of Donovan Thomas.
I'm going to have to for research point as to what Mr. Sprinkle told Mr. Bradford.
Sustained.
To what? I'm not asking what Mr. Bradford told Mr. Sprinkle. I'm asking what Mr. Sprinkle told Mr. Bradford.
Oh, okay. Overruled.
Still an adequate statement.
Well, y'all can ask him. He's right here.
Okay. So you told him that there was evidence against him in this case.
I don't recall exactly what I said. I bet I likely said that to him. I would go so far as to say as yes, I did. That would
report. I'm sorry for interrupting.
Yes, I'm sure I said that to him because there was.
Okay. And you wanted him to speak to you about who was at the Texaco, correct?
I did.
Okay. And you told him that your supervisor wanted to charge him, but you were holding things off to give him a chance to talk.
Yeah, I mean, it is. Sustained.
Okay. Let me ask you this. Was your supervisor Pat Dutcher at the time?
He was in.
Sustained.
Your Honor, may we approach?
You may.
Baby, baby. All right, so we have another approach, y'all. So we are up to 3 now. 3 approaches. Our approach counter is growing. Our approach counter is growing. Oh, man. Oh, crap. Y'all, I don't think this Sprinkle, wasn't Sprinkle, he was a cop and he was I think Sprinkle was a cop and a DA, if I'm not mistaken. From Stepping and Stomping. Well, I'll tell you what. All you got to do is think about Glanville. What's so funny, I was making videos flashing back to the mistrial motions under Glanville. And just hearing Glanville's voice, it makes you feel like, oh. I mean, Glanville did such a job with this case that just hearing his voice is triggering for people who use that term. So what else do we have? We have basically this is going on until we have this going on for another 4 hours. Lunch should be coming up soon. We're going to be getting back in there for an hour. Do we have any firm word yet as to whether or not Monk Tonk's hearing will be televised or broadcast, streamed? Okay, looks like we're coming back.
Your Honor, based on the court's ruling, I do not have any more questions, and I'll note with like 50 minutes to spare.
That is correct. All right. Is any other defense attorney going to have questions for Mr. Sprinkle?
Briefly.
Okay. All right. I think we can fit in another 1 or maybe 2.
Good afternoon, Mr. Sprinkle, or AD Sprinkle.
Good afternoon. How are you?
I'm good. How are you doing?
Very well, thank you.
Can I just look at this? You can see this demonstrative, right?
I can.
I'll leave this here. Is that okay?
Mm-hmm.
That's okay. I don't see Mr. Kendrick's phone on there.
That is correct.
So you didn't do any analysis for Mr. Kendrick's phone on January the 10th, 2015.
I was without records to analyze for Mr. Kendrick's phone.
Okay, so you have no records of his phone on that date, correct?
Correct, yes.
Okay, thank you.
Anybody else?
I would like to ask a question, Chair.
All right.
Good afternoon, sir.
Good afternoon. How are you, sir?
I'm okay. How you doing, sir?
Very well. Thank you.
I'll actually let you know if I'm okay. Can I ask you some questions?
Well, yes, please.
Thank you. So, I want to just go into a few different topics. The way this was set up in your office, and you specifically work in this case, I think you made it clear. I'm going to be very brief, but if I'm wrong, just say I got it wrong. Law enforcement officers with whomever, FBI, APD, GBI, whomever is working the case, eventually your office may get involved and summon, or they give to you their work product or their files on the case. Fair to say?
That's fair to say, yes.
And then what you're doing is, because you're a law enforcement, but you're the arm of the attorneys who come to court, you have to look at everything and prepare it or not prepare it for any type of charges.
That's right.
All right. And when I say charge, I mean formal charge. I know, ladies and gentlemen, know police can issue warrants, but warrants aren't an official charging document. That would be an accusation or a bill of indictment.
Yes.
When you got, and I'm focused only on this case, obviously, okay? When you get you're getting the files from everybody who touched the case, as far as you could tell, from crime labs, from law enforcement, APD, GBI, whomever. I'm not eliminating, I'm not trying to keep out other agencies, but you try to get all those files together.
Well, yeah, I try to get all the documents or whatever media that every agency that investigated the case has. I mean, I want to get as much as possible.
Sure. Now, when you get the APD files, Atlanta Police Department files, and you start looking at them and reviewing them, I want to ask you if you can remember. Do you remember any notation from Detective Thorpe that he reviewed the McDonald's surveillance video from January 10th, either January 10th, 2015, and he did that on or about January 11th or January 12th, 2015?
I don't, and I feel like I would remember that.
Tell the jurors why you remember that, if you don't mind.
Well, the McDonald's, as they've heard, was the McDonald's at Old Hayville and Cleveland Avenue.
151 Cleveland Avenue?
Yeah, I think that's the address. Whatever, it's at the intersection, at or near the intersection of yes, I believe that's the address. What you just said, and that was said to be a rendezvous point, the parking lot of which. So I would have remembered I would have remembered it because, first of all, I've never seen that video. I've never seen any surveillance video from McDonald's. So if I were to read something that said from a law enforcement officer said they did review it, I would have said, well, I would have remembered. That would have been a big thing for me. I would want to have had the video. So no, I don't recall any notations from Detective Thorpe about him reviewing the video and not obtaining it, presumably. So no, I don't remember anything like that.
And if that video, if it's working and if it captures the area that this, what was your word, rendezvous? Is that what you just said?
I think so.
Okay. And the rendezvous, according to Mr. Copeland, let's say, it might be others, but at approximately 8 o'clock at night, January 10th, 2015, approximately.
Mm-hmm.
You could correct me, if my times are off. If that surveillance at the McDonald's captured people actually meeting, then we would know who was actually there and if Mr. Copeland was being straightforward. Is that fair to say?
It's speculation.
Sustained.
Did Detective Thorpe ever tell you, besides his file, did he tell you that he went out and looked at and saw or tried to see the video from the 10th day of January 2015, approximately 8 o'clock p.m. from the McDonald's?
Yeah, here's that.
I covered this with Detective Thorpe, and I'm impeaching him.
Overruled.
I don't recall him telling me that. It doesn't mean that he didn't, but I just don't recall it. It just seems like something that would leave a mental impression on me because, again, I would have just thought, well, where's the video? I don't have the video. I would have liked to know that. So I don't think he ever did.
In your experience, since I believe you said 2012, but it might have been 2009, with the DA's office in Fulton County, have you looked at and subpoenaed whether, or a grand jury, or excuse me, a court's search warrant, surveillance video from stores?
I have, yeah.
Have you found that after a certain period of time, some of the video is erased or deleted?
Yes, that's the practice. Videos are all digital. I don't want to say they're all digital. There may still be people using tapes, but every video I've ever seen has been digital, and they only have so much room on the computer system that's storing the video, and eventually will start overwriting itself.
Explain, first of all, this includes 2015?
Yes.
Okay. Tell the jurors what you mean. I know you're comfortable with it, but overriding itself, just explain that process from your experience, knowledge, and work with these.
Well, just like every computer surveillance system, cameras are hooked up to essentially a computer. The footage is recorded digitally and stored on a drive, some sort of media in the computer, but that drive can only store so much data, so many ones and zeros, I suppose. And so once the drive is full, the system is programmed to it's not like a tape where it starts in the beginning of the tape and starts overwriting it, but it starts writing data to the parts of the drive that already have data on it. And over time, the data just starts to rewrite itself. And eventually, after a certain amount of time, all traces of the footage from a certain date will eventually be gone as they've been overwritten by data from other footage.
So just putting that make it simple on a date. Have you seen a surveillance video that lasts 30 days?
I believe so. Yeah, I don't want to throw out any names, but there's one place in particular that comes to mind, but it's not relevant here, and I also don't remember exactly, but I do believe that 30 days I have seen before.
Okay. What's a typical days until it starts overriding?
I'm going to just ask and answer the speculation element relates to, be honest with you.
I'm impeaching Detective Thorpe.
I feel maybe 2 weeks. That's always what I kind of mark in my mind as if it's within 2 weeks of an event. I mean, you want to get the video as soon as possible, to be clear. But I really start losing hope after 2 weeks. But again, it depends on it could be a big retail outfit. Now going back to 2015, it may be a little different, and maybe they just have petabytes of storage for their video and it's stored off site. But your typical, like a gas station, particularly in 2015, where it was stored within, probably on a DVR, you're going to want to get that as soon as possible. You can start overwriting after 48 hours.
Okay. And when you say then it writes it over, so if I'm just using 2 weeks, okay?
Mm-hmm.
January 1, 2015, 2 weeks would go to approximately January 14, 2015.
Right.
On January 15, 2015, does the entirety, in your experience and your dealing with this, does the entirety of everything in those 2 weeks go away, or is it on a rolling basis?
Would you object to ask and answer on
Not of this witness.
and speculation as to this witness?
He's asking within his experience overruled.
Well, okay, so are we talking about one location and if we're talking about surveillance footage, one location and one computer system, or we're talking about in the entire world of surveillance footage?
McDonald's, 2015, January 10th, surveillance, just typical McDonald's, your experience, hypothetically 2 weeks. I want to know on the 15th day, so I'm just after the 2 weeks, what you're explaining to the jury, does day one, January 1 override, or the entirety from January 1 to 2014? That's my question.
To lack of foundation at this point.
Sustained.
In your experience with a 2 week camera, does it override just one day at a time? As the next day comes in, the first day's gone.
Vague as to your experience to a camera in a 2 week period. Any camera? I mean,
Sustained.
When you say override, tell the jurors what you meant by that.
asked and answered.
Sustained.
I don't believe he just
Yeah, he
used the
did.
word.
He explained it in detail.
All right. Did you or any of your members of your team, I'm including the prosecution team, you understand what I'm asking?
Mhm.
So prosecution team are all law enforcement, GBI crime lab, your office, whomever, okay? FBI. Did you ever find out from any source that McDonald's, how long, if at all, they had that surveillance video?
The record retention period for surveillance video, if I knew it, I don't remember it now. So no, I can't answer. I don't know what their retention period was back then, nor do I know what it is now.
Did you ever hear from a detective, you know who Detective Gaither, Detective Dennis, they worked together, gang unit in 2015, January?
Yes, I know them.
Okay. Did they ever tell you or put in writing in any way that they went to the McDonald's in June 11, 2015 and inquired about the surveillance?
Objection, hearsay.
I am impeaching Detective Gaither's testimony.
And who are you asking about at this point?
Detective Gaither, January 11th, 2015, going to McDonald's and inquiring about the video.
And that is hearsay, and it's not impeachment unless they specifically confronted Detective
Sustained.
Gaither
I did confront Detective Gaither.
with
Yes.
telling Mr. Sprinkle as to whether they got video surveillance footage or not.
I want to know if
Was
it's
not
in,
I
want to know if it's in his
Detective Gaither was
records.
not confronted with that.
Okay, sustained.
I want to know if it's in the records.
That wouldn't be, then that would, rephrase your question. That question, the objection is sustained.
Do you have any information from any source that you looked at in your records, conversations that Detective Gaither and or Detective Dennis went to the McDonald's on the day after interviewing Kenneth Copeland, June 11, 2015, and inquired about their surveillance equipment?
No, I have no notes that indicate that, and I have no memory of any conversations that I had with them where they told me that they did.
Did you ever obtain personally or have a member of your team, or it was done before you got involved, Sky House, you know, the condominium that Mr. Williams was living at in January 2015?
Yes.
Okay. Any surveillance from there?
No.
How about the Green Store? Any surveillance at the Green Store that Kenneth Copeland states that he was there, personally there, at and around the time of the killing of Donovan Thomas? Any surveillance from there?
No, no surveillance.
Did you or members of the prosecution team, I'm including all law enforcement, ever interview the people or persons that Kenneth Copeland said in June 10, 2015 that he was with at the Green Store at the time around Mr. Donovan Thomas's murder?
Well, there's a little Rick that he mentioned, if I remember correctly. No, I didn't, nor do I know if law enforcement did. No.
How many cell phones did Kenneth Copeland have access to that he can use on January 10, 2015?
All I know of is the one that I testified to.
And you do know that Kenneth Copeland testified in this court, and if you don't know, just say I don't know, that he had multiple cell phones.
I'm going to object at the rule of sequestration.
I mean, I would hope he doesn't know.
Okay.
Since he's a
Do you
witness in this case.
have knowledge that Mr. Copeland did not have 2 or more cell phones on January 10, 2015 through your investigation?
Asked and answered. He just answered that question, that he only knew of the one cell phone.
Sustained.
Let me ask you this. Phone records that you talked about at length with the Honorable Mr. Body, through your analysis, and what you were given and subpoenaed more phone records, fair to say?
Yes.
All right. Those phone records give a general whereabout of where a handset is located, if it's working properly, if the records are accurate. I'm assuming all that, where a phone set would be in relation to a cell phone tower. Is that fair to say?
Right, just the area that the approximate area that the phone would be located based on the tower that it utilized.
And in your experience, if you know, and if you don't know, just say, I don't want to testify to this. That area could be how many miles, how many feet, do you know? And we're talking about Atlanta, January 2015. And please, I'm not trying to put you out on a limb. I know you're under oath.
Well, I don't know that anybody could testify as to the exact square footage of the area, but it suffices to say it's not like GPS. It's a large area, probably, like over a mile.
Could be multiple miles.
Could be.
And jurors may not understand what you meant by, it's not like GPS. Just explain that.
Well, like a point on a map. Like, in other words, when you get phone records, you don't have a log of the exact locations of a cellular device, like a pinpoint that you could put on the map that the phone was right here. Like, for example, I have a phone on me. If you were to get my phone records, it wouldn't show my phone sitting right here in the witness stand. It would show that it was using the tower next to the courthouse or near the courthouse, down the street, wherever, but it's not exactly.
Now, are you aware from your review of your records as you've been testifying and the recordings that Kenneth Copeland met with Detective Thorpe, Homicide Detective Thorpe, on the early morning hours of January 11, 2015?
Yes, I do recall Kenneth Copeland traveled to the precinct or arrived at the precinct and spoke with Detective Thorpe, yes.
And did you remember seeing that video? Did you ever watch that, and do you have a memory of that video encounter?
I believe so. It's been a while. I don't recall that video being all that important to me. I remember summarizing it, so I must have watched it, yes.
Do you remember Kenneth Copeland had a cell phone on the desk when he was speaking with Detective Thorpe?
That I don't remember. I'd have to take a look at the video.
Well, the jurors have seen it, so we're good. Do you remember Kenneth Copeland explaining that he knew that cell phones can give an area on January 11, 2015, explaining to Detective Thorpe that he was aware that check the cell phone records, check the cell phone, it'll show it's in this area. Do you remember him saying that?
I remember somebody saying that during the, I can't say that I remember if it was him, though.
All right. Let me ask you this. The cell phone records that we have here, unfortunately, don't give the actual communication. They might say handset of Kenneth Copeland, speaks with a handset of Natasha Williams, but we don't know what's being said according to these records. Fair to say?
That's correct.
Now, with regards to Nyesha Williams, Nyisha Williams, typical
Yes.
spelling. Do you know that person?
I do not.
Okay. Do you remember seeking and obtaining and subpoenaing cellular telephone records for Nyesha Williams?
I do remember doing that.
And do you remember why you did that?
They appeared in there was a number that appeared in Kenneth Copeland's cell phone records that evening. And when I say that evening, I mean the evening of January 10th, 2015. And specifically, so I'm clear here, it was 404-621-0102. I'm looking at Kenneth Copeland's records to refresh my recollection. And because of the times that there were phone calls sent or transmitted and received by that number, I thought it was relevant. So I subpoenaed both the call logs and the subscriber information. The subscriber information was the name of Nyesha Williams.
And sometimes people can, it's nothing wrong with it, people can use a cell phone that's not registered in their name for various reasons. Is that fair to say?
It's very fair to say. It happens all the time.
So a Nyesha Williams, I'm just using that name since we're using it, she could be on the Verizon call as a registered person, but she can freely give me her cell phone and I could use it all the time.
That's right.
But it would come back if somebody, like you subpoenaed it, it would look like it's Nyesha Williams' call. In the name doesn't mean she's using the phone.
That's right.
And you, through your research, took Kenneth Copeland's statements on June 10th, 2015. And when he said he called Mr. Garlington, you wanted to know what number Mr. Garlington was using then. Is that fair to say?
That's fair to say.
And through your deduction, whether it's right or wrong, you said the Nyesha Williams registered phone might have been in the custody, control, and use of Demeke and Garlington.
It's possible, but I do not know.
I'm not saying anyone knows, but that was your deduction.
That's right.
That's why you then targeted the jail records for Nyesha Williams' registered phone, because you thought it may relate to Mr. Garlington.
Do you mean the cell phone records for her phone?
Did I say that?
I think you said jail records, but yes, I obtained the cell phone records.
I
for a
said
phone.
jail record, I meant cell phone record.
Yes.
Okay. Now, when you obtained those records, you specifically did not request, you testified to this before, you specifically did not request historical cell site location data for Naisha Williams' phone.
That's correct.
And what that means to the jurors who may know what it is, but don't, that means you don't get the longitude and latitude of which tower that phone is employing at the time of the handset speaking with the cell tower, then it goes to switching station.
That's essentially right. You just get a log of incoming and outgoing calls, the times, the numbers, but the columns that tell you the location of the tower that was utilized, you don't get that. You need a search warrant for that.
Did you ever exclude the Naisha Williams cell phone as the phone Mr. Garlington was using on the night of January 10, 2015?
Did I ever conclude that it was not his phone, or the phone that he was using, rather?
I meant the phone is using.
No, I never definitively concluded that he was or was not using that phone.
And if, as you believed or hunched or were doing your work, Mr. Garlington was using that phone registered to Naisha Williams, then you can track at least what calls were being made at what times. Is that fair to say?
Speculation on if it belongs to God.
All right, go ahead. You can answer.
You mean I can at least see the phone,
Yes.
like the list of calls that were sent and received, text messages sent and received by the phone, the
True.
handset?
Yes.
Yes, I believe I obtained those records.
All right. Now, Mr. Copeland stated on June 10th, 2015, from the McDonald's, that he was in his car at some point, along with Mr. Garlington and along with Mr. McMullen, Demise McMullins, also known as Nard.
If I remember correctly, I think you said it was his brother, Rontrez Brock's Dodge Charger. But yes, all three of them were at the McDonald's in that car, a car that he had possession of. Kenneth Copeland did, that is.
Okay. And Kenneth Copeland said that I'm not saying it's true, but Kenneth Copeland said on June 10, 2015, he left the McDonald's. I'm using 8 o'clock. If I'm wrong, just correct my time, but approximately 8 o'clock. He was driving the vehicle, the Charger, along with Mr. Garlington in the front passenger seat and Mr. McMullen or Nard in the rear driver's seat.
That sounds right, yeah. I don't recall what the exact seating arrangement was, but the occupants of the vehicle, that sounds correct.
And then he has that car, the Charger, going up, following another vehicle, a Nitro, white Nitro, to around Jeffrey Williams' Sky House condo.
That's what he said.
And did you look, when analyzing the calls from Naisha Williams, records rather, from Naisha Williams, and realize that during that relevant period of time on the supposed drive from the McDonald's to the Sky House, the Naisha Williams call that's potentially with Mr. Garlington and the Mr. McMullen calls, the number associated with Mr. McMullen, were in communication with each other?
Are you asking me, did Mr. McMullen and or the phone subscribed to by somebody named Naisha Williams communicate?
At the relevant time of when supposedly Mr. Copeland is driving them together in the same car to the Sky House? Yes, that's my question.
I don't recall. I do recall Mr. McMullen was a very frequently contacted number within the Naisha Williams phone records. I don't work, but I don't have, well, I do have Mr. McMullen.
If you could check it, I'd appreciate it. And just tell the jurors whether at the time they're supposedly in the same exact car, these two phone numbers of the Naisha Williams and the Mr. McMullen are communicating together according to phone records.
Okay, so we have what?
Can you use what exhibit you're using?
Is that an exhibit, or
It's already in evidence.
does he know what exhibit number it is?
Do you have an exhibit number? Are you looking at an actual?
I think he may, well, y'all can clarify it, but is there an exhibit number on what you're looking at?
No, I just brought
No,
the phone, I printed them out and brought them to court. So
This is, what is it that you're looking at?
the phone records for 470-217-6080, Demise McMullen.
Okay, does anybody know what exhibit number that is?
Yes, 464Y.
Thank you.
Mr. Steele requested it during my direct.
Okay.
I didn't want it during this process as well.
Okay, so what I see here is at 7:59 PM on January 10th, 2015.
Just do me a favor, because you're looking down. Can you just go a little slower?
Yes, yes. What I see.
Actually, let me stop. How much longer is your examination of this witness going to be?
45 minutes?
All right, let's stop and break for lunch.
To an hour and a half, because I don't want to,
All right, I'll see y'all back at, let's be back at 1:45.
Thank you, Your Honor.
All right, unless there's anything we need to take up, I'll see everybody back at 1:45. All right.
All right, y'all, I'm going to play the video from yesterday.
Right.
I'm going to play our video from yesterday. And we'll be back at 1:45. This video will last a little bit under that, but we'll figure it out afterwards. So, going to play the video. Gonna play the video from Detective Dennis getting booted.
Excuse me, Your Honor. I have one question. Is retired investigator Dennis going to return to the stand at some point? I'm not sure if the state had planned on that or not, or if your sanction would bar that as well.
Oh, no, he won't be returning.
Thank you, Your Honor. I just wanted that clarified.
And we are back. Stop what you're doing and go ahead and hit that like button for us. You know, we appreciate it. It helps us and it helps you because it helps us and it helps us stay here creating this wonderful content for you. Y'all, today we have a very dramatic video for you, a serious mistrial motion, and your boy Detective Dennis gets banned from the YSL trial. You're going to see everything in this video. So Dennis, from the infamous duo of Gaither and Dennis is no longer allowed to come back and testify. Now, as you watch, you're going to see a couple of exhibits and you're going to hear the audio go off. That is not due to our feed. That's due to all of the feeds. When they put up these visual exhibits, the audio goes dead for a while and you're not going to actually hear what Dennis says. But due to the mistrial motions and all of the ruckus after the fact, you're going to know what he said and you're going to see him get banned from the trial. You're going to see all of the back and forth. You're going to see everything. So without further ado, stop what you're doing right now. Like this video. Don't forget to comment and subscribe, and let's get into it.
He's not already qualified with that degree of specificity. Go ahead, whichever one of y'all is going to handle that part.
Detective Dennis, as a gang investigator, did music sometimes come up in your investigations?
Yes.
How did it come up in your investigation?
A lot of rappers participate in gangs, and so it often came up.
And as an expert, when you said a lot of gang members rap. Do gangs in your experience use music in order to promote their gangs?
Yes.
Do they also use music and sometimes to promote fear and violence in their music?
Yes.
I think it's, if you could focus more on what his training and experience with regard to that is.
Sure. Tell the court about your training experience in using music as a part of your gang investigations.
In my almost 10 years in the gang unit, we investigated countless different gangs, gang members, music, literature, social media. Like I said previously, nothing was off limits. And music, like I said earlier, a lot of times we weren't investigating the music, we were investigating the crime, and the music came up or someone made us aware of a song that referenced something in reference to the crime in which we was investigating.
And as you heard those songs, how did you then use that as a part of your investigation?
That helped understand sometimes why a retaliation happened, or were they taunting a rival, or were they highlighting something that they did or something like that. And that helped us investigate what we were doing.
And how often over your 10 years of being a part of gang unit, would you say music came up in your investigation?
A lot, like a percentage.
Yeah.
I couldn't even, 75% to 100%, I don't know.
Okay. And have you ever had the occasion to teach on how music and gang culture, about music and gang culture?
Yes, I think I said last time I had a presentation that I talked to other investigators and students about hip hop and gang culture and how they go hand in hand.
And how many times have you done that presentation?
More than 10.
More than 10. And just tell the court a little bit about what you talked about in that presentation.
In the presentation, I basically used movies, music, and showed through entertainment how in the African American community, they can be brainwashed through entertainment, and how gangs has been pushed on the African American community through entertainment. I think I referenced last time the movies Boys in the Hood, Menace to Society. I didn't know what a Blood or a Crip was until I saw Colors. All of that is through entertainment. Same thing with music.
If you could tell the court briefly, what were some of the songs that you used as a part of your presentation?
Part of my presentation.
I'm more interested in his own training than his teaching other people. I mean, I get that he must have had something that from which he could then teach other people, but we're skipping that part.
So again, over the course of your tenure, you said you maybe had about 75 to 100% of your cases are with, may have had some type of music involved in your investigation. Have you had you yourself training specifically on how music can be a part of your gang investigations?
I took every gang class that they offered us. We took gang training through Gypstick. We took training in other jurisdictions. We took whatever gang training was offered in an effort to learn trends, music or what have you. We also had monthly meetings with other departments, and we also information shared about music, gang trends, and different things, because a lot of times something that was happening in Atlanta or happening in another jurisdiction eventually was going to come to Atlanta. And so we often shared this information over the course of my years through my training and my own background. I was able to decipher a song, decipher movies and entertainment, and understand what's being said. And through interviews with individuals involved in our investigations, a lot of them would help us understand some of the music and some of the lyrics that they were saying.
Of course, indulgent. No further questions.
All right. Does anybody have questions? All right.
I want to hone in specifically on your training, right?
Okay.
I heard you say that you've given a presentation about gangs but I'm asking you about gangs and specifically rap music and rap lyrics as it relates to gangs. What is this presentation that you've given, and are there any literature? Is there literature or any material that you have that you can share with us that you've used in this presentation?
I don't have the presentation with me, but in the presentation, it's my own accumulation of entertainment, music, and presenting. I present to kids, I present to adults and other cops and educating them. In the gang unit, a lot of officers don't understand what's happening right before their eyes. And so for myself, I was tasked with educating not only our department, but other departments when I worked for the ATF, them as well as students about this information.
What literature specifically have you used to educate either yourself or other investigators in regards to the relationship to rap and rap lyrics to gangs?
You mean, when you say literature, you mean like books, or are you talking about magazines?
I'm talking about books. I'm talking about learning treatises. I'm talking about studies, anything like
Training
that.
materials.
None of it.
None.
Our magazines, we might use any hip hop magazine or different examples that's in a magazine might be something that we are able to reference because of the wording or something along that. When you reference books, I've read different gang books from other officers. I've read a book out of Compton. I think it's A Lonely Day in Compton or something, and it was written by gang detectives out of Compton because a lot of gang, they were privy to a lot more information than we were in their own work over the years.
Right. And what specific information? Here's what I'm trying to get to, Detective. I'm really not trying to trick you or anything.
Okay.
But I want to know specifically, is there a book? Is there a training manual that specifically deals with rap lyrics as it relates to gangs?
No.
Okay. You referenced before, I think you used the words, my own background is used to decipher this information. You talked about movies.
Mm-hmm.
So are we talking simply about you looking at the movie Menace to Society?
Yes, I've seen it. Yes.
Right. Looking at the movie Boys in the Hood?
Yes.
And you're saying that is what you have used to form your expertise in regards to rap lyrics and the relationship between rap lyrics and gangs?
What I'm saying is, based on my own upbringing, growing up in a gang-infested environment, my own education, my own training, as well as watching these said movies is where I formulated my opinion.
Have there, other than what you yourself have experienced in your own personal life, right? Have there been any, for example, instructors, professors, or anyone else who have taught you using material or lesson plan in regards to the relationship between rap lyrics and gang? No?
No.
All right. Those are all the questions I have.
Anybody else? Any redirect?
Nothing from the state, Your Honor.
All right. So, and then has a part of what you have done, how does that intersect with what you know about gangs?
What?
The music and the lyrics.
From listening, I'm a rap fan myself, and from listening to music and watching movies, videos, YouTube, I'm able to understand what is being said and what is being expressed. Of my life, it's just like watching anything. I can understand it. And by me being a gang investigator, a regular person might listen and think it's art. And it may be art. But for myself, with my education and my background and investigating gangs for a number of years, I'm able to understand exactly the message that's being kind of, what's the word I'm looking for? That's being given. I can't even think of, but I understand when someone says, I caught somebody down bad. To you, you may look at that and say, oh, they caught somebody down bad. But for me, that means you caught somebody and you were able to hurt them, kill them, or what have you. So I'm able to decipher what is being said. Regular lay person does not understand that. They look at it as just art or a lyric in a song.
Okay. All right. Once again, I'm satisfied that based on his training and experience, he can testify as an expert as to maybe a double meaning within rap lyrics.
Your Honor.
And it's obviously ultimately going to be for the jury to determine whether they,
And
believe and accept as credible anything he or any other witness says. Yes, sir.
And Your Honor, that's my issue. I understand the court's ruling. I just asked you to consider what he has testified to. He has no specialized knowledge beyond the ken of any layperson. I understand his saying that what he grew up around. I grew up in Brooklyn too, and maybe there are members of the jury who have the same life experiences as him, but that's not what the purpose of.
I understand. I'm not basing it just on where he grew up. It's
Right.
his training and experience as a gang investigator.
But specifically in regard to the interpretation of rap and rap lyrics as it relates to gangs, he has not given the court any information whatsoever to indicate that he has any specialized knowledge that will qualify him as an expert, such that his opinion could go to the jury for them to look at him as an expert in that field. None whatsoever. And I'd maintain my objection. I'd ask that he not be qualified in that particular area.
All right, I understand, and your objection is overruled. I mean, this just happens to be words that are set to a beat. It's no different. All right, let's get the jury in here.
Investigator Dennis. Before we go back to where we left off at, just a few additional questions. You talked about during your investigation back in 2015, you were able to go to social media and pull things from social media. Is that fair to say?
Yes.
All right. And even after 2015, did you still pull or were able to view social media of individuals that were a part of that 2015 investigation?
Yes.
You have permission to approach?
You may.
I'm going to show you what's been marked as State's Exhibit 1TT and 544Y. Can you please talk if you recognize what's in first State's Exhibit 1TT?
Yes.
And did you pull that from social media?
Yes.
And is that a fair and accurate depiction of the picture in which you pulled from social media that contains a blue car and an individual standing on a blue car?
Yes.
You know, this time State like the Tender State's Exhibit 1TT into evidence. 1TT into evidence.
All right, that's admitted.
And then also looking at State's Exhibit 544Y, is that a picture that you pulled from the Instagram of, whose Instagram is that? Let me ask.
It appears to be Shannon Stillwell.
And what was the Instagram handle?
OG_Bull, BOOL.
And
Excuse me, I'm sorry. Could you use the microphone, please? Thank you.
And is there a date on that image?
March 28th of 2015.
Your Honor, this time the State would like to tender State's Exhibit 544Y into evidence.
It's admitted.
Your Honor,
Yeah.
I do have a
sorry.
specific objection.
Okay.
I can approach now, or I can approach before it's published.
Yes, go ahead and approach now.
I'm going to also show you what's been marked as State's Exhibit 545Y. Do you recognize State's Exhibit 545Y?
Yes.
And what is it State's Exhibit 545Y?
It's a post from Mr. Stillwell's Instagram.
Okay. And was that also pulled in, appear to be, have been posted in 2015?
Yes, same date as the other picture.
Yeah, this time the State would like to tender State's Exhibit 545Y into evidence.
Just renewing my objection from when we litigated these before.
Okay, it is admitted. All of the objections that were made before are preserved. And as to 544Y, that's admitted, subject to whatever modification the two of you agreed to.
And preserving the objection.
Sure.
Thank you.
All right. First showing State's Exhibit 543Y. Now looking at State's Exhibit 1TT, why was
Your Honor, this one you cannot fix. This is bad character evidence that came in. The state should have prepared their witness. I move for a mistrial. This absolutely cannot be unheard by the jury. It was heard clear as day in his deep, sonorous voice. They have heard it. They have absorbed it. It cannot be fixed. 404A, Your Honor.
Here, whatever response the state might be able to make on that.
Your Honor, that was not the state's intention.
I'm sure it wasn't.
Your Honor, that wasn't even, that response didn't even come across my mind that would even have come out of our witness's mouth, Your Honor. The state's intention was to solely talk about the vehicle that he was standing on and the fact that he was standing on that vehicle. If you can just give us an opportunity just to look at some case law just to see if we can.
Your Honor, I'm sorry. How many times has this man testified in a trial? How long has he been I know he's a retired investigator. How long has he been an investigator? He knows he is not supposed to say that, Your Honor.
I would find it surprising if he isn't aware that that's not supposed to come out. I do not believe that the state intended to elicit that. And I think that you actually yourself acknowledged up here at the bench that you don't believe that was the state's intention.
I do not believe it was their
Nonetheless,
intention.
it happened. I'm going to give y'all about 15 minutes or so to find whatever you might be able to find.
Thank you, Your Honor.
All right.
Thank you.
All right. What is the state?
Yes, Your Honor. The state will ask that you deny defendant's motion for a mistrial. The state would like to cite the court to Swims v. State, which is 307 Georgia, 651, a 2020 case, Your Honor. In that case, which was the defendant's only enumeration of error, and I'm in Division 2 of that opinion, Your Honor. Swims contends that the trial court erred in denying his motion for mistrial after his character was improperly placed into evidence during Chelsea Owens' testimony. When the state asked Owens if Swims offered any reasoning for why he wanted to escape, Owens responded, and this is what the witness said in that case. I asked Swims, why would he do that? I said, why would you want to do that? He told me because they did not honor his fast and speedy trial. He was looking at getting off on the technicality because they didn't honor that. He didn't have that for his defense. He said he was doing time. He had a lot of time in West Virginia that he wasn't never going to get out. In that case, Swims' trial counsel immediately asked to approach the bench and moved for a mistrial. The trial court judge overruled Swims' objection and denied his motion. The state resumed its direct examination of Owens, who then testified that Swims provided another possible motivation for attempting an escape, that Swims had murdered Clemson. I asked him, did y'all kill that child? And he told me, why do you want out of here so bad? So that was how the testimony continued. I'm going to skip down. A trial court's denial of a motion for mistrial based on the improper admission of bad character evidence is reviewed for abuse of discretion by examining factors and circumstances, including the nature of the statement. Slow down, reading, please. Sorry. The other evidence in the case and the action taken by the court and counsel concerning the impropriety. And they cite Smith v. State, 302 Georgia, 699. A passing reference to a defendant's incarceration does not place his character in evidence. And they cite Lewis v. State, 287 Georgia, 210 at Penn site 212. Furthermore, Owens' passing reference to Swims' incarceration in West Virginia for an unstated crime was an unexpected answer to the question asked by the prosecutor, who was attempting to establish that Clemson's murder was the reason Swims wanted out of jail so bad. And they see Walker v. State, 282 Georgia, 703. A non-responsive answer that impacts negatively on a defendant's character does not improperly place his character in issue. After Swims' mistrial was denied, the state did not inquire further into Swims' crimes in West Virginia beyond the single confirmation that his incarceration there also served as a motive for escape. Your Honor, given what occurred in this case, Your Honor. The state's intention, when I asked the question, what was the significance of that picture, the state's intention was solely to talk about the fact that Mr. Kendrick was standing on that car being that of Rayshon Bennett. His mother had identified that car yesterday during her testimony, Your Honor. So it was an inadvertent response, which was non-responsive to the state's answer, Your Honor. And given that is what occurred, Your Honor, the state would ask that you deny their motion. Furthermore, Your Honor, other factors that you look at in order to determine whether or not a mistrial should be granted is the nature of the statement, other evidence in the case, the actions taken by the court.
The what?
The actions taken by the courts. Was the reference isolated and brief, and whether the jury's exposure was repeated and extensive, and was it inadvertent? Additionally, Your Honor, within the indictments, Your Honor, we did charge Mr. Kendrick with, as one of the overt acts in this indictment, which is Act 58, and he's also charged in this indictment in counts 63 of this indictment, Your Honor, possession of a firearm by a convicted felon, previously convicted of a felony involving the use or possession of a firearm. Your Honor, so for the purposes of having to prove that count of the indictment, we will have to enter Mr. Kendrick's certified copy of his conviction, of course, with a limiting instruction that only be used against him, Your Honor. So the fact that came out during that testimony would not be substantially more prejudicial, Your Honor, given that, one, the jury has heard this indictment, and as well as this evidence will come out, at least that he was convicted, because we have to prove that portion of the indictment, Your Honor. So we would ask that the court deny his motion.
All right.
And we have instructed our witness, pass that as well.
Ms. Weinstein.
Thank you, Your Honor. In the Swims case cited by the state, correct me if I'm wrong, but I do not believe that was a seasoned officer that testified about the bad character. Is that correct?
I don't know if it was seasoned officer.
No, I looked. It's not.
It's
It was
an
a fellow
inmate, right? And I think there's a distinction between a fellow inmate and an officer with decades of experience. And it's not just I that think that. I mean, I think if you go back and look at Posey v. State, which you may have already looked at, 152, Georgia Appeals 216, there you have a case where a seasoned officer testified about bad character of a defendant. The court in that case called for, there should have been a mistrial. It says that when it's impossible for the trial court by corrective instruction to rectify the harm done by improper testimony, a mistrial must be granted. And again, the issue here is you have a seasoned officer, someone with years of experience testifying. And in Posey, there's really very instructive language from our courts where they say, we reiterate here, I'm sorry, I'm talking too fast.
And too loudly.
Yeah, you know what? I'm going to tone it down. We reiterate here what we said in Boyd. It may well be argued that peace officers are not always well acquainted with our rules of evidence and that statements such as the one here are merely inadvertent. I'm going to stop the quote for a second to say something, which is, again, here we have a peace officer, here we have an investigator who is well seasoned. The quote continues, but if we refuse to reverse this judgment, then we provide no incentive to district attorneys and solicitors to counsel their witnesses, especially law enforcement officers, to avoid extraneous and inadmissible outbursts. It is high time that this court go on record as opposing without reservation such conduct by law enforcement officers. Posey is exactly on point. Posey calls for a mistrial. This officer should have known better. The state should have properly prepared the witness to not issue, to not blurt out, to not state so clearly that my client was just getting out of prison. It cannot be corrected, Your Honor.
All right. Any last words by the state? Well, actually, never mind. It's the defense's motion, so y'all don't get any last words. All right. I think I am finding that this was not intentionally elicited on the part of the state. However, I also am finding that this witness as a law enforcement officer should have known better than to make any mention of it. It is, however, significant that one of the charges against Mr. Kendrick in this indictment is that he is a convicted felon. Were it not for that, I would grant the mistrial motion. But given that the jury already knows that he's been convicted and is a convicted felon anyway, even without this testimony, I don't think that a mistrial is warranted. I am, however, going to give a curative instruction and as a sanction for this having occurred, that's the end of the testimony from this witness. There's going to be no more testimony from him. So he's done. All right. What I am proposing to say as an instruction is Defendant Kendrick's prior criminal history has no relevance to this case except as to count 63 and should not have been mentioned. Further, this witness, as a former law enforcement officer, should have known better than to make any mention of it. Likewise, Mr. Kendrick's criminal history should not be considered in connection with any of these other defendants or any of the charges against them in this case.
Your Honor.
Yes, sir.
I would also then, because we didn't have the opportunity to cross-examine, so it would be a confrontation clause. It would be reversible error. So I'm moving.
Let me ask you this. Have y'all cross-examined him the two times before? All right. So we're going to strike everything he said today.
And
all right.
the notes, just like you did before, all the notes, they have to go back, give them to the court if you don't mind, put them under seal, or that's what I remember you doing, but whatever you did with them. And if they can't follow that instruction, please alert your honorable court if you don't mind.
You're right. Can we just ask that we could just stop our testimony and give them an opportunity to cross-examine him?
No. Yes, you can ask, and the answer is no.
But I don't.
The answer is no. You can make a record.
Yes, Your Honor. Your Honor, I don't believe that my question was broad.
It's not your fault.
And I understand that, but Your Honor, the testimony that was given today, this was a one-time infraction, Your Honor. And we would just ask, we can understand that if his testimony, if the state no longer can question him, we would ask that all of his testimony from today is not stricken because of one mistake. Like this was one mistake that he made, Your Honor. We would stop our questioning of him, allow the defense to cross him on what has come out now. But all of the information that he's provided this far, he has been careful. He has not said anything today that was even remotely close to what happened here right now. I believe it was a mistake on his part. Maybe as a state, I should have instructed clearer, and I will take that responsibility, Your Honor. But given that this was one moment in time, the state is going to ask that we will stop questioning. If that's the sanction that the state has to stop questioning him, Your Honor, we will take that sanction and ask that the defense be allowed to cross him and that we be not allowed to direct him, and that's fine, but not that his entire testimony from today be struck, Your Honor, given that that was one mistake that he made very short in time, Your Honor.
All right, understood.
Do I need to respond to that, Your Honor?
You don't need to.
Thank you.
Yes.
I did not mention it, but also all the exhibits admitted through this gentleman need to be taken back under seal as well and disregarded by the jury, please.
Do you have another witness available?
Yes, Your Honor. We're
Okay.
trying to figure that out.
All right, go ahead and get them lined up.
Excuse me, Your Honor. I have one question. Is retired investigator Dennis going to return to the stand at some point? I'm not sure if the state had planned on that or not, or if your sanction would bar that as well.
Oh, no, he won't be returning.
Thank you, Your Honor. I just wanted that clarified.
Unless you'd like for me to have him come back and admonish him. But I'm not going to do it in front of the jury because I don't think we need to highlight it further. Okay. I kind of would like to tell him he should have known better, though. Y'all can just relay that. Okay.
Excuse me, Your Honor. And I'd like to renew my motion for mistrial prior to the next question.
All right. It is denied.
Thank you.
Okay. Do you have another witness you can put up now, or do I need to give y'all a few minutes? Okay. Why is the possession of a firearm by a convicted felon, why is that already in before the jury? That wasn't bifurcated?
It was not bifurcated, Your Honor.
Did nobody ask that it be bifurcated?
This has been a long trial, and I know you're not asking about my client's charges, but my recollection is I asked for my client's charges to be bifurcated.
I think we can.
And it was denied, is my recollection. And so.
It might be, I'm going to check, you overact as well, and that's why I think I'm going to check. So it's an overact, so like a felony murder.
Okay, what is the overt act? That they're convicted felons? That would be weird.
Yeah, they're holding back on
I mean, there has to be some reason, but, oh, that.
187.
That's why it wasn't exact.
Okay,
189.
The 187 is just possession of fire.
189. Okay, that explains it. Okay, well then I guess my instruction will say as to count 63 and alleged overt act 189. Okay. Where'd my instruction go? Okay, thank you. Okay, which actually then has to change my instruction as to the rest of them too. In order to be correct, my instruction would be his prior criminal history shouldn't be considered in connection with any of the other defendants except to the extent the jury finds it relevant to overt act 189, which y'all may not want said at all. You may want me to just not say anything at all about it. So what's the defense preference, everybody other than Mr. Kendrick? You know what I'm asking? Yes. So I was going to say that his prior criminal history shouldn't be considered in connection with any of the other defendants or any of the charges against them, but that's not actually true if it's an overt act. And so do you want me to just not say anything at all about the other defendants, or say it shouldn't be considered against any of them except to the extent it might be relevant to their determination of overt act 189?
But Your Honor, I thought we discussed this. The overt act is coming in as an admission by Mr. Kendrick, which violates our confrontation clause, right? That's the instruction the state was supposed to give to you when they were talking about the same thing,
Right,
overt
the
act.
conviction itself.
Right.
In that.
So that would insulate us, not Mr. Kendrick, of that overt act. And that's the instruction I tried to do. I cannot formulate it. And you asked the state to do it. It goes
Yeah,
to Mr.
I mean, I'd
Ryan.
love for both of you to at least come up with your best effort on it. So
So it does not apply to Mr. Matthews, Miss
any of the rest
Williams,
of them,
right.
basically. But so
That's the instruction you've been waiting on.
I know. But I think, yeah.
If I may just continue speaking, that's why I believe that Mr. Ryan's jury verdict, Mr. Kendrick's conviction, Mr. Stillwell's conviction, there might be one more, the guilty pleas, Mr. Winfrey, but I've discussed that, should all be kept out of this trial. Because somebody like me, Mr. Williams is not a convicted felon. He can't cross any of these people unless they testify. And I don't believe that a limiting instruction will be fashioned. That's my belief.
And y'all are planning to prove those as to the defendant who's convicted with their convictions, but are you doing anything beyond that?
No, Your Honor, and I think that was what Ms. Love was working on as far as crafting instruction, that it only goes against the defendant whose conviction, it only goes against that defendant, not the other.
Even as an overt act, even in consideration of RICO.
And I think that is where, as I say, we've been trying to word it, and Mr. Steele and I have had brief conversation figuring out the best wording.
But do you agree that they can't consider, even if they find that overt act with regard to Mr. Kendrick or Mr. Stillwell, it normally would be that, you don't, if you find that any of the co-conspirators committed an overt act, which then they would have found that as to these people, if they believe the conviction, then all you need to find with regard to the rest of the co-conspirators is the rest of what's required for the RICO violation, not a separate overt act. You know what I'm saying? And so how is it not in some way considered, it's not necessarily considered against them, but it checks a box that has to be checked with regard to each defendant that somebody committed an overt act. Okay, here's somebody who committed an overt act. And so it checks that box for what's required for RICO.
Can I ask, Your Honor, for this purpose for right now, can we do the curative instruction that they disregard what he said?
Yeah, but I mean, what do I say? Disregard it with regard to any of these other defendants or any of the charges against them? And then y'all just are going to have to prove something else or what? Because I don't want to give them the wrong instruction. I mean, and it may be that it does have to be some other overt act with regard. I don't see how it can't, how you get around confrontation clause. You know?
Yes, Your Honor. I guess my thought is if you're striking, for purposes of today, if you're striking his entire testimony, then everything he has said is.
I know, but I'm trying to tell the jurors, Mr. Kendrick's criminal history is not relevant except with regard to count 63 and overt act is it 189?
Yes, Your Honor.
But really, I mean, is that?
Can we?
Or you can just strike overt act 189 out of the indictment. That would be easier.
And that was our position, because there's no way, respectfully, that a highly intelligent juror like we have is going to be able to follow this gymnastic.
And I guess our thought is, since you're striking his entire testimony now, can we deal with the felony portion of the instruction later?
I mean, I'd love to, except for the fact that now's the time to do it. I'm taking their notes away and I'm saying to them, what you heard about him having just gotten out of prison, you need to disregard except for some very limited reasons.
But since we have not put his conviction in, if you just tell him disregard everything at this point, there's no evidence before them about him being in prison right now. So my point is, if you just tell them disregard everything that they heard, there is no other evidence for them to consider right now.
So then I would say his prior criminal history has no relevance to this case. And yes, it will ultimately have relevance to count 63. And I know we don't have what the conviction is or why he was in prison yet, and they're being told to disregard it anyway. But I mean, if y'all can come up with some better wording, great.
What is?
I mean, I can just say this witness, as a former law enforcement officer, should have known better than to make any mention of Mr. Kendrick having been in prison, but.
No, I don't think that part is necessary, Your Honor. Given that I do think it was a mistake. Can you read your instruction again?
Yeah.
Thank you.
Defendant Kendrick's prior criminal history has no relevance to this case except as to count 63 and overt act 189 and should not have been mentioned by this witness. Further, this witness, as a former law enforcement officer, should have known better than to make any mention of it. Likewise, Mr. Kendrick's prior criminal history should not be considered in connection with any of these other defendants or any of the charges against them in this case. I'm going to strike the testimony of the witness today, disregard the testimony exhibits, I'll collect your notes, blah, blah, blah. I mean, I guess that can just do for now, and we can get into the nitty gritty of it with regard to Rico later. I just think if we can't come up with something better in the next couple of minutes. That's what I'm going to go with. All right, anything?
Your Honor, I think the limiting instruction should be similar.
I'm sorry.
You're okay. My apologies. Your Honor, let's see. Can you hear me now?
I can hear you anyway. Can y'all hear him? Okay.
So the state's recommendation would be the similar limiting instruction that you've been giving as it relates to the other evidence or that you've given previously as it relates to the other evidence, for example, that came in today during the prior testimony about Mr. Jackson. Pretty much the same instruction with obviously you're changing the fact that there will be certain, there'll be evidence related to certain defendants that they were have prior convictions. You're not to attribute those convictions to any other defendant other than the ones in which it's related to in the counts of the indictment. Something of that nature.
Okay. All right. So our issue that we're struggling with is that it's an overt act in the RICO count. And it's apparently going to be proven ultimately by his conviction, which is, of course, testimonial. And how can that be considered against any other defendant? And that hadn't been sorted out yet. I'm just going to say should not be considered in connection with any of these other defendants in this case. All right, that's what I'm going to say. So let's get the jury out. Yes. Do you need to approach if I don't have the jury here yet? All right, ladies and gentlemen. Gone. I am sorry for the delay. I need to give y'all an instruction. Defendant Kendrick's prior criminal history has no relevance to this case except as to count 63 and overt act 189, and it should not have been mentioned by retired investigator Dennis. And further, investigator Dennis, as a former law enforcement officer, should have known better than to make any mention of it. Likewise, Mr. Kendrick's prior criminal history should not be considered in connection with any of the other defendants in this case. I'm going to strike the testimony of investigator Dennis that was given today. You're to disregard today's testimony and the exhibits admitted through investigator Dennis today in their entirety. We'll collect your notes from today and shred them. And if there's anybody that is not going to be able to follow those instructions, please let the court know that now by raising your hand. Everybody good? Okay. Yes. And he's all we've heard today so far. Anyway, we're going to hear some further testimony from other witnesses. So just, I know if some of y'all are trying to conserve paper, so we'll do the same thing we did before if anybody's written on both sides, but otherwise, is that what your question was going to be? Okay. All right. So just flip to a new page now, and we've got a couple more hours and we'll just collect them at the end of the day. All right. Okay. Call your next witness.
During the course of the interview, did he talk about? Is that a copy of that video that you pulled as a part of your investigation?
Yes.
You know, this time say like a tender and admit and publish this with the 543Y.
All right. I'm sorry, 543Y. That's admitted. You may.
Just orient the jury where they need to be looking to see the fight on in the video.
In this first video, you're gonna see an individual walk right to here. Mr. Arnold is right there, and the video will pretty much do it.
Y Yankee 1 for the record. Now publishing 543 Yankee 2.
It's gonna be the same, but just a different angle. This is gonna fight, it's gonna begin, and then this is where it's gonna spill over into.
Are they still fighting?
They are still fighting.
Okay. One minute and 28 seconds. Now, when you spoke with Mr. Kendrick about this incident, was he read his, you said he was arrested, correct?
Correct.
Okay. Was he read his Miranda warnings?
Yes.
When you met with Mr. Kendrick, who all was in the room with you when you met with Mr. Kendrick?
Detective Thorpe, Sergeant Gaither, and myself.
All right. And when you went to go speak with him, did he agree to speak with you all?
Yes.
Okay. Did he appear to have any learning disability?
No.
Did he appear to be intoxicated or otherwise incapacitated?
No.
Did he appear to be sick?
No.
Where did you all interview Mr. Kendrick?
Atlanta Police Headquarters.
Court's indulgence.
Yes.
Yeah. If this line of questioning is going to continue, can we have that same limiting instruction that you gave yesterday?
Yes. And in fact, let's go ahead and take our morning break.
All right,
Now, in September of 2015, as a part of your investigation, did you investigate any shootings in which Mr. Shannon Stillwell was the victim of the shooting?
Yes.
How many such shootings was a part of your kind of investigation?
2.
When, do you recall when in September both of those took place?
The first was September 13th from I don't know the actual address. I just know it as the Green Store.
Okay. And then when was the second?
The Tierra Jones murder investigation.
And did the Green Store shooting happen before the Tierra Jones homicide?
Yes.
And was there anyone ever apprehended for the Green Store shooting?
No.
Okay. What about for Tierra Jones?
Yes.
All right. Initially, do you know who arrest warrants were taken out?
Yes.
Taken out. Who?
Kelvin Watts, Bobby Hardy, and Jamal Ward.
And later on, do you know if there were specific people, was there anyone not charged out of those 3?
Say that again?
Out of the initial 3, Dominique Carter, Bobby Hardy,
No.
Bobby Hardy, Jamal Ward, and Kelvin Watts, were any of them not actually indicted for that offense?
Kelvin Watts was not indicted, and then Dominique Carter was charged.
Okay. And does Dominique Carter have a nickname?
Stewie.
What about Bobby Hardy?
Smoke.
And what about Jamal?
Merle.
And are any of them affiliated with a gang?
All of them are associated with IF gang.
No, Your Honor.
All right. Ladies and gentlemen, as you heard yesterday, and maybe prior to that as well, sometimes evidence is admitted against some parties and not others, or for some counts and not others. And when this happens, the evidence can be considered by you, the jury, only as to the party against whom it's offered and only for the count for which it's offered, and not against any other defendant or for any other count or purpose. In the next part of the testimony of this witness, you're going to hear about a statement made by defendant Diamante Kendrick. You may consider that statement only against Mr. Kendrick and only as to count 1. You may not consider this statement as to any other count, and you may not consider it in any way at all in determining the guilt or innocence of any other defendant in this case besides Mr. Kendrick.
Thank you, Your Honor. When you met with Mr. Kendrick, was he read his Miranda warnings?
Yes, ma'am.
I think where I left off is you said that you had, the interview was at the Atlanta Police Headquarters?
Yes.
Sitting here today, do you remember about what time of day you spoke with Mr. Kendrick?
Middle of the day, I guess.
Speak up. You said,
Middle of the day, I guess. I'm not sure.
were there portions of the interview where you took breaks?
Yes.
Right. You said you read his, did you read the Miranda warnings or did another investigator read it in the room?
I'm not sure.
Did you all read it from a card or did you have a sheet of paper that you read it
We
from?
usually give them a sheet and allow them to read it. We ask them their highest level of education, have them initial it and sign it.
Did he ever ask you to repeat anything when you were going over his rights?
Not that I recall.
Did you ever threaten Mr. Kendrick to get him to speak with you?
No.
Did you ever promise him anything to get him to speak with you?
No.
Did you tell him about the charges for which he was charged with on that day?
I believe Detective Thorpe did.
At any point, did he waive, well, initially when you spoke to him, did he waive his rights?
No.
Objection, Your Honor. It's commenting on my client's right to maintain his silence.
Sustained.
We were trying to establish the voluntariness of
come up to the bench.
Okay. After reading it, he understood his rights. He agreed to speak with you.
Yes.
Okay. All right.
And let me just given that clarification, it sounds like it was just a misunderstanding, but let me just let the jury know that every defendant, every accused, everybody who ever is a suspect in a crime has a right to remain silent, doesn't have to talk to the police. And if they choose to remain silent, it is wildly inappropriate to comment on that. However, this was just a misunderstanding, so we're not going to worry about that. All right, go ahead.
When you spoke with Mr. Kendrick, did you speak with him about a fight that occurred at Club Crucial?
Yes.
And specifically, did you speak with him about a fight that happened at Club Crucial after Kenneth Copeland was beat up at Club Crucial?
Yes.
And was that fight somewhere around January 6th of 2015?
Yes.
And specifically, did he talk about his involvement in fighting an individual by the name of Bloody J?
Yes.
What did he tell you about his involvement in fighting Bloody J?
That when they got outside, he was the one that punched Bloody J.
And again, this is all after Kenneth Copeland was beat up inside of the club.
Correct.
During the course of your speaking with Mr. Kendrick, did he talk to you about any conflict or tension he had with an individual by the name of Rich Homie Quan?
Yes.
What did he tell you about the tension or conflict that he had with Rich Homie Quan?
He spoke about he had went to a club. I don't remember the exact date. And when he walked in, he saw Rich Homie Quan, and Rich Homie Quan, cousin or something. No one said nothing to him when he walked in. And then once he got to a certain area, he spoke of how Rich Homie Quan began pointing at him. And his cousin or something had pulled him to the side and basically said, don't do that yet. Don't do that. And he basically explained that he was just there, but he could see how everyone was kind of positioning himself. And initially he wanted to leave, but he didn't want to look like he was basically scared or something. So he stayed. But it was basically tension in there.
Was this before or after January 10th, 2015?
This was after.
The incident that he was telling you about was after?
Yes.
When you spoke with Mr. Kendrick, did he acknowledge a beef between YSL and If Gang?
Yes.
Did he ever speak with you about his desire or wanting to be a member of the Bloods?
Yes.
In speaking with Mr. Kendrick, did he ever appear to be confused about his understanding what a gang was?
No.
During the course of the interview, did he talk about gang banging or being a part of a gang?
Yes.
All right, we had a little bit of movement, y'all. We had a little bit of movement. I thought maybe we were coming back, but we still don't have anything. A little late, so they have just two hours roughly before they have to get going with the Monk Tonk. Y'all, can you believe it's like a Saturday tomorrow? It's weekend, and you're here Friday afternoon. It's like you almost made it to the weekend, and you got to trudge into the Fulton County Superior Courthouse to fight for your freedom. You almost made it to the weekend. Ocean Beach. I watch other channels as well. Nothing wrong with watching other channels. We should watch other channels. I watch Cat, Not Williams. I like AV. Lead attorney's excellent. And thank you for watching that.
This is stuck, so I can't do it. Oh, there's this.
Y'all, the sound in court has gone off. So people know.
Thank you, Your Honor. Good afternoon, Mr. Sprinkle.
Good afternoon.
I think we were at a point where you were about to testify, I believe, obviously, tell me I'm wrong, that at 7:59 p.m., according to the phone records, Aisha Williams' associated phone, who may be Mr. Garlington's phone, handset that he had, connected to Mr. McMullen or Nard. And just if I'm wrong, I didn't mean to be wrong, just correct it.
Yes. So I see that actually there's a call at 7:53 p.m.
And just to make sure we're oriented, this is all Eastern Standard Time, and we're talking about January 10th, 2015.
Yes,
All right.
Eastern Standard Time, January 10, 2015. So I see a call from the handset associated with Demise McMullen to the handset associated with a subscriber named Naisha Williams at 7:53 p.m. I then see that at 7:59 p.m., and I believe that's where we left off, that the handset associated with Naisha Williams calls the handset associated with Demise McMullen. And again, that's at 7:59. And then I don't see another call between those two handsets, at least of the variant that would appear in phone records, until 11:01, when Naisha Williams, or when looks like the handset associated with Demise McMullen calls Naisha Williams, the handset.
Now, from your view, the reason we even got Naisha Williams is because Kenneth Copeland gave a statement on June 10, 2015, articulating that he made calls at a certain time to the handset of Mr. Garlington. And you deducted potentially that would coincide with Naisha Williams' handset.
Yes, I thought that was a possibility. But like I said before, he also said that he called Mr. Garlington on FaceTime. Now, he didn't specify if all the calls were FaceTime calls. Some were voice calls that would show up on cell phone records. But apparently there were multiple ways that, according to Mr. Copeland anyway, that he would have contacted Mr. Garlington. So I surmised that based on the time of the calls, that perhaps this 404-621-0102 number that was subscribed to by somebody named Naisha Williams may have been Garlington. But again, I don't know.
I understand. And I appreciate you telling and educating the jurors. Now, Mr. Copeland said around the 8 o'clock time, so 7:53, 7:59, I'm including that time, that he was in a car with Mr. Garlington and Mr. McMullen, also known as Nard.
So I don't recall Mr. Copeland pinpointing the exact times that any of these things happened. We may just have to deduce it based on everything else in the case. So to be exact, I don't know that he ever said, I was in a car with these people at this exact time.
Let me do it a little differently then. From the McDonald's going to the Sky House, he had traveling with him Mr. Garlington and Mr. Demise McMullen, also known as Nard.
Yes.
According to Mr. Copeland.
Mm-hmm.
Okay. But you have the handsets of Naisha Williams and the handset of Demise McMullen, also known as Nard, contacting one another around the times that this Mr. Copeland's car would be traveling from the McDonald's to the Sky House, if he's true.
That is correct.
All right. Do you know of a reason that people would call one handset to another handset in the same car?
Objection, calls for speculation.
Sustained.
All right. Let's go to Mr. Copeland's claim on June 10, 2015, that he traveled with his phone that we have, that he says he had with him, from the McDonald's to Jeffrey Williams Sky House condominium on January 10, 2015, approximately. I'm using the 8 o'clock time. I understand 7:53, whatever, but around that time. Do you have any phone records to show on Mr. Copeland's phone that he says he had with him that he was ever using a tower near the Sky House of Jeffrey Williams after leaving the cell tower of the McDonald's on the evening of January 10, 2015?
From what I remember, he did use a tower near the Sky House at 11:14 p.m. that evening. But that's what I recall. I mean, obviously the records are in evidence, but yeah, 11:14, short answer.
Okay. But according to Mr. Copeland, he's leaving the McDonald's and driving to the Jeffrey Williams condominium located at the Sky House on the exact date and time that we're talking about, and he went directly there.
I don't know. That's what I recall. I did say, I don't know if he said we went directly there, or if he just omitted that they made pit stops along the way. But my recollection was that, the short answer to your question is, I don't know if he said they went directly there or not, or if that's what he meant to say. But yes, the phone didn't travel from the McDonald's directly to the Sky House.
Okay. And Mr. Copeland also told law enforcement on June 10, 2015, that from the McDonald's at the appropriate time that we're talking about and date we're talking about, on the way to the Sky House, he followed the vehicle that contained Jeffrey Williams and Mr. Kelvin Treadwell and others. Do you remember that?
I do.
All right. And Kevin Treadwell's nickname would be OG Bentley. Is that fair to say?
Yes, that's right.
All right. Understanding Mr. Kelvin Treadwell's phone records, does Mr. Treadwell's phone records indicate that he is at or near a tower by Jeffrey Williams Sky House condominium on June 10, 2015, after being down by the McDonald's area?
Do you mean January 10th, 2015?
What did I say?
June 10th.
No. I'm sorry. Yes, you are correct.
Okay, I do not. I'm referring to my report to refresh my recollection, but I don't recall seeing that Mr. Treadwell's handset pinged off a tower near the Sky House condominiums.
All right. Do you have any, if you're looking to, I'll wait for you, I apologize.
All right. Yeah, I'm done.
You stand by your answer?
I stand by my answer.
Okay. Do you have any physical evidence, eyewitness, surveillance video that Mr. Treadwell, Kelvin Treadwell, actually had the killing weapon or the other weapons that were used at the time of the shooting of Donovan Thomas and the other two people, as stated by Mr. Kenneth Copeland on June 10, 2015?
That's speculation, elements, how the witness would know, phone records would put guns anywhere.
Objection, Your Honor, to the speaking.
Okay, well, he's making a whole lot of objections. So overruled as to relevance, and he's not limited to the phone records. So overruled on that. And what was the other one?
Background evidence,
Sustained.
There's been 10, okay. Do you remember Mr. Copeland stating that Mr. Treadwell had, or OG Bentley, also known as OG Bentley, had guns that were used in the shooting of Donovan Thomas and the other two people in his car given to him and around the McDonald's 2010 that we're talking about?
Yes, he said that.
Do you have any physical evidence, surveillance evidence, anything to corroborate that those guns were actually in that car at any time or given to Mr. Treadwell?
No.
All right. Now, I want to ask you to educate the jurors if you are aware of what a geofence is. If you're not aware, just say, I have no idea.
Yeah, I'm aware of what a geofence is. I'm aware of what a geofence, if we're talking about the variant that Google produces, yes.
If you can you explain to the jurors what is a geofence and how it works and how you use it in your everyday or whenever it's needed in your duties as a district attorney working with law enforcement?
Okay, so basically, Google has compiled over the years the general locations of Wi-Fi signals. And there's a variety of means that they've done this, but it suffices to say that Google has a database that has a set of points that define roughly, or maybe exactly, the boundaries of Wi-Fi signals, maybe cell phone. I mean, this is, I don't work for Google, but this is what I've come to understand. And that based on this, Google, if you have an Android device in particular, with location services turned on, Google can approximate your location because while you may not be connected to a certain Wi-Fi network, your phone can nevertheless see the Wi-Fi network. So if your phone can see a Wi-Fi network, and Google, because like I said, they know where the Wi-Fi networks are generally, then Google has a pretty good idea where your phone might be at a certain time.
In this case, if you know, was a Google fence analysis and search warrant taken out for the phone, targeting the phone of Jeffrey Williams that he had on him on the 10th day of January 2015?
No, no, there was no geofence warrant done for Mr. Williams' phone that I know of.
Let me ask you just to refresh your memory, if it does, refresh your memory.
I know there was a geofence warrant done, but a warrant specific to Mr. Williams' phone, I don't recall that. But if you have something to refresh my memory, maybe that will help.
What number do you have for Jeffrey Williams' cell phone, January 10, 2015, if you don't mind?
Well, there's one that ends in 3904 and one that ends in 9596.
Let me show you, just for purposes of seeing if this refreshes your memory. If it doesn't, tell me. Your Honor, may I approach?
You may.
I'm showing you a document. Do not, may I approach you?
Yes.
Just do me a favor, peek at it. Just tell me if you've seen it before and if you were involved in it and if it refreshes your memory. And if it doesn't, tell me that as well. And on the second page, second to last paragraph, you should see that phone number you just articulated.
I have not seen this. I was aware that I know who this investigator is. I was vaguely aware he was working on things like this, but this was not a search warrant that I drafted.
All right. You weren't involved in that part of this investigation?
I recall looking at a warrant that he did for a geofence, but that's not what this is. I know. I don't know. I see what maybe he was trying to do, but I don't recall ever seeing that warrant.
Your Honor, may I retrieve the document?
You may.
I will not ask you about this then, okay?
Okay.
All right. Let me ask you this. Are you aware, in your involvement in this case, whether you, your office, your prosecution team, the whole group, ever tracked the cell phone associated with Kelvin Watts, also known as, do you remember his?
I do remember. I know who Kelvin was.
Shell, same person?
Yeah, I know who he is. Yes.
Okay. Tracking his cell phone historic data related to these shootings in 2015.
Well, for Mr. Watts, the one case that I recall was a shooting of a fatal shooting of a young lady named Tiara Jones. We did have phone tower logs, and that would have been September 2015, but that's the only case I remember.
Did you or your coworkers, the prosecution team, ever analyze the cell phone historic data records for Kenneth Copeland's phone from these shootings in 2014 through 2015?
Well, apart from what we're talking about right here, January 10th, 2015, I don't recall now.
All right. Do you remember on phone records, getting phone records or viewing phone records of a young lady named Alexis Greer, also known either as Max, also known as Dolly? Do you know who I'm talking about?
I do.
All right. And through your investigation, your belief, if you don't know, just say Jeffrey Williams' sister,
Yes.
older sister?
That was my understanding, yes.
All right. Do you remember that at 12:04 a.m. on the 11th day of January 2015, the handset or cell phone associated with Alexis Greer, Max, Dolly Greer, same person, called 911?
I don't recall that. If I ordered her phone records, if it's in there, I'm sure it's true, but I don't remember that specific 911 call. I don't remember that.
All right. Well, let me ask you a different question then. Did you ever get, or the prosecution teams, I'm including everybody, did you, to your knowledge, ever obtain the actual 911 call from a handset associated with Alexis Greer, the actual words?
No, I don't recall anything about this 911 call, so I can't imagine that we obtained it unless this has completely slipped my mind. But no, I don't remember that.
Let me just show you something, see if it refreshes your memory. If it doesn't, just say it does not help, okay?
Okay.
Your Honor, may I approach
You
this for a
may.
minute? It's going to be behind you, Mrs. Springer. I'm going to walk right behind you, okay? Your Honor, may I just already use as a demonstrative? May I publish?
You may.
For one moment. Mr. Sprinkle, I'm just going to hold this up if that's okay with you. Okay. And if I block you or anything, just let me know. Do you see on here, can you read that exhibit number on the bottom for me? It's exhibit 533YF. Show that to the jury's lady, Your Honor. And I am looking on here specifically at the fourth line there. Do you see that 911 says 104 seconds?
I do. I see that.
And do you see the 1990?
I do.
Do you know if that corresponds to Dolly Greer? I can help you with that too.
Yeah, I might need my memory refreshed. I don't recall.
It's right here. I'm just going to pull this back. On this one. Okay, I see it there. Can you just do me a favor, since I'm showing it to you, can you read the exhibit number?
It is 533Y, it's like A,
Okay, and who's the 1990 number associated with?
Dolly Greer.
All right. My question then, does this in any way help you to remember whether you, let me go, I don't want to yell at you. Does that help you with whether you or your coworkers ever had possession of that 911 call? The actual, I'm talking about, this is 911 and here's a recording.
Right, I don't recall that.
How long are 911 calls kept by APD?
If
If you know.
1 year is what I've always, unless that retention period has changed, 1 year is what I've always known them to keep them.
Okay. I want to ask you, you were asked by the Honorable Mr. Body a couple of questions about listening to or being present at, actually, interviews of Mr. Zachary, also known as Little D.
That's correct.
All right. And there's two Little Ds. Earlier, I was saying Mr. Garlington, he's also Little D. Fair to say?
That's correct.
All right. I'm now talking about Mr. Zachary,
Yes.
also known as another Little D. All right. You were present at the April 13, 2017 recorded interview with Mr. Zachary. Fair to say?
Yes, I was there.
And you were there with other law enforcement, including Detective Thorpe, Detective Dennis, Detective Gaither. I believe if I'm leaving someone out, I'm not trying to.
Yes, that's correct.
You were not present for the August 5, 2015 interview with Mr. Zachary, but you've referenced it today with Mr. Body and you've reviewed that. Fair to say?
That's right.
That's also audio video. Fair?
That's correct.
In the August 5th, 2015 interview that you recorded, that you reviewed, that was recorded that you reviewed, did Mr. Zachary make it clear that Mr. Williams did not know about the killing of Donovan Thomas till afterwards?
From what I remember, yes, he did talk. Yes, the short answer to your question is yes.
In the April 13, 2017 interview with Mr. Zachary, did he say something similar?
I don't recall how much detail we went into him on that, but yes, from what I remember, he said the same thing. He at no point implicated Mr. Williams.
I'm going to ask you the same exact question, the same dates. We'll take them one at a time if it's okay with you. Start with the August 5, 2015 recording that you reviewed first. The tour bus shooting of a gentleman, phenomenal artist, Dwayne Carter, also known as Lil Wayne. You know who I'm talking about?
I do.
All right, that's April 26, 2015 date, the shooting of the tour bus?
Oh, yes, yeah, April 2015. Yes, that's correct.
Okay. And is it fair to say that Mr. Zachary, at the August 5th, 2015 interview, you were not present for it, but you reviewed, said that Mr. Williams had no involvement in that whatsoever, and Lil Wayne, Jeffrey Williams idolizes Lil Wayne?
I don't remember, since I wasn't working on that case, but so I don't remember exactly what he said, but I do remember him mentioning it, and he did not mention that Mr. Williams was involved.
Same question for you, August or April 13, 2017. If it came up, tell the ladies and gentlemen, jury, Mr. Zachary again stated Mr. Williams was not involved in the shooting bus of that tour bus.
That I don't recall it coming up during that interview.
Okay. Let me ask you this. Do you remember Mr. Zachary stating that Mr. Copeland was responsible for shooting TIG? Do you know what TIG Studios is? You know what I'm talking about?
Metropolitan Parkway?
Yeah, 675?
Mm-hmm.
Okay. Do you remember Mr. Zachary explaining that Mr. Copeland fired bullets into that establishment?
Objection, Your Honor, that's not.
Okay, I need you to speak up a little bit.
Objection, facts not evidence.
It's in the recording that was played for the jury, that was reviewed by Mr. Sprinkle, and Mr. Abadi asked Mr. Sprinkle about that same interview.
It's not my recollection of how.
Sustained.
Do you recall Mr. Zachary stating that Mr. Copeland and Tay, do you know who Tay is? Tay, T-A-Y. I'm spelling T-A-Y.
Which Tay?
Threat.
No, I don't recall this.
You don't remember?
I do not remember this.
Do you remember Mr. Zachary stating that Mr. Copeland and another person were responsible for shooting Rich Homie Kwan's father at the barbershop? Different barbershop, not the January 10th, 2015.
No, I don't remember that.
Okay. All right, let's talk about all the work that you talked about here and your studies, and I'm not mentioning everything, but your interviews, reviewing interviews, cell phone plotting, videos, all your work, okay? Then in some point, do you remember the date in 2018 you interviewed Mr. Kelvin Treadwell, O.J. Bentley? Do you remember that?
Which day was this again?
2018.
Oh, right. Yes, I do remember that. Yes, that was another matter, but yeah, I do remember it.
And do you remember stating that you can't understand why people think that Thug, I call him Jeffrey, had something to do with the killing of Nut, I call him Mr. Thomas? That doesn't make sense? That's a thing that always confused me about this case, because all these rumors started immediately that Young Thug had something to do with it. But yeah, then Young Thug put a picture of him on Instagram, Mr. Thomas. So I'm looking at these people saying, oh, you and Little Woody had something to do with it. The more investigated the case, the more I've investigated the case, I just don't, near as I could tell, Young Thug and Birdman were friends with Mr. Thomas or Nut. So I don't know why people say that he was involved.
Well, I recorded the interview, so I'm assuming that's a verbatim quote. I don't have everything I said during that interview memorized, but I'm assuming that, like I said, since you're reading from a transcript, that yeah, I said that.
Okay. All right. The jurors may not, they're getting insight now into how jail phones work, jail recordings work, things like that. But I'd like you to explain to him, if you know, people who visit people at the jail, 2015, okay? If you know, can you yourself, you're a lawyer, can you actually physically go into the jail, you know, with permission, everything's lawful, it's ethical, I'm not suggesting anything, and actually get up on a floor and meet with someone who, God forbids, in custody? Have you done that before?
At the Fulton County Jail?
Fulton County Jail, thank you.
No, I've never done it. Now, I don't have clients, I'm not a defense attorney, but I can tell you as a prosecutor, I've met with people at the jail, but it's never been in the pods. It's in the library.
Sure. Mm-hmm. That's what I'm saying. Just get access to the jail and meet with a human being who's, God forbid, incarcerated. You've done that before?
I've done that before.
Do you know whether the jail in 2015 now had surveillance for people walking in and out of the jail? I'm talking about the common area, walking in and out of jail, if you know.
I do not know, because I've never, or I don't recall ever seeing footage, not on this matter or any other matter, from that area. It would seem logical that they would, but I can't say that I have personal knowledge that they did.
How about when a person, we could use you, so your personal knowledge, in 2015, if this happened to you, going into the Fulton County Jail to see somebody, in custody, have to sign in any paperwork, show your ID?
Yes, that you have to do.
All right. And to your knowledge, is that saved by law enforcement? The jail?
From what I remember, it was the sort of paper that it would create it was like a carbon paper, the kind of paper that it would make a copy of it when you write on it. So they'd give you a copy, and then they retain the copy with the impression left from the original. Now, as to what their record-keeping practices are at the Fulton County Sheriff's Office, that I don't know. All I know is they had it set up so they would keep a copy. I can say that, but I don't know what the record retention was after that.
And for people who may not know, who's in charge of, who is constitutionally in charge of running the Fulton County Jail?
I'm going to object to relevance at this point.
Sustained.
All right. Your Honor, may I have just a moment?
Sure.
Do you know whether the sheriff officials ever log? Do you know what Odyssey is?
I do.
Just tell the jurors what Odyssey is.
It's a database. It's just a piece of software made by a company called Tyler Technologies. I believe they're out of Texas. And it's used here by the staff in the Fulton County Justice System, staff at the DA's office, the courts, and the jail. And it's basically just all of the data. All the cases in the system are maintained in this Odyssey database. The DA's office keeps their records, part of their records anyway, in the Odyssey database, and the jail keeps their records in this database.
Does the jail on Odyssey, you can access that?
I'm going to object to relevance again.
Sustained, as far as I can tell.
Okay. People visiting people in the jail, is that also on Odyssey?
Yeah.
I'm going to object to relevance.
It'll come up with the witness in the future.
All right, I'll give you some latitude.
So yes, there is in the what's called the jail module. When you click on a bookend number, there will be a tab called contacts, and I've seen entries made. Now, reason why I'm going to hesitate a little bit here is, and I can't remember exactly when, but I from what I remember, there have been times when I knew a visit was made and it didn't get logged. Because everything in Odyssey has to be entered by a human. Well, maybe not everything, but something like contacts would have to be entered by a human. So the data is only as good as the people are tasked with entering it. So yes, I can tell you this. There is in the jail module that the sheriff's office maintains, there is an area for them to enter data regarding the date and time of a contact and who came to contact that person. But I don't know that every single contact they're diligent about logging every single one, or if there are variants of contacts that they don't log, you'd have to ask somebody from the sheriff's office about that.
Mr. Sprinkle, as always, thank you so much. Your Honor, I don't have any other questions. Thank you.
All right, are there other defense counsel with questions for this witness? Is there redirect? Oh, you do. I'm sorry. Go ahead.
Thank
The ADA, Michael Sprinkle. Good afternoon, sir.
Good afternoon. How are you?
I'm doing well, thank you. I have a few questions for you. When you testified some days and weeks ago, you were giving the jury some background in terms of how long you've been with the district attorney's office, right?
Yes.
And you talked about some of the various roles that you've had in the district attorney's office. You've been in the complaint room, right?
That's right.
And in recent years, I think you said from the last several years, you've had a dual role as both the prosecutor and an investigator, right?
Well, so I haven't been given the title of investigator. You know, I'm not post-certified, so calling me an investigator is more of I guess you can call me that informally, just because because of what I'm tasked with doing for the DA's office. I necessarily am investigating things, but I'm not, as far as my employment is concerned, I'm not on paper an investigator. I'm just a prosecutor, an attorney.
Understood. So you're a prosecutor, but some of your tasks in the prosecutor's office involves some investigations.
That's right.
Fair enough. Okay. Now, you testified in days and weeks ago that sometimes a detective, a law enforcement officer, when they make an initial arrest, sometimes they'll hand a file over to the prosecutor's office, to the district attorney's office, and you testified that sometimes after they make an arrest, they feel their work is complete. You remember saying that?
I remember saying that, yes.
Okay. In other words, the detective believes that after they make the arrest, based on your statement, that their file is done, they've gotten an arrest, and they'll hand it over to you guys.
I've definitely seen that, yes.
Okay. And when your office gets it, it sounds like either an investigator who's, who has that official term investigator, or someone like yourself, a prosecutor who informally has the role of investigations, will pick up the file, blow it off, and continue some investigations in the particular file. Is that fair?
That's fair.
Okay. Now, some of the things that you would expect to see when you get a file from the police department, from law enforcement, you would expect to see police statements from witnesses, right?
Yes.
A lot of times you might want to see video surveillance if it's there, if it's available, right?
That's right.
Sometimes text messages, phone records, things of that nature.
That's right.
When it's not there, you'll then.
I'm going to interrupt. I'm the objector to ask and answer.
Sustained.
So when those items are not there, you get the file, or someone in your stead will get the file and continue the work of investigations. Now, in this particular case, I want to talk to you about a specific time frame around April 26 or so, 2019. An alleged armed robbery that is supposed to have occurred at 741 Morosco Drive Northeast, 12:39 a.m. in the morning. Do you know anything about a case involving an armed robbery of supposedly involving Mr. Marquavius Huey concerning that particular time frame?
I don't have that exact date and time memorized. I'm familiar with Mr. Huey. That address sounds familiar, but I don't remember the facts of the case.
Okay. So that being said, without having that memory, so you don't recall you specifically doing any investigations concerning requesting any potential video surveillance of any VIC cameras in that area of 741 Morosco Drive?
No, I'm afraid I don't, unless you have something to refresh my memory. I don't.
I'm not saying you do, or it's not a trick question.
Yeah, no, I don't.
You were involved. I'm asking you if you were. Okay.
Yeah, no, I don't have any memory of that.
Okay. Are you familiar with Google image search capacity?
Yes, when you upload an image into Google and it tries to find like images.
Yes. To your knowledge, well, you didn't take any actions or do any actions on the alleged armed robbery from April 26, 2019. I think you've already indicated that. Is that correct?
Well, I don't want to say I didn't. I just can't. I just don't remember. Some of those dates and the locations sound familiar, but I also have dealt with hundreds of cases, so I could be getting cases mixed up. If just a date and time and address isn't enough to go on. So I just don't remember.
Okay. And so as we sit here today, you can't tell the jury that you specifically, you yourself, were involved with any investigation, to your knowledge, for an April 26, 2019 alleged armed robbery at 741 Morosco Drive. Is that fair?
Sustained.
Okay. Nothing further. Thank you.
All right. Anybody else? Redirect.
Mr. Sprinkle, back in 2019, were you assigned to the major case division that handles homicides and particular homicides only? Back in 2019, around the date in which Mr. Matthews just asked you about, were you assigned specifically to the major case division that handled homicides and vehicular homicides, or cases involving death?
Yes.
Okay. And in your time working in the capacity that you've described to us now on 1, 2, 3 occasions, have you had cases with phone records and no video surveillance?
Yes.
And Mr. Steele asked you a number of questions concerning video surveillance and the McDonald's. Do you remember all those questions?
Yes.
Do you have any idea if the video cameras at that McDonald's were even operable back in January of 2015?
I don't know.
And Mr. Steele asked you on cross about what Mr. Zachary and Mr. Copeland had indicated about who did or didn't kill Donovan Thomas. Do you remember him asking about that?
Yes.
Can you tell the jurors who did Mr. Zachary and Mr. Copeland both say were involved in the killing of Donovan Thomas? Do you recall?
Yes.
Can you tell the jury?
Diamante Kendrick, Shannon Stillwell, Demise McMullen, and Justin Cobb.
Your Honor, I have no further questions.
All right, any recross?
Not on behalf of this board.
Anybody? All right, thank you, Mr. Sprinkle. You are excused. Call your next witness.
Your Honor, the state calls Detective Underwood to the stand.
Okay.
State calls Kim Underwood to the stand.
Oh, we got a Hilton sighting, y'all. They bringing in the whole bench. They got the whole dugout playing in this game. Hilton just coming in with an armful of books and papers and a stack of files.
Kimberly Underwood, Kimberly Underwood.
Oh, she got that southern
where are you
drawl.
employed? City of Atlanta Police Department.
And what do you do for the City of Atlanta Police Department?
I'm actually a recaptured employee, meaning that I retired after 31 years of service. And they called me back, or they let me come back as a contractor with the gang unit because I spent the majority of my career in the gang unit.
Okay. And how long have you been back under the recapture program?
I'm in my second year, so almost 2 years.
All right. And tell the jury a little about what you do now, back in the recapture program, and then when you were at APD before retirement.
Okay, now they brought me back because I'm a senior investigator, I'm an instructor. They wanted me to really kind of mentor the younger investigators. I also teach at the police academy, so the recruits have to take a 4-hour class from me before they hit the streets about gang identification, gang awareness, gang investigations, and so forth. I also assist background and recruitment. We have to screen our applicants because we do have gang members that try to get employment, try to infiltrate the Atlanta Police Department. So I assist with the screening of them. Whenever an investigator have like a warrant or paperwork that they're not sure about, they'll bring it to me and I can proofread it or kind of help them with their cases. Before that, like I said, I spent 14 years before I retired in the gang unit. Prior to that, I was in licensing permits as an investigator. I was Zone 3 CID as an investigator. I did most of my career in Zone 3. So I've had, like I said, 31 years of experience with the police department.
And do you hold any degrees or certifications pertaining to law enforcement?
Yes, I have a degree from Columbia Southern University in criminal justice administration. I got my associates in criminal justice from Georgia Military College. I have over 2,000 hours in law enforcement training, and I still go to training even though I'm retired. I have over 1,000 hours, maybe hundreds of hours in gang training, because even though I'm retired, I still go to trainings and meetings and stuff like that to stay up on the gang trends.
And are you a member of any law enforcement organizations?
Yes, I'm a member of Georgia Investigators Association, Georgia Gang Investigation Association.
Is that short GGIA?
Yes.
And you spoke briefly about presentations. Have you ever made presentations on law enforcement topics to any professional organizations?
Yes, back when I first started teaching, which was back in 2011, I used to do a lot of the Atlanta Public Schools because I was a resource officer as well at Atlanta Public Schools. So I would teach the administrators on what to look for when it came to gangs in schools. I would do block captains in neighborhoods. I would go to City Hall and the block captains would come in and I would kind of give them a gang presentation on what to look for in their neighborhoods. I've done Grady EMS. Whenever they go to calls, they like to know what they're getting into when they're dealing with victims, whether they're gang members or whether there's going to be like retaliation while they're trying to triage a patient or whatever. I've done the military. I've done Atlanta Fire Department. They also want classes about gangs because they're EMTs as well. They have to do first, they're first responders, so they might like to know what they're looking for as well. Fire cadets. It's a list of different, groups that I've talked to about gangs.
And if you could tell the jury about, I think you said you had about over 1,000 hours of.
Maybe close to 1,000 hours. It's over 100. I know it's hundreds of hours. Again, I can't tell you exactly. I did probably submit my training from like at my daughter maybe, but it's hundreds of hours of gang training.
Give just a synopsis of some of the courses that you take as a part of that 100 hours of training, over hundreds of hours of training.
Well, I started out, when I first started the gang unit, I had no idea about gangs, even though I grew up here in the city of Atlanta where we really didn't have gangs, I say. But I started out in California. I went to California, did some gang training. It was mostly like gang awareness.
So I need you to slow down for me just a little.
I'm sorry.
Slow down. Okay.
Gang awareness, gang identification, interviews and interrogations of gang members, courtroom testimony, training. So anything that was pretty much dealing with gangs, I have been trained or either have trained people.
Outside of formal training, have you had the occasion to, in your personal experience as a investigator, speak with, interview individuals who identify as part of gangs?
Yes, pretty much my whole career as a gang investigator, I've done that.
And you talked about some of your trainings, talking about the national gang trends. Are those some of the topics that you learned as part of your gang training?
Yes.
Have you had the occasion to study gang trends here in Georgia?
Yes.
Over your 14 years working in the gang unit at APD, can you provide an estimate of how many gangs you have investigated?
Whenever I started the gang unit, we had a bunch of hybrids, like non-traditional gangs. So counting those, it was over 100.
And over the course of 14 years, how many times have you come in contact with individuals who identify as gang members or who are identified as gang members?
I would come in contact with them daily because that was a part of my, duties as a gang investigator. But like I said, I did work for the Atlanta Public School System where I came in contact with them there as well.
Can you even give a number of approximately how many gang members you have investigated or interviewed?
Over the years, I would say hundreds.
And as a gang investigator, did you have your own caseload?
I did. I have had caseloads, but what I did like about working in the gang unit that we did joint investigations. So most of our larger investigations are either, like the smash and grab burglaries or robberies or whatever. We would work as a team or as a group on cases.
Have you ever been a part of sharing information and intelligence with law enforcement, other law enforcement agencies?
Yes, we actually, like I said, the GGIA meetings, we meet with other agencies from all over the state of Georgia. I've gone to Cobb and assisted on cases, Clayton, I've testified in the to assist them. So yes, we do information sharing. I actually have a meeting next week with the Atlanta Public Schools and all the other schools in the metro. We get together and share information about gang trends.
And do you stay current on gang trends, including rivalries, alliances, customs, and habits?
Yes.
In the experience and training that you've just described, have you developed a familiarity with criminal street gangs, their activities, customs, and behaviors, both across the United States and Georgia?
Yes.
Have you received any training on how gangs use music to promote allegiances within their gang?
Yes.
I'm going to object. There's been no downward finding on that. I'll object to that. No question.
That's overruled at this point.
Have you received any training on how gangs use music to promote violence?
Yes.
What about how gangs use music to promote fear in other gangs?
Yes.
What about how gangs use music to promote cohesiveness within their gang?
Yes.
And what about how gang members use music to send messages to rival gangs?
Yes.
Have you ever been qualified as a gang expert here in the state of Georgia?
Yes, in Fulton County Superior in federal court, because I left out the part about me being a task force officer for 6 years while I was doing my time at the gang unit from 2013 to 2020. Federal court, DeKalb County Superior Court.
And you said you were a federal task officer for what agency?
For ATF.
And what were some of your responsibilities as an ATF task officer when you were assigned to that unit?
My responsibilities over there was to mainly focus on the VROs, the violent repeat offenders, who, when I went over there, I really didn't want to go over there, but when I went over there, I was told by my superiors that I could still work gang. I had been in gangs and I wanted to do gangs. So when I went to ATF, I was told that I can actually focus on the violent gang members. So when I was at ATF, that's what I did. All of my suspects that I came across were violent repeat offender that were actually gang members. We kept up with the NIBIN, where I actually went to training to learn about NIBIN and how we were able to match crime scenes with just the casings or firearms that we recovered. The caseloads that we did get were kind of like adopted cases from the police departments around the metro that we worked.
Your Honor, it's time to say, would like to tender Investigator Kim Underwood as an expert in criminal street gangs and criminal gang activity.
You may, yes. Mm-hmm.
Got to update, got to approach counter number 4. We're on number 4. Yeah, so they just came back, y'all. They just came right back with another expert. Came right back with another expert. What do y'all think is the subject of the approach, though? Because, frankly, this sounds kind of like what we were dealing with yesterday and what I talked about this morning, where you have a gang expert, but where's the lyrics part of it? Chaos in justice system, morning, afternoon. So where's the lyrics part? I mean, if she's presented as a gang expert, fine. What does that mean? What does that mean to be a gang expert? But beyond that, what makes her an expert in lyric interpretation? Gigi says, child, I'm done. Where's Rico? Haven't seen him yet. I've been telling y'all. They told us last sighting of Rico, he was still in blue jeans with the Blue Jean Bandits back in 2014, 2015 in Mechanicsville. That's the last time we saw Rico. He was still in blue jeans with the Blue Jean Bandits in Mechanicsville and the surrounding areas in 2015. We haven't seen Rico since. There isn't even a foundation laid that definitely says it's for the betterment of the game. Yeah, I agree. I agree. You know, that's the problem with this sprawling trial. This trial is sprawling, y'all. This trial is like it's falling over on this side, it's falling over on that side. They're trying to pick up the sides and put them back together into a package. Nobody knows what the heck is going on. That's why, like, sometimes you'll see when I do a video, like, honestly, I'll just put nobody knows what's going on. Because, like, I literally feel like so often, like, you aren't even watching a coherent trial. You have 6 defendants. You have 6 defendants. So you're talking about you kind of watching 6 different trials in one. And so that's already complicated enough. You have the longest trial in Georgia state history, probably the longest trial in, not the longest, but one of the longest trials in U.S. history, I'm pretty sure. And with all of the different elements that need to be met, it's like they're just slapping stuff together. All right, Tatiana. That Tatiana says, here's my problem. And no offense to anyone of political preference. Uh-oh. We're about to walk through the minefield. Finally lied on the stand, and no one cares that she did. Then she charges people with crimes, and her helpers make a fool of it. I don't think that's a political statement. You talked about a person. I mean, I'm not saying that I know personally that she did that, but it doesn't seem like a political statement. What you're saying it sounds like an assertion about Fonnie. Patron Gold, man, that's how I know the jurors got to be confused because they can't even discuss anything yet. That's what I was saying this morning. Jurors can't even talk to each other. This is like, and then somebody said the juror's going to come back with a verdict in a few hours. You know what? I was about to say it's going to take them weeks to put it all together. But you know what? They might just come back with verdicts in a few hours, and I'll tell you why. It's possible. The reason why is because they can't understand all this. It doesn't matter how many weeks or months they have. So they may very well come to the conclusion within the first few hours or day. They might, if I'm in there, I'm the guy who's going to look, y'all, listen, there's no sense being here for 3 weeks debating this. Nobody in this room can understand anything that we just saw over the past year or two. So based on whatever little bit you understand today, that is the maximum of your understanding. The little bit that I understand is the most I'm ever going to understand about this. Let's just vote based on our limited, 2% understanding of everything we just saw over the past 2 or whatever years, because we're not going to understand anymore. We're not going to be illuminated from here on out. There's no amount of explanation. That's what this whole trial already was. It was one big long explanation. We didn't get it. Nobody got it. So we might as well just take a vote and go home. That's how that's the guy that y'all might, there would be people who like me on the jury. There would be people who don't like me, but that's the way I see it. There's no sense. There's going to be no. Now, if you say, no, we have one specific question that we want resolved. Okay, fine. Okay, that makes sense. Yeah, we have these 3 specific questions we want to get answered to. Excellent. That means you understood enough to even ask 3 intelligent questions. I would say if I'm on a jury at this point, I don't even understand enough of this trial to ask 3 questions. I just need somebody to sit me down and take me from day one and just explain the whole thing over. So if I'm far enough along to pinpoint, okay, I'm good except for these 3 holes in my understanding, I'm a legal genius at that point. You know what I'm saying? So let's get some more comments. Is that Collins? They already read lyrics out of context. So this is what I was saying earlier this morning. I was saying that, of course, you're going to use people's lyrics if they line up, but this is where you want people of integrity in the prosecutor's office. This is why integrity matters so much in the prosecutor's office, because you want to be able to trust them to use lyrics and any other evidence for that matter in a way that represents their best understanding of the truth. And you want them to, when it's clear, when it becomes clear that the lyrics, that they've misunderstood the lyrics or they've misinterpreted or they have the wrong context, you want them to exclude that automatically, like, okay, we get it. You don't want prosecutors to have the power to purposefully misinterpret lyrics or to accidentally misinterpret lyrics and then not change that once it's made clear to them. That is the danger, but it's not just lyrics though. So it's not just lyrics, it's anything. You notice today, Max Sharp, he stood up in court. He said, Your Honor, my client is on a call. He said X, Y, ABC thing. Matter of fact, let's go back to what Sharp said. That was early. Since we're on a break, we're on a long one this morning. All right. What's Sharp say?
There is, in one of my clients' phone calls, there is a comment where he says, I just went to court and they let everything out. F him, in the context, it's D, Woody, and the other D. In that context, he just came back from a prelim. So to someone that's not a lawyer that practices in Fulton County, you would get the impression that Woody and D and the other D let everything out in court, when I think it's pretty clear he's referring to the detectives the detective that testified at the prelim.
Okay.
So we're going to work on a stipulation that lets the jury know that a detective testified at a prelim on that date.
So the reason I just played that is because, as you can see, as a lawyer, you have to be able to articulate that this thing was said, but it doesn't mean that thing that it could have meant, or that you think it means, or that it could be interpreted as meaning. It doesn't mean that thing. It means this other thing. So when it comes to the lyrics, and I'm hoping we get to see this lady. I want them to get into I don't want them to misunderstand the lyrics, but I want to see how she's going to handle this lyrics question. I really do. I want to see how she's going to handle this lyrics question. Patron Go says, I'm with you on that. I couldn't convict all these people beyond a reasonable doubt. Patron, I don't even, for me to even say that, and I agree with that statement, but that's assuming I even know what I'm talking about. I know I'm like here doing this live and, we're working through this, but globally speaking, as a global, it doesn't seem like anybody really understands this court as a whole. Kai G says lyrics should not be acceptable in court. Kai G, were you on earlier when we talked about this? I think lyrics should be accepted on a case-by-case basis and in a limited capacity. We talked about this extensively earlier. But it really would come down to the prosecution being of integrity and the judge being of integrity for that to work out properly. And we can easily imagine situations where those two things.
Yes, sorry.
Yo, did they just approach again? All right, so we need to update this. That was the quickest approach ever. So our approach counter just went from 4 to 5, just that quick. Our approach counter went from 4 to 5. So, a lot of legal work to handle a dishonest office. Yeah. So I'm not. When I first heard about it many years ago, let's say 3-4 years ago, whatever it was, when this started becoming a thing, my gut reaction was like, oh, they shouldn't be able to do that. But as you think about it, you gotta like, what would be a good explanation for why the prosecution can't use lyrics? There is no good explanation for why they can't use lyrics. But there has to be relevance to the trial. There has to be a reasonable connection to something they're trying to prove. And again, we elect and select and allow to operate prosecutors. We need to hold them accountable for the decisions they make.
As a part of the gang unit with APD, were you familiar with a gang YSL?
Yes.
And does YSL go by any specific names?
Young Slime Life. I've heard Young Stoner Life.
And how are you familiar with Young Slime Life?
I'm familiar with YSL. What happened was I've been in, like I said, the gang unit since 2009.
Your Honor, I'm going to object to broadness of this question.
All right. Let me ask you this. Was there an iteration of YSL prior to the name YSL?
Yes.
And what was that gang called?
Rock Crew.
And were you familiar with Rock Crew?
Yes.
And how were you familiar with Rock Crew?
From gang investigations while I was an investigator in the gang unit.
And around what year or time was there a transition from Rock Crew into YSL?
Your Honor, I apologize. I'm going to object cumulative.
Sustained.
Okay. Let me ask you, are you familiar with another gang, YFN If Gang?
I am.
And how are you familiar with that gang?
They are Inglewood Family Bloods. YFN is a subset of the Inglewood Family Bloods.
And based on your knowledge of gangs, did those two gangs have a rivalry?
Yes.
Object that debate 704. No jurors can figure that out. We don't need expert testimony.
Overruled. And can you please use your mic? It'll make it easier. Sorry. Thank you. Sorry. Wish it weren't the case in here that this sounds so complicated, but it is.
And just approximately how long has that rivalry been in place?
Asked and answered cumulative.
Sustained.
Have you heard of the term gang war?
Yes.
And how have you heard of that term gang war?
Objection, relevance, and self-explanatory.
Sustained. I mean, not relevance, but it is self-explanatory.
As part of the gang unit, were you familiar with the facts of the Donovan Thomas murder and the retaliatory shooting surrounding Donovan Thomas's murder?
Yes.
And how were you familiar with the Donovan Thomas murder and the retaliatory shootings surrounding Donovan Thomas's murder?
I was assigned to ATF as a task force officer. So Operation Planners is actually a federal name that we gave the investigation. So whenever Donovan Thomas was murdered, gang war ensued and several shootings around the city. So APD and ATF came together to investigate those shootings and to try to stop the gang war.
And were you involved in any of those investigations?
Yes.
How were you involved in those investigations?
Like I said, I was a task force officer with ATF. What happened was we all got together, the gang unit at APD and special agents at ATF. We all got together and we would meet like weekly about the shootings because they were rapid and happening so much that we had to do something. So we all used to get together and we kind of divided up the cases between different officers, investigators, agents, or whatever to, like I said, try to stop the gang war.
And did you have any particular focus for you as a part of that kind of collaborative effort?
Yes, because I was a federal agent. I was tasked with handling anybody that was a federal target, meaning that if they could go to federal court opposed to state court, I was involved in those cases because I was a federal task force officer. So I could prosecute a case federally when my partners over at APD couldn't because they were not task force officers.
And as a federal task force officer, did you find that you were involved with more of the YSL side of the gang war or the YFN side of the gang war?
Sustained.
Okay. What were the two entities that were engaged in this gang war?
Answer cumulative.
Sustained.
In preparation for your testimony today, have you had the opportunity to review some of the reports that came in back in 2015?
Yes.
Have you also had an opportunity to review some of the operation planners report that summarized some of the incidents that occurred in 2015?
Yes.
Have you also had the occasion to review a video from Magic City?
Yes.
And we'll speak about this more, but have you reviewed any type of music in this case in order for your preparation for your testimony today?
Yes.
Based on your review of the reports and your knowledge of the events in 2015, in your opinion, was there a gang war going on in the city of Atlanta?
I'm clearly going to object to cumulative 704B, and this is the fourth gang expert that the state has called the same exact events.
All right, well, one of them was, all of yesterday's testimony from that person was excluded, so.
I didn't mean to interrupt the report. Actually, that person testified 3 previous times.
I know, and that was not excluded. But I would imagine, why don't y'all approach?
Y'all remember the song where they say it's getting kind of hectic. It's getting kind of hectic. Y'all, it's getting hectic out here. You can feel the temperature rising. You can literally, it's palpable just how hot things got. They do not want these gang experts testifying any longer. Yes, we are 6 on our counter. We are 6 on our counter. They do not want these gang experts to get up here and talk about lyrics. Y'all, they feel the lyrics coming. They got somebody knocked off yesterday right before he got to start talking about lyrics, and they are going after this lady because she's about to start talking about lyrics. I mean, I think it's the whole gang angle, honestly, not just the lyrics. But this is the crux of the matter, y'all. Why are they so hot, if you will? Because this is the crux of the matter. No gang, no Rico. No gang, no Rico. Okay? It's like the OJ. If it doesn't fit, you must have quit. If there is no gang, y'all help me finish that one with some kind of rhyme. If there is no gang, they go free. I don't know I couldn't finish it up, y'all. I should have thought about this. Y'all help me out. Yeah, no gang, no Rico, but we got to make it rhyme. Like if it doesn't fit, you must have quit. You know, that was Johnny Cochran. No gang, Thug and them go home. I don't know. Yes. No gang, no bang, you know? So they got somebody off the stand yesterday talking about the gang stuff, and they look like they're ready to go with that same strategy again. No gang, no claim. No gang, can't hang.
Your Honor, I believe I may have failed to do this, or if I did, I'll just do it again. Your Honor, this time today would like to tender Investigator Underwood as an expert in criminal street gang activities and an understanding of gang culture and how music can be a part of gang culture.
All right, she is so qualified and may testify as such.
Thank you.
I maintain my previous objection.
Yes, of course.
Y'all, that was a bit of like a Dahlberg hearing.
Now I want to go specifically, Detective Underwood, to the week leading up to Donovan Thomas's death. Okay. And from the review of the records, do you recall Donovan Thomas being killed on January 10th, 2015?
Yes.
Right. I want to go back to that week, earlier in that week. Are you aware of, through your own personal knowledge of what was occurring in 2015, a fight at Club Crucial?
Yes.
And who was involved in that fight in Club Crucial?
Kenneth Copeland and Kevin Watts.
After that fight at Club Crucial, did you become, and I'm going to ask just very specifically, about a shooting outside of Club Crucial?
Yes.
Right. And on that same day, Mr. Arnold being stopped by police along with another individual?
Yes.
All right. After that incident on January 6th, were you aware of any other incidents that occurred that week of 2015 before Donovan Thomas's murder or the killing of Donovan Thomas?
I can't think of offhand except for think over at maybe at a what they call it, it was a gambling spot in Zone 3 where a windshield was damaged and words were, I guess, exchanged or had about the windshield being damaged between rival gang members.
What about a shooting at TIG Studios?
Yes.
Now, after the death of Donovan Thomas Jr., in your opinion, based upon your understanding of what occurred in 2015 from reports and your own parts of your investigation, after the shooting of Donovan Thomas, was there a main target of individuals associated with YFN or IF gang?
I don't understand the question.
Sure, sorry. Did they have someone that they were targeting, individuals who were associated with IF gang and YFN after Donovan Thomas's murder?
Vague with they and also.
Sustained.
Sure. After Donovan Thomas's murder, was there an individual who was targeted?
Yes.
God bless you.
Speculation calls for speculation of the intent of others.
Sustained. You may rephrase.
Sure. Based on, let me ask you this. After the death of Donovan Thomas Jr., did law enforcement receive information about shootings at several homes after Donovan Thomas's murder?
Yes, we received several 911 calls and incident reports were made at these locations.
Okay. And in evaluating and looking at those locations, were those locations associated with a particular individual?
Yes.
Who?
Kenneth Copeland.
And the homes that were targeted, that were in relation with Kenneth Copeland, do you know where those homes were located?
One was on Van Ira. I think I remember Deshaun Copeland's girlfriend. That was her mother's house. I remember his sister's house was targeted on Oakland over in Zone 4. And his brother's house was targeted on Hendricks Drive in Zone 3.
Okay. And did those particular shootings happen within the first few days after Donovan Thomas was killed?
Yes.
Now, in January of 2015, were there any shootings that came into the Atlanta Police Department in which the locations involved individuals who were associated with YFN?
Yes.
What were those locations?
I remember Rayshawn Bennett, AKA Lucci's mother's home being shot over on Hill Street in Zone 3.
I'm going to object to previous testimony already given. It's cumulative.
Okay, go ahead and get to whatever point there is.
How many times was her home shot?
Twice.
Okay.
I'm going to ask her about the first time. Were there individuals from YFN who were at the location when police, because that's going to form what I have to ask next.
Same objection.
Your Honor, this is part of what occurred yesterday.
Go ahead. I'll give you some latitude.
Thank you. The first time her home was shot, were there individuals at her home when police arrived?
Yes.
Who were those individuals?
Kelvin Watts, Jermaine Hardiman, and Jamal Ward. No, Jamal, I can't remember his last name.
Does the name Jamal Bynes sound familiar?
That sounds very familiar.
And were those individuals associated with any gang?
Yes, they were Inglewood family blood members.
And the second shooting of Miss Rayshawn Bennett's mother's house, was that on 1/26/2015?
Yes.
Okay. On that same day, on 1/26/2015, did you become aware of an incident in which Kenneth Copeland was shot at on the highway?
Your Honor, I'm just going to object to hearsay. Unless
Overruled.
Based on your review of the reports, did you become aware, whether it's part of the reports or your own
Yes,
knowledge of the
'cause
investigation?
At the time, we were actually keeping up with and collecting every incident that happened between the two gangs.
And so did you come aware of an incident in which Kenneth Copeland was shot on the highway on January 26, 2015?
He wasn't shot. I think he was shot at. Him and his brother they were fired upon while they was driving down the expressway.
Thank you for that clarification. Did you know that case number, was that for case number, APD case number 150260124?
That sounds correct.
All right. Now, did you also have the occasion to review APD incident case number 150262672?
Yes.
And was that the incident we just talked about when Lucci's mother's house was shot up?
Yes.
And did you also have the occasion to know of and look at APD case number 150262801, the shooting of Trevante Turner?
Yes.
And the location 198 Stanhope Circle, are you familiar with that location?
Yes.
How are you familiar with that location?
During the investigation, I found that whenever I prosecuted Jermaine Hardiman on the federal side, that was his residence.
And Trevante Turner, from your investigation, was he associated with a gang?
Yes, he was a 9 Trey blood, but he hung out with his bestie, Kenneth Copeland, who was YSL.
All right. And in looking at those three case numbers, 15-026-0124, then 15-026-2672, and 15-026-2801. Would the 0124 incident be the first incident?
I think so. They in chronological, if they're chronological, yes.
All right. And I'm going to put those numbers up because I know it's probably hard for you to remember what I just. Okay, so I think if you could, permission for investigator Underwood to stand.
Yes, of course.
So I believe you just testified that 0124, there's a number in which Mr. Copeland was shot at on the house. And Copeland, was he associated with YSL? Yes. Then on 15-026-2672, is that when Lucci's mother's home was shot? Yes. And Lucci, what, if any, gang was he associated with? YSL and Inglewood family. And then 15-026-2801, you said the location was in YSL, near YSL member's home? Yes. Name Harvey. But the individual who was shot was YSL. And you put him with another gang? Not regulars. Now I want to ask you about some incidents that occurred in February of 2015. February 10th specifically. Do you recall looking at an APD case report where there was a shooting of Kelvin Watts? Yes. Do you know where that shooting occurred? It was over in Zone 3 on University Avenue, but it was very close to 30 territory. And Kelvin Watts, was he associated with a gang? Yes, the Inglewood family was. On that same day, was there a shooting at 193 Hendrick? Yes. And who was associated with Hendrick there? Kenneth Copeland's family, his brother. And again, same Kenneth Copeland as above? Yes. YSL? Yes. And then on February 19, 2015, was there a shooting involving Kenneth Copeland and his child's mother?
I'm going to object to leading, Your Honor.
Sustained.
What, if anything, occurred on February 19, 2015?
Object to leading, Your Honor.
Overruled.
If that's the one over at, Villages of Carver, whenever, Chief Copeland was at his, girlfriend's house, he, was walking out with his baby and was, fired upon by rival gang members while holding his baby. Do you know who the rival gang members were? Yes, I'll have to look at the report to refresh my memory, but I remember, Ivy Hardy being involved because he got blood in the car. So they actually crashed the car. It was Deontay Fleetwood, it was Josiah Johnson, and I never think of the last guy's name, but it was his girlfriend's car that they showed up in, the reason why we was able to solve the crime. It was Octavia's, what was his name? That's why all these people, why are they? They are actually Inglewood family blood. Now, as you all, you have a secret right now. Now, within the first 6 months of 2015, did there ever come a point in which it appeared that the shootings kind of died down within the early portions of 2015? Yes, around after those incidents in February, I think March was pretty quiet for us.
You said March was pretty quiet.
Yes.
Right. Did it pick back up again at some point?
April.
Okay. As a part of your familiarity with Operation Planners and what was happening in 2015, was there a shooting on April 12th involving an individual by the name of
Objection, Your Honor, repeated.
I can rephrase. Are you aware of a shooting that occurred on April 12th, 2015?
Yes.
Who was the victim in that case?
Was that the one on 490 Glen? Or?
Let me ask you a better question.
Right.
Are you familiar with an individual by the name of Dexter Montgomery?
Yes.
Okay. And were you familiar with a shooting involving a Dexter Montgomery?
Yes.
Did that occur in April of 2015?
Yes.
Also, are you familiar with the individual that goes by the name of Dwayne Carter or Little Wayne?
Yes,
Were you familiar with a shooting of his that occurred in April of 2015?
I do. I am.
Were those two shootings considered a part of the Operation Planters?
They were.
Were those two shootings particularly determined part of the gang war between YFN and If Gang?
Yes.
Relevance.
Sustained.
Now, I want to take you specifically to April 28th, 2015. Did you have the occasion to review a report for 151180288?
Yes.
And do you recall what location that incident was?
I don't recall by case number. If you give me the location, I can probably tell you what happened there.
Was there an incident at Club Cushion?
Yes,
What occurred at Club Cushion?
it was a shootout.
Yes, sir, Your Honor.
Overruled.
Objection cumulative.
If I just had just a little leeway.
It's
Just
all been
get the
cumulative,
facts on
Your
the
Honor.
paper. Overruled.
I'm going to show you what's been admitted as 1JJ. Looking at Section Exhibit 1JJ, do you see the incident number for 1JJ?
Yes,
What is that incident number?
151180288.
And where is that location?
2517 Donald Lee Hollowell, which would be Club Crucial.
Can you also show me what's been admitted as 2 Tango Tango? And while we're waiting for that to come up, was there an incident at 1903 Jew Drive?
Yes,
Was there also an incident that morning at 1428 Adele?
yes,
And was there also an incident at 2900 Lane?
yes.
course, it goes. While we're waiting, the incident at Club Crucial, who was involved in that incident?
Objection cumulative.
I'll ask him that.
Yet again.
Was the individual a YSL associate?
Yes.
Yes.
All right, approach number 7. Approach numero 7. Oh, this is wild. I told y'all that this I mean, not that you couldn't see it yourself. Not that y'all couldn't see this yourself. I think this is clear for everybody to see that the defense is dead set against allowing this lady to. She hasn't even gotten into any real new testimony, y'all. This is all cumulative evidence. This is all cumulative. This lady, this expert, and it's not her fault. It's Hilton who's asking the questions. Literally just going over the same stuff that they've talked about 11 times at this point. I mean, come on. What's that? She read a motion for mistrial? Andre, are you saying there's a motion for mistrial open right now? Or what? Andre, what are you talking about? Fourth gang expert. Oh, Ashley Merchant's letter. Okay, got you. Yeah, I might do a video on that this weekend. But yeah, y'all, 11 times they done talked about what happened on April 28th. What happened on, did Lil Woody get shot at on when he was driving down the street? Was he holding his daughter? I mean, it's like, yo, come on, yo. They should have been able to line everybody up, give all the different angles and perspectives on that one thing, and that's it. It's like they're going to keep coming back every couple of days, every couple of weeks to go over the same. Do they have any new crimes to talk about? Do they have any new? Yesterday, it seemed like we were finally moving forward to some new crimes with the Eppinger situation. It was like, oh, okay, maybe they finally are moving forward to talk about other things. And now, I mean, I get it. Detective Dennis was disqualified, but was he just going to be brought up to talk about the same old stuff that everybody already talked about? I mean, I don't know. We're on 7. We have 7 approaches, y'all. We put our banner back. There's 7 approaches so far today. Many of those, like 3 of those, with this one witness.
I'm going to show you what's been a minute. It's 4 kilo. And what incident is 4? What incident number is 4 kilo?
151180462.
And what's that incident location?
1428 Adele Avenue, Southwest.
And then I'm gonna show you 2 Lima Lima. What is that incident number?
Incident number 151180588.
And what's that incident location?
1903 Drew Drive, Northwest. Apartment 1, no, I thought it was apartment, no, B110. Yeah, apartment 1122.
And then on that same day, was there a incident at 2900 Landrum Drive?
Yes,
And do you know that case number sitting here today?
I don't know it by heart.
I'm going to, Commissioner Cochran? You may. I'm going to show you what's been marked for identification only at 600 YYR. We're looking at the help refresh your memory as to what the incident number was for 2900 Landrum.
Okay.
What is that incident number?
It's 151180531.
Okay. Now, looking at, if you want to come here, you can. Looking at the first, would this have been in chronological order? Yes. And I think we talked about for 0588, was that the location where the Meek Young, something happened to the Meek Young Garland?
Yes, he was shot at the club.
And the Meek Young Garland, who did he associate with?
YSL.
Now, 1428 Adele Avenue, where was that location?
That was Inglewood family gang member Darren Mills' address.
And what occurred at that location? Was it a shooting?
Yes, the house was shot up, and I think a lady was shot.
Right, 2900 Landrum Drive. Who was associated with that location?
From what I remember, it seemed like Summer Good was over there visiting and was targeted because she's Quindary Zachary's girlfriend.
And Quindary Zachary, what gang was he associated with?
YSL.
And then 1903 Drew Drive.
That was Philip Collins' girlfriend's apartment.
You said Philo or Philip?
Philip Collins, aka Philo. His nickname is Philo.
And was he white?
He was Inglewood gang.
So on April 28, 2015, there was an incident involving a YSL gang member at the club getting beat up.
Yes.
And then right after that, there was a shooting at.
Actions of leading, repetitive.
That's Nancy.
Sustained.
Is this what occurred on that day?
Yes.
Now, looking at what happened in April 28, 2015, February 10, 2015, and January 26, 2015, was that the kind of agenda of the back and forth that was happening over the course of those first 6 months of 2015?
I object to the example if they want to prove individually, otherwise I object to the characterization of the example.
In your opinion,
Go ahead.
in your opinion, was that the back and forth that was happening based on police reports in January 2015, January through June 2015?
Doesn't call for opinion testimony. I object.
Sustained.
Was this what was happening?
Yes.
back and forth?
Yes.
All right.
Oh, we were about to get an approach right there, y'all.
Now, as a part of your investigation, I want to take you to September of 2015. Were there any incidents involving an individual by the name of Shannon Stillwell as a part of your operation planners?
Yes.
And I want to specifically talk about September 26, 2015. Was there an incident involving also a woman by the name of Tierra Jones?
Yes.
And the individuals, were you aware of the individuals who were charged in that incident?
Yes, they were in Inglewood.
This is cumulative, and it's also, in my opinion, my humble opinion, and it's also hearsay, and the expert is using as a conduit, is being used as a conduit for hearsay at this point.
Your Honor, this case was
Experts can testify based on hearsay. Overruled.
the individuals who were charged. Are you aware of an individual by the name of Dominique Carter?
Yes.
Does he have a nickname?
Stewie.
What about an individual by the name of Bobby Hardy?
Yes.
Is his nickname Smoke?
Yes.
Is that the same Bobby Hardy that we discussed for the incident that occurred February 19, 2015?
Yes.
And then it was an individual who goes by the nickname of Merrill.
Yes.
His name Jamal Ward.
Yes.
Were those individuals ultimately charged for what happened on 9/26/2015?
They were.
And were those individuals a part of If Gang as well?
Yes.
Now, taking you to about 4 days after that, on September 30th, 2015, were you, as a part of your investigation, did you learn of an incident that occurred at Magic City Adult Entertainment Center?
Yes.
And what occurred at that location?
Your Honor, confrontation clause.
Was there a surveillance video? Were you able to observe a surveillance video at that location?
Yes.
And did you observe that surveillance video in preparation for court today?
Yes.
And Your Honor, may I approach?
Yes.
I'm going to show you what's been marked as State's Exhibit 543Y. Do you recognize State's Exhibit 543Y?
Yes.
How do you recognize it?
It's a video that I initialed, it's a CD rather of a video from Magic City that I initialed today.
And does that video contain an incident involving a person by the name of Martinez Arnold?
Yes.
Foundation. Can't use the exhibit portion of it. I object to foundation.
Does that show an incident that occurred at Magic City nightclub in September 2015?
Yes.
Same objection.
So you're saying what it is before it's been
Have you,
admitted.
were you aware of an incident at Magic City?
Yes.
I asked that earlier.
Right.
Okay. And have you seen a video regarding an incident that occurred at Magic City?
Yes.
Was that a fair and accurate depiction of the video of what you understand occurred at Magic City back?
Excuse me, I apologize. I will object to foundation.
What happened? Ask what happened at Magic City, woman. Sorry, y'all, but
How are you aware of the
even
incident
I
that
know
occurred
what
at
to
Magic
say
City?
here.
I was aware because it was
Ask her what happened.
YSL member that was jumped inside of the club, and so
Hearsay and.
Okay, I think we're gonna break for the day. We'll sort this out. And I know that somebody needed to leave early today.
Do we
anyway,
count
so it
this
seems
as
like
a,
a good
as a
place to
mixed
stop.
conference or no?
I'm gonna see y'all all on Monday, and I'm wondering, y'all come up here for a second.
We gotta
Y'all go
count
ahead
it.
and be gathering your stuff, but I may have
We'll
y'all come
count
in at 9:30 instead of 9, but I need to consult on some scheduling first, so don't leave before you get the show up time for Monday. Remember, don't talk to anybody about the case. Don't let anybody talk to you about the case. Do not view, read, observe any kind of media or social media or news or anything about the case or anybody involved in it.
Oh my gosh, man.
So y'all can
Like
go out to
Hilton,
the jury room and I'll give y'all the show up time soon.
You got stuck, y'all. In my opinion, the Recapture Gang Project is a great big money opportunity for the retiree and big ways. Oh, 31 years, retired, probably got that nice, good government pension. Then they go back and say, hey, you want to come back and work for a nice 6-figure salary on top of your
At 8:30 on Monday. And I know that we need to get through motions in limine 64, 65, and 66. I don't know that the motion to reconsider is really gonna, I think it might be mooted. Well, to the extent I'm gonna need to entertain that, we'll have to deal with that as well. So I don't know that we can do that in 30 minutes. Do y'all think so? All of those things? I mean, maybe, but instead of having them show up at 9 and not reach them until 9:30 or 10.
Let them come in at 10.
Your Honor, 64, 65, and 66.
What?
I just don't know off the top of my head.
I mean, I don't know. They're the last 3 motions in limine that Mr. Steele filed that we never reached because we've been in court all day. I mean, all week. Oh, yes, thanks. But you don't know what time to be back either, but they'll let you know. Sorry.
Y'all, she got a good gig.
And I'm going
y'all.
to get y'all's responses sometime today. They're due today.
Yes, Your Honor.
And of course, they will as well.
That gang expert.
I was going to update the court in terms of scheduling Monday. Me and Ms. D. Williams have been talking extensively about the remaining objections for Act 79 through 81.
Okay.
We're going to speak again after court today.
Okay.
There may be a very brief disagreement on the remainder,
Okay.
but we expect it would be quite brief and similar to the arguments that we've discussed previously. I just wanted to.
All right, well, great. Then that could be something we can finalize.
Yes, Your Honor.
Monday morning. I'm just going to tell them 9:30 and tell y'all 8:30. And I think we can get through those things in an hour, but I don't think we could get through them in a half an hour. Okay. Laura, do you mind letting them know that? What?
Okay. Your Honor, I would just humbly ask that if the state could provide us with a updated roadmap of what witnesses.
Yeah, they're
Yeah.
supposed to be doing that. And did y'all say you had already emailed it?
No, not yet, Your Honor. We will email that today.
Thank you.
Okay.
Is this from,
For next week.
we'll definitely have, I think, for Monday, and we're trying to just confirm some other things, but we'll definitely have the witnesses from Monday.
Okay, so it needs to be for next week, and if some of them are, we're not sure about this person, then just put a little note, we're not sure about this person, or it may be this group, if not, it's gonna be that group, okay? But that needs to be done today for the whole week. All right, if there's nothing else, I'll see everybody at 8:30 on Monday.
You said today 11:59 is okay?
I didn't actually give y'all a time, but, I mean,
It's a bad joke.
yeah. I'm sure that for the witness list, everybody would like it before then. For the responses, 11:59 is fine if y'all don't have them ready yet.
Thank you.
All right, I'm going to take a, all right, so we're adjourned for the day.
Thank you.
For this.
All right, everybody, listen up. We are going to stick around for the next 20 minutes. If you want to see what happens to Monk Tonk, he has a probation revocation hearing coming up with the same judge, Judge Whitaker. It is not, you don't have to change the channel away from us. Law and Crime will have it. We will just find the feed and bring it to you at the right time. So let me make a quick banner. Blah, 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 blah. Let's make a new banner. Monk, Tunk, probation, revocation, hearing coming up at 4 p.m. Eastern. So if y'all want to see Monk Tunk, probation, revocation, hearing, hang out. I will just continue to play the video from yesterday until we get that up. Whoops. I will just continue to play the video from yesterday till we get that up. So first, let me bring that back. Give me 1 second to load it up. Here we go.
Or any post
We'll play this one.
new evidence code cases with similar facts to ours. So I'd rather have something in writing if y'all don't mind.
I will, but there's a ton of
All right. Well,
cases.
you don't have to give me every one. Just
So the state is wrong.
About 10 minutes.
okay. I don't want to argue it right now. I want a written response. All right. Appreciate it.
And we are back. Everybody go ahead and hit that like button. Today, we're going to bring you a very interesting video on the heels of what happened yesterday. Now, as a quick flashback, yesterday, Detective Dennis of the infamous pair, Dennis and Gaither, the two gang cops who set out to take down the YSL record label, Detective Dennis was permanently banned, barred, and kicked out of and just booted from the YSL trial for misconduct because he talked about Yak Gotti's criminal past when he, as a retired investigator, retired detective, should have known better. Now, Whitaker, she was not having it. She kicked him out. But D.A. Hilton, who was examining Dennis at the time, she really couldn't. She saved the mistrial, right? So there was a mistrial motion on the floor at the moment, and she saved that. But she lost her witness. She lost all the exhibits. She lost his future participation in the trial. So after this, the state has now filed a motion after Detective Dennis was absolutely kicked out and booted from the YSL trial. The state has filed a motion that we are going to review right now. Now, I'm going to tell y'all something. I'm going to tell you what to look out for, and I'm going to tell you that you're not going to hear this. I want your ears to perk up. I want you to pay full attention, and I want you to see the gaping deficit, the gaping hole in this motion. The gaping hole, the gaping deficit in this motion is it does not address the defense's argument. This motion should present a clear path forward where the defense can be at least somewhat satisfied, where the state can be at least somewhat satisfied, and where the judge can save face and be somewhat satisfied. You're not going to hear that. What you're going to hear is the state tell the judge that she's wrong, that they, while the Detective Dennis did do something wrong, they're going to admit that, but they're going to say that they should get their way, the state should get its way. They're going to tell the judge she's wrong, and they're not going to present any kind of clear path forward where the defense's reasonable objection can be handled. So I'm going to play the clips from yesterday for you so you can see what I'm talking about. And as you listen to me read this, notice that there is absolutely no path forward where all parties could be at least somewhat taken care of. Okay, so I'm going to read. State's motion to reconsider oral order striking witnesses' testimony and related exhibits. Comes now the state of Georgia and respectfully moves this honorable court to reconsider its October 17th, 2024 oral order striking the October 17th, 2024 testimony of witness retired investigator T. Dennis and related exhibits and precluding his future testimony as a sanction for an inadvertent, non-responsive answer during his testimony. In support thereof, the state shows the following. Background. During Investigator Dennis's testimony, Investigator Dennis referred to actions defendant Diamante Kendrick performed immediately after his release from custody. Defendant Kendrick moved for mistrial, which this court appropriately denied. As a sanction for this event, however, the court struck the entirety of Investigator Dennis's October 17th testimony, precluding him from testifying in the future, and struck from evidence exhibits which Investigator Dennis had authenticated on October 17th. 2. The scope of the state's claim. It is appropriate for the court to strike a witness's answer from the jury's consideration when it contains information the court finds the jury should not have heard and should not consider. The state does not contest that part of the court's ruling. The state submits, however, that the order striking the entirety of the witness's October 17th testimony, precluding the witness from testifying in the future, and excluding exhibits which had been admitted through that witness on October 17th was improper, as an exclusion of evidence which the law does not permit. The state thus respectfully moves the court to reverse those portions of the court's oral order. Analysis. Evidence exclusion is an extreme sanction and not one favored in the law. This is so strongly a part of Georgia law that even the most well-established privileges are narrowly constructed as, quote, the ascertainment of as many facts as possible leads to the truth, the discovery of which is the object of all legal investigation, end quote. OCGA 244402, or Rule 402, provides in relevant part that all relevant evidence shall be admissible except as limited by constitutional requirements or as otherwise provided by law or by other rule, as prescribed pursuant to constitutional or statutory authority applicable in the court in which the matter is pending. That is, Rule 402 forbids a court from excluding evidence unless constitutional or statutory authority authorizes that exclusion. Here, no constitutional or statutory authority authorizes the exclusion of the non-offending portions of Investigator Dennis's October 17th testimony, of his future testimony, or the related exhibits. All right, y'all. This is all we need, y'all. What I want to do is summarize the rest of this because I'm sure you all don't want to hear every word of this legal argument. What I'm going to tell you here is that the rest of this says, Judge Whitaker, you do not have the authority to exclude this evidence. So they have made themselves, the state has made itself an opponent to Judge Whitaker and her order. What they have not done here is they have not given Whitaker any way of maintaining her order, satisfying the defense's claim that they need to be able to cross-examine Detective Dennis or Investigator Dennis. They haven't done that. So basically, their way of going about this is to say, Judge Whitaker, you overstepped your authority. You are wrong. And we're asking you within your authority to correct your wrong. I would imagine that Judge Whitaker is not going to side with the state because, again, they are not only telling her that she's wrong, but this entire write-up does not even attempt to address the main point or one of the main points of contention that the defense is going to have, which is that they do not get to cross-examine Detective Dennis. So I think this motion is going to fail. I would like to hear from you all in the comments. Like, comment, subscribe, and let me know what you think will become of this motion to reconsider. For
those of you who did not catch it yesterday.
Oh, that's a lovely voice. That man has a stupendously lovely voice. Y'all, so we're just waiting about 5 minutes. We expect the Monk Tunk probation revocation hearing to start in about 5 minutes. So we'll hang out here for a sec. I think that it's going to be held on Law and Crime. They said that they got permission. They're still live. So just even though we see this tab here, they did say they got permission to cover this. Kathy Russin said that on X. By the way, y'all, let me show y'all something real quick. This is Mel. Mel is I'm Not a Lawyer, but that's what she goes by on YouTube. Check this out.
The house basically was a drive-by shooting.
Which group did you
Check this
investigate
out.
Kenneth Copeland as being a part?
Mind you, this is day 72, not yesterday. This is Detective Dennis, who we saw get booted yesterday, being interviewed by, sounds like DA Love. Does this look familiar to anybody?
The house basically was a drive-by shooting.
Which group did you investigate?
20.
Person,
Does
you're
this look familiar?
of Jeffrey Williams.
Has anybody
as
seen
a
anything that
alleged
looks like
perpetrator
this?
or alleged victim in this case?
Victim.
January 22nd, lived at 1007 Hill Street.
Does this look familiar to anybody? So, y'all, the cumulative objection is basically saying we already have enough evidence before the jury to establish a certain fact or certain set of facts. Presenting more evidence to establish that same set of facts is not going to help the jury understand more about it. If anything, it might prejudice the defendant. So you would say, objection, cumulative. You are piling more of the same evidence on top of itself. We are today on day 147. According to Mel, I'm not a lawyer, but as of day 72, so basically we've gone another 100% of the trial since then.
Kenneth Copeland. The
Yeah,
house
we're waiting
basically was
for
a
them
drive-by
to
shooting.
Which group did you investigate Kenneth Copeland as being a part of?
As of day 72, we had a timeline.
Drive-by shooting.
Is that
Okay?
address
And
connected
then
with
today,
anyone
we
who is
cumulatively
associated with
had the
YSL?
same timeline or similar depiction. This time, previously, it was Dennis, and today it was Dennis's replacement. Okay, so I thought y'all might find that interesting because guess who wasn't presiding on day 72? Judge Whitaker was not the judge on day 72. She did not see this timeline depiction on day 72. So when you change judges, as Bruce Harvey pointed out, when you change judges, you kind of get a little bit of a do-over on certain things. All right. So y'all, we're hanging out here. Yes, we do have the Live View logo popping around, but we are hanging out because Monk Tunk is going to be, so Patron Gold, court for the YSL Rico defendants. The 6 people we've been watching every day has ended for the day and has ended for the week. But what has yet to start, which will be starting in a few minutes, we anticipate, is the probation revocation hearing for Monk Tunk. What does that mean? Monk Tunk had RICO charges on him. He had gun charges on him. He was facing 30 years in prison. Monk Tunk signed a deal saying he would agree to certain factual acknowledgments. And as part of that deal, he said he would testify to those factual acknowledgments. And that is basically against Thug and against the other defendants on trial. Montong signed his deal, which gave him probation. He gets to be free, but he's under this cloud of, if you don't do what we told you to do or what you agreed to do, you go back to jail, plus any little thing might send him back to jail. So when he went to court, he had to know this was coming. Montong's been around the block. There's no way he didn't know that this was coming. There's no way that he didn't know that this was coming. When he went to court, of course, as anyone with half a brain would have guessed, they started asking him about his factual acknowledgments. And at certain points, Montong would say, yes, that is true. Yes, that is true. Yes, that is true. But at other points, he said, no, that one's not true. Now, this was D.A. Love who was questioning Montong, and also it was D.A. Love who had previously read out his factual acknowledgments in 2022 when he signed them. So it's the same person. D.A. Love, she knew she had all the cards in her hand. She knew that as Montong was disputing the factual acknowledgments that he had previously agreed to, she knew, and so did all of us, we all knew that D.A. Love, at the signature of a pen, could put Montong into the situation that he's in right now. What situation is he in? He's in a situation where he's going to have to try to convince Judge Whitaker not to send him to prison. That's what we're expecting. We're expecting this to be a kind of a final hearing, okay? That's what I'm expecting anyway. I could be wrong about that. I don't know if this is going to be just some kind of hearing that will set up a future hearing, or if this will be the beginning and end of the matter. That's what I'm not sure about. But the interesting thing is, and maybe this is the way the system is set up, the interesting thing is that this is Judge Whitaker who is going to be hearing this matter. And it was also Judge Whitaker. All right. Let me check something real quick. I'm gonna share this tab for the moment, y'all. This says hearing for Montong. Okay, so the Law and Crime still does not have this feed up, whereas it is on this one. But I have Law and Crime on another computer. This is Fox. Their audio is off sometimes, so we'll check back with Law and Crime shortly. See if we can grab that. So at any rate, Judge Whitaker is going to be hearing this. So Judge Whitaker, I imagine, has all the information she needs right now to make this decision. Andre, when you say it's starting, you mean, so we're here, we're on Fox 5, they're in the courtroom, Montong Sledge. So we're live on it. I would definitely prefer that we get it from Law and Crime, because the audio from 5 and from 11 Alive always comes out on the right stronger than the left. But if this is where we have to watch it, this is where we have to watch it. Somehow, Law and Crime has equalized their audio on both sides. But 5 and the other channel, 11 Alive, their audio always comes out weird for some reason. So we don't know what to expect as far as this being a hearing. We don't know if this is going to be like a preliminary hearing, if this is going to be like the final thing. I mean, they've only allowed like an hour, maybe 2 max for this to happen. So is this kind of just like, is it just kind of laying the groundwork for what's coming up? Or because it's Judge Whitaker, maybe she's like, yo, I was there for the whole thing. I saw exactly what happened. I know the letter of the law. So basically, let's just get him in here, adjudicate this thing, and get him out of here. Things that are working in Sledge's, okay, things working against Sledge first. He signed a piece of paper that said he would do something, and he didn't do it. He did it partially, but he did not do it completely. Any person watching what the trial, and sees what he signed he would do. It does not take a rocket scientist, as Woody would say. Doesn't take a rocket scientist for you to conclude he said he would do something and he didn't do it. So that's one. That's one. That's what's working against him. Just the letter of the law. Just the straight up. Okay, we have law and crime here. Let's stick with them. Usually their audio is better. Okay. How do I get rid of this? Okay, we back to Fox. Okay. We want long time. We want to make it big. Okay. Paralegal, are they allowed to have a witness today if the defense wasn't notified she was coming? You're talking about the gang expert? Apparently so, yeah. Apparently so. They're able to have her in. I think the main dispute was about her qualifications to be considered an expert, not so much whether she could come and talk or testify. Was MC actual attorney in the court with him when he testified? So Ocean Beach, not only was Monk Trunk's attorney in the court with him when he testified, yes, he was. The same attorney was the one who, you can say, negotiated the plea deal. The same attorney was the one who was there in person when Monk Trunk verbally agreed to and signed the plea deal, the plea deal in 2022. The same attorney was there with him this year, month and a half ago when Monk Trunk testified, and we could say broke the plea deal. That's what the state would say anyway. And the same attorney was then called to the stand to himself testify about the terms of the plea deal. So it's all one and the same person. Now, what we don't know, and we will not know, and, is my mic muffled? It might be muffled. I don't know if it's super muffled, but I probably should get a new mic. So, if that's the case. Now, what we do not know, and what I find, what I'm really, the first thing I'm really waiting to see right now is will this attorney show up here today? My mic muffled. Let me see something. I'm gonna switch out my mic. Hold up. Don't go anywhere. Let me see if I can switch out this mic. I have another. I actually bought a new mic. Did you just say it's better now? How's it better? I didn't do anything. I didn't even touch it. I have a different mic. Let me switch it out, y'all. Just bear with me. See what's that. I bought a new microphone. I probably need to buy another one. I'm gonna use this one. Give me a sec. All right, can y'all hear me now? Yeah, I don't know what happened. It might be the audio, honestly. Okay, it's probably the audio because I was getting some feedback from the audio. But I have a different mic now. So maybe there was some kind of feedback coming through here. Okay. Yeah, microphones. Okay, so who knows what's happening, y'all? Who knows what's happening? Okay, so what I was going to say, first thing I'm really looking for, y'all, the first thing that I'm really looking for is whether Derek Wright, which is Monk Tong's attorney, is he going to be there today? That's what I'm looking for as the first thing. And the reason why is because Derek Wright, Monk Tong's attorney, took the stand and basically fell on his sword, saying that he, as the attorney, had missed in the factual acknowledgments something that Monk Tong apparently told him, his attorney, Mr. Wright. Monk Tong had told him, hey, that's not right. That's not a fact. That is not true. And somehow this untrue statement, this thing that Monk Tong did not agree with, this thing that we can say is not a fact, wound up staying in the factual acknowledgement, getting signed off on by Monk Tong, getting agreed to by Monk Tong when DA Love read it out loud in public or in court. And Derek Wright's like, hey, we just missed it. I don't know how. So, yeah, everybody should be streaming this. Cat, everybody should be streaming this. Everybody should be streaming this one. I mean, it's kind of a tangent to YSL, but if Monk Tong hadn't taken a deal, he would probably be in either this trial or another one. So, he is one of the co-defendants in a sense. Okay. So if Derek Wright is in there, then I would expect Derek Wright to say, okay, let's see. Do we see Derek Wright? There he is. All right, y'all. Hold up. Law and Crime's a little bit behind. Derek Wright is there, y'all. Law and Crime's is a couple of seconds behind Fox. That's Derek Wright, everybody. So the first question is, was he there? Is he going to be there today? Yes, he is there. Yes, Derek Wright is his lawyer that has been with him through this entire saga, from negotiating the plea deal to signing it to testifying in this trial, in this current trial. So the fact that Derek Wright is there is good for Monk Tong, in my opinion. Pop-Tart, nothing has happened yet. Literally, we just got video feed about a minute ago. We're seeing Monk Tong. He came in with a seemingly, y'all, let me try to give a play-by-play, a designer shirt, open, looking easy and calm. They sit here. He's whispering or speaking quietly with his attorney, Derek Wright, who's in a gray, light gray suit. Now, we want to remember that Derek Wright was his attorney, was Monk Tong's attorney during the plea deal negotiations, during the signing of the plea deal, during his YSL testimony. And here we see the two of them seated together during Monk Tong's probation revocation hearing. Okay, and now we pan back. Now we pan back to the Georgia State Seal. Why should the Ashley Merchant letter help Monk Tong? Why should the Ashley Merchant letter help Monk Tong? I did not read. I did not read it. Okay. Let me see something. We don't have any audio. They didn't turn the audio on. That might have been why my mic sound muffled. Y'all, this is not me. This is not the feed that I have. I have another feed on over here by me, by my side, and there is no sound on either feed. So don't kirk out. You don't have to try to go somewhere else. There is no sound on either feed. Y'all know that the court has been dealing with sound issues. Yesterday, when the key thing that happened, the sound went off. And here we are. Fox doesn't have any sound. Neither does Law and Crime. This is crazy. I don't know what's going on with these sound people, but they really need to get it together. Okay. I think the sound's coming through now.
All right.
All right, give it a sec.
This is a probation revocation matter.
Yes, Judge. State filed a notice of a probation revocation for the defendant.
Y'all, I might go to Fox because I
as
think
to his violation of the special or a special condition within the sentence that he received from Judge Glanville on December 8th of 2023. As
Can y'all hear it now?
to his reviewing, acknowledging that the factual acknowledgments that were a part of the plea agreement in which he entered into on
Right.
December 8th of 2023. I have a certified copy of the conviction for your honor with a certified copy of the indictment, as well as a copy of the transcript of the plea that was taken on December 8th of 2023. An exhibit within that plea transcript is the plea agreement, which includes the sections, I believe it's sections 4 and sections 5 of the plea agreement as it relates to the factual acknowledgments that the defendant swore under oath during the plea that he had reviewed, then initialed each one of the factual acknowledgments, and then signed that he again understood and had reviewed each one of the acknowledgments that he initialed as part of the special conditions of his plea, that when called to testify, if called to testify, that the specific factual acknowledgments within the plea agreement were true and accurate statements, and that would be the testimony that he would provide as it relates to his witness testimony during the trial of this case. So I would present to the court State's Exhibits 1 and 2, as well as a USB drive of the defendant's testimony on day 124, 125, 126, and I think 127, Your Honor, but all of the defendant's testimony can be found on State's Exhibit 3. As everyone is aware, Your Honor witnessed it and can take judicial notice of everything that occurred during the testimony in which Mr. Sledge did testify. And I believe the court during, I think it was day 125, helped direct the defendant to sections 4 and 5 of the plea agreement during the testimony for him to focus on and read and to go one by one and acknowledge or disavow is the only word I could really think as to being no longer true and testifying under oath that he was violating the special conditions of his probation, Your Honor. So this time I would tender State's Exhibits 1, 2, and 3 for the court.
All right, I'm not quite sure I understand what 3 is.
3 is a USB drive with all of the testimony of the defendant. If Your Honor wants to preview it or wants to be part of the record.
Is that from the official transcript?
Well, it's the YouTube link, the live stream of all of the.
Okay, I'll just take judicial notice of it. I mean, if you want to make an exhibit, that's fine, but I'm not going to be relying on that. Since, as you know, it's only the official transcript that is the official transcript anyway, but I was here and witnessed it, so I will take judicial notice of it.
Yes, I'm very much aware of that. The transcript obviously is not ready as we're still in the midst of the trial.
Right.
I didn't want to overwhelm the court reporter who has been doing nothing but probably working hardest out of everyone in the courtroom. So I knew, Your Honor,
All right.
we could take judicial notice.
Thank you.
Can I approach this?
You may. And can you try to use a mic, please?
Yes, Your Honor.
Can they go to the court reporter?
Nothing further from the state at this time, Your Honor.
All right. Mr. Wright,
Your Honor, may I remain seated or?
it's probably easy. You can. It's probably easier to hear you that way.
Okay, I think I'm on. Your Honor, if it'll please the court, I believe, and I already sent to the court defendants 1 through 6. Defendants 1 through 5, I believe, were already, I think my emails between myself and Ms. Love came into evidence during our testimony.
Came into evidence in the trial of the defendants that are on trial right now.
Yes, Your Honor.
Yes.
So those are sort of resubmissions
Okay.
of those, but I do think they're already before the court, or the court can potentially take judicial notice of that.
What is your exhibit 6? I think I
Well,
only got
exhibit
5.
6 is the one thing, and that's just a listing of my emails in December between myself
Oh, that's
and
this
Ms.
one
Love.
page?
Yes.
Okay, it didn't have an exhibit marker on it.
I'm sorry,
so
Judge.
That's fine.
And so succinctly, I thought it best to submit these exhibits. When you look at exhibits 1,
And
2,
those are admitted for purposes of this record, which is the probation revocation matter.
Thank you, Judge. When you look at exhibits 1 and 2, what you see going on is plea negotiations in this case started on December 27th between myself and Ms. Love. You can see it's in the evening hours, and that's one reason I wanted to make sure that the sort of the cover page along with the attachment are part of these exhibits. At approximately 4:57 p.m. is when the email first comes in from Ms. Love. You see that a second one, defendants 2, comes in at 5:06 p.m. And at some point I respond. Those are the only 2 exhibits or the 2 drafts which occur on the 27th. However, it's important to note that when you see the response that I send to the email at 5:06, I send that response at 8:42. And I point out specific issues with the draft that need to be revised.
Right.
Now,
Yeah, and I recall we discussed this during the trial of this, the ongoing trial as well.
Yes, Your Honor. And the point I won't belabor it is these revisions you actually see being put into the drafts. So by the time you see defendants 3 and defendants 4, they note that there's attachments updated to. You see that those very revisions that we requested are being put into the actual drafts. And ultimately, it was defendant's exhibit 4 that if you look on defendant 6, when the email comes in, it says, use this one. That is the agreement that we thought we were executing on the 28th. And remind you, on the 28th, we're in court. This isn't where I'm at my office. I can print it out, look at it, take it to the client like we did on the 27th. On the 28th.
On the 28th, both you and Mr. Sledge are in person in this courthouse, right?
Correct. So the emails, if you notice, I never respond because I'm here, I'm in person.
Right.
So we would get it and via phone, or if they would give me a draft, to take to him, I would literally go from the conference room back to the holding area. We would go through it, go over it. But the one that we thought was going to be the executed final was the same one that they said on defendants 4, use this one.
But are you testifying now, or are you just recalling for me the testimony from previously during this ongoing trial?
I am asking the court to take judicial notice.
I will
testified
take judicial notice of what both you and Mr. Sledge testified to in the trial. I recall it.
Understood. So ultimately, the last thing that I think we mentioned in our testimony was where we did take issue with some things. We said he'll have a chance to answer the question and to explain. Now, there was a big problem, and I noted in my testimony that number 8 on that version that got signed had been taken out, removed. All of a sudden it reappears and it's there. My client initialed it. Yes, it was tendered. But ultimately, here's the problem. My client has always said he does not know who's responsible for shooting the victim, who he never was a participant or heard about planning the murder of the victim. And therefore, number 8 was put into evidence by Ms. Love to the court when it was a knowing statement. She knew that statement was false. That is.
Yeah, I'm not sure about that. That may be your contention, but.
Well, we would contend to the court that where my actual email defendants 2 clearly denoted that.
It does not. That is up for debate what that denotes.
It is removed from all the drafts and then ends up back in.
That is true.
So.
But your response on your defendant's exhibit 2 to what is then item number 4 does not definitively state anything like what you just said.
Okay.
He said he did not know, as we discussed at the time of the ongoing trial, could have been interpreted in several different ways. But I understand what you're saying.
And just so
you maintain that the 2 of you both missed the fact that you signed, or your client signed, a factual acknowledgement that included item number 8.
Correct.
And then when Ms. Love read it out orally in the court, and Mr. Sledge one by one said, yes, I acknowledge that somehow that didn't occur to you at that point in time either. So I understand what the assertion is. Here's the thing. You seem to be focused almost wholly, if not wholly, on, well, maybe there was a mistake with regard to factual assertion number 8. The issue that I see is that the state has not limited their petition to revoke probation to he contradicted or he refused to acknowledge during the trial that item number 8. It is the entirety of disavowing factual acknowledgments, etc. And what got disavowed under oath in this trial was far more than just item number 8. It was item number 3, item number 4, item number 5, item number 6, item number 7, item number 8, item number 9, item number 16, and then the part 5. Sentencing acknowledgments, number 1, number 2, number 3, number 4, number 5, number 6, and the paragraph underneath asserting that he's read and that they're true and that he understands that he's had an opportunity to discuss it and he voluntarily enters into it, et cetera, et cetera. So even if we entirely disregard item number 8 of the factual acknowledgments, there are still however many other ones that added up to. that the state is still relying upon. And I don't see how you get around, and maybe you have a way to get around the rest of it, and I'm certainly willing to listen. But that one thing is sworn to in open court on December 28th of 2022, and then something diametrically opposite of that is sworn to under oath back on September 5th of this year.
I understand your concerns, Judge. One of the things that we traveled on after taking the plea was he would be able to explain his answers if he had issues.
Can I ask you a question about that? Is there anywhere in the guilty plea agreement in sentencing of your client in December of 2022 where you reserve that, where anybody, the state, the defense, or the court puts on the record that that's part of the understanding?
It is not in the written plea agreement, no.
All right.
However, in evaluating my client for the purpose of this hearing, I don't think the state is denying that that is something that it was understood. Understanding it's not in the written plea agreement, but it was understood. And the other thing to also take note of, my client, when asked to make himself available, to meet with the state, to be prepared by the state, at all times would show up and do that. He was never provided or questioned it with any details such as, here, let's go over your plea agreement, these factual allegations, what questions may be asked. In other words, what you saw at trial was someone who was now, after what was that, December of 22, was now for the first time being drilled or asked questions rather as to the specifics of all the things that he had allocated, all the questions that were going to be asked. There was no preparation of him. So what you saw was probably frustration on his part at times and shutting down at times on his part. But it was also part of the manifestation of what happens when a witness who's not a lawyer, who's not someone used to this, is getting questions fired at them. And at some point, I think the court can take note that he literally shut down. And some of what the court saw may be more of a manifestation of being overwhelmed as opposed to trying to purposely change or diametrically say something different than what ultimately he allocated initially. So I, in retrospect, wish the state had actually, more than general questions, actually prepped him like you would normally see a witness be prepared and prepped. That did not happen. So you saw a very raw witness recounting things that happened quite some time ago and did not necessarily say things consistent with what he said before. But it wasn't simply for a malicious intent or an intent to deceive. There were several factors, is all I'm indicating, that may well explain why it was so difficult during his testimony.
All right. Anything else you want to present?
Your Honor, not at this time, no.
All right. Can the state give me a quick rundown of what this defendant's prior history is, including any prior probation violations? And then I guess I know that the probation officer is on here, so I'd probably need to at some point ask that officer if they would like to be heard as well.
And Your Honor, we would defer to probation as it relates to, I know they have a full account of his history as
All
it
right.
relates to.
You know what? I think I'm still on Zoom.
Yes, Judge.
Yeah. And what's the officer's name?
Oh, that's
Jolly. Oh, it's my regular probation officer from long ago, whom I haven't seen in the last 2.5 months because I've been otherwise occupied.
Hello, Judge Whitaker.
Hello, I'm trying to, oops. Okay, I'm trying to get myself on video. Ah, I know. So that it's not a disembodied voice. Hang on. All right. Hello, Officer Jolly.
Hello, Judge.
All right. What is probation's? Can you give me a rundown of Mr. Sledge's criminal history? And I'm sure you heard the question I just asked, as well as any prior probation violations.
Well, currently, he'd used his first offender twice, one for DeKalb County, one for Fulton County.
Well, that's lucky.
The DeKalb,
Since you're only supposed to get to use it once. Okay.
yes, so the DeKalb County case, 04CR24799, that was theft by receiving stolen property, felon, and a obstruction of law enforcement officer, which was a misdemeanor. That was May 19th, 2005. I'm sorry. He used his first offender. The second case, 04SC23883. That's Fulton County. He used his first offender. That was possession of cocaine, as well as a possession with the intent to distribute cocaine. That was December 10th, 2004. The possession with intent to distribute cocaine in Fulton County was January 3rd, 2014. Again, both times, all three times, he used his first offender. The next case is 15 SC 138994. That is a Fulton County case. That is the gang participation, aggravated sex battery, attempted aggravated sex battery, aggravated battery, aggravated assault, criminal damage first degree, criminal damage second degree, and possession with the firearm by a convicted felon. That was January 10th, 2018.
All right. So given the fact that he had at that point a possession of a firearm by a convicted felon, does that indicate that at least one of those first offenders was not successfully completed?
One
Or are we
moment.
missing a felony?
One moment.
He was adjudicated guilty.
That would be correct, Your Honor. In addition, of course, the current case that he is currently on probation on. As far as previous revocations,
So hang on. So the 15 SC and then this 22 SC case, right? Is there anything
Correct.
between the two of them?
there's nothing in between the two of them, no.
Okay. Are you looking about prior revocations or prior violations?
Yes, at this present time, I don't see any prior revocations. There was one documentation. It's a little bit, I guess, I'm having a hard time understanding what they meant by it. One moment.
Judge, while she's pulling that up, there is a 13 SC 123423 out of Fulton County. It's a BGCSA, possession of cocaine with the intent to distribute, where the defendant received 5 years probation on January 7th, 2014, which would be the predicate or basis for the possession of a firearm by convicted felon of the 15
I figured
SC.
there had to be something else there. Okay.
Sorry, I should have spoken sooner. I apologize.
Appreciate it.
Yeah, the only documentation that I have regarding a revocation just said, revoke closed, July 16, 2008. Doesn't really show any actual time served or any time being revoked or continued on probation back in 2008.
Okay.
So I'm unsure if that's an actual, revocation that was completed.
Okay, well, yeah, it sounds like maybe it was revoked, but it was just wrapped up in something else is how I would take that. I don't know, but, or that that a violation was found, but we don't know what that was or anything like that. All right, so does probation have a recommendation in this case?
Due to the last minute notification of this, probation revocation, I would leave that up to the courts to make that decision.
Okay. All right, well, I find there to have been a violation as alleged, and again, even discounting the item number 8. What is the state's recommendation?
In full candor to the court, Your Honor, I'm going to leave it. The state is going to leave it in the full discretion of the court. Your Honor is fully aware of the conditions. Your Honor witnessed the testimony and how it affected the trial of the case, and I'm going to let Your Honor be the full steward of deciding what the penalty should be as it relates to all of the time that Mr. Sledge still has remaining on probation.
All right, well, I know that at least, I believe in the petition for revocation, the request is that the entire 30 years be revoked. Is that right?
It's not the request.
Or is, oh, you're just telling me that's what he has at this point, although it can't be all of it, right? I mean, he's been on probation for at least a couple of years, and did he serve it? What's left?
He just started on December 8th of 2023. I think he got credit for the time. I think he was in for 2 years. So he would have 26 and change or 25 and change.
I'm sorry, correct, 22.
My bad.
Give the exact number. That would be 27 years, 7 months, and 8 days.
All right. All right, thank you. Anything else from either side?
No, Your Honor, nothing further from the state.
Okay.
Your Honor, if it'll please the court, I understand the court's ruling that there's a violation. Ultimately, I guess to some degree, while it's not clearly akin to a substantive versus technical violation of probation, it is a non-violent, non-new offense kind of violation. And I would say if the court is going to violate my client, it would be more germane to treat it as a technical violation. We have expressed to the court different thoughts and reasons for the way the testimony came out. We don't know what effect, if any, one way good or one way bad, that has had. But in terms of his violation, I would ask the court treat it more as a technical. He has one grandchild on the way, one that just came early this year with Ms. Jaquila Freeman. So the point is, he has been staying out of the way. He's been complying with probation. I would ask the court to maybe consider if you want to put more restrictions and make his probation much more of a, not just something he's on, but something that now has more teeth to it because he's been working. He's been taking care of his family. He's staying out of trouble. He's turned that corner. literally, it was always our hope he wouldn't have to come in and testify. And there was a reason the state allowed this plea to go forward so that he could step away. And in doing so, if you recall, you may have remember from his testimony, by no fault of his, he was a victim of a crime where he was shot multiple times and had to recover from that. So we would ask the court to consider some restrictions first, as opposed to custody. And if you do go with custody, we would ask to consider it as a technical type of violation, not a substantive violation in which you would be authorized to give him an even greater sentence. So we would leave it in the discretion of the court, but we're asking again for a non-custodial revocation punishment.
Okay, well, I don't view it as a technical violation or akin to a technical violation, considering the solemn oath that he took when he said that he understood every term within the plea agreement, factual acknowledgements, and sentencing acknowledgements, and understood and, in fact, orally answered that he understood when both asked by the prosecutor and the court at his plea hearing that a failure to abide by any of the terms would constitute a violation of the agreement, and he was notified that the entirety of his probation could be revoked. I do appreciate the fact that this particular violation is a non-violent violation. But I also appreciate the fact that some of the many why this could have occurred include the fact that there is just not a proper regard for the judicial system and the seriousness with which an oath in court needs to be taken. I actually view this much more akin to perjury, frankly, than a technical violation. And the sentence for perjury is up to 10 years. I am going to revoke 5 years of Mr. Sledge's probation. And Mr. Sledge, I am sympathetic to the fact that you have generally stayed out of trouble, and I want to commend you for that. And I really hope that this revocation doesn't set you back. But we've got to take seriously the court system. So that's the sentence of the court. I find there to have been that violation. I'm revoking 5 years.
And
And he will be continued on probation, Your Honor?
Yeah, and reinstate the balance.
Thank you.
Might I ask, is it possible for my client to turn himself in to make arrangements?
I think y'all knew when you came in here that this was a strong possibility. So no, I'm sorry. All right, court is adjourned.
Good seeing you, Judge Whitaker.
Yes, thank you. Good to see you.
All right.
The only person you could hear was Miss Jolly, so the only person you could hear was Miss Jolly.
Oh, wow.
Not on Zoom.
Yo, Moontoon.
I didn't know the sound.
Y'all be at that. Let's go to the next room.
Oh my gosh, y'all. We just watched it. Can y'all believe it? Like, this is crazy.
We need the order from Miss Jolly.
This is crazy, y'all.
Did you find all the
We just watched Moontoon go back to jail. And he gonna be in there for some years, y'all. I don't even know how to understand what we just watched, to be honest, because I gotta go back and watch and see, did they say what S word did they say about Moontoon? I got to go back and see what S word they said. Was it a 6? You know what? We can go back right now. Let's go back right now. Y'all, for everybody, thank you for being here. I'm going to go back. I just want to see what that S word they said for him was when the lady was giving the rundown. So I'm just
the only documentation that I have regarding a revocation just said is first offender.
Okay.
County.
Well, that's
the DeKalb.
Since you're only
I'm
supposed to
gonna watch this again. I want to hear.
Yes. So the DeKalb County case 04 CR 24799. That was theft by receiving stolen property, felon, and a.
I want to hear the whole thing she's gonna say.
Hello, Officer Jolly.
Hello, Judge.
Okay, we about to go back. We about to go back and watch it.
Probations? Can you give me a rundown of Mr. Sledge's criminal history? And I'm sure.
All right, we're gonna let it load up, y'all. She's gonna take a second to start talking.
Violations.
So,
well, currently, he'd used his first offender twice, one for DeKalb County, one for Fulton County.
Well, that's
the DeKalb.
Since you're only supposed to get to use it once. Okay.
Yes. So the DeKalb County case 04 CR 24799. That was theft by receiving stolen property, felon, and a obstruction of law enforcement officer, which was a misdemeanor. That was May 19th.
Y'all, let me say something real quick. I want y'all to keep something in perspective. This man was facing 30 years, but he didn't want to tell on his friends. He was facing 30 years and he didn't want to tell on his friends. And he wound up getting free for a minute. And through a long circuitous route, he wound up getting 5 instead of 30. Think about it. He was facing 30. He didn't want to tell on his friends it's just my interpretation. He didn't want to say that his friends committed this murder. And he knew that this day was coming. He knew this was coming. He was hoping, okay, hopefully they won't call me, but they might call me. They called him, but the whole time they weren't calling him, he was free. So he really deserved 30 years according to the state. That's what they felt. They felt he deserved 30 years and he had that on him. He was caught. It was over for him, but they gave him a way to get out of the 30. So he had to make a choice. Either I could get out of the full 30 and tell on my friends, or I could do like this little half thing I did and get 5. So he really had the power within his hands to either tell and stay out and not do any time, or do what he did. And he still didn't have to do the 30. He's only going to have to do not even, 20% of the 30 would be what? 6. So he's not even going to do 20% of the time that they were trying to give him. But I do want to hear, did it say set? I want to hear what it said.
2005. I'm sorry. He used his first offender. The second case, 04 SC 23883. That's Fulton County. He used his first offender. That was possession of cocaine, as well as a possession with the intent to distribute cocaine. That was December 10th, 2004. The possession with intent to distribute cocaine in Fulton County was January 3rd, 2014. Again, both times, all 3 times, he used his first offender. The next case is 15 SC 138994. That is a Fulton County case. That is the gang participation, aggravated sex battery, attempted aggravated sex battery, aggravated battery.
Attempted aggravated S battery, y'all. So, it wasn't 6. It wasn't 6. It was S with the E in the middle. Y'all, honestly, y'all, I'm a bit of a contrarian, but this Montung's going to jail. He's going to prison. For him, that's terrible. Not making light of it, but She didn't throw the book at him today. She didn't throw the book at him. She could have given him 30 years, yo. Yeah, you're going to do 5 years and like 22 more on probation. He's never going to get off probation. And not rocking with the attempted, aggravated, whatever. No. So it's a sad day for him, for his family. But y'all, if you're thinking about this tonight, just remember this. Montung knew what he was doing. When he went in there and he testified, he knew what he was doing. Okay? So we definitely wish the best for him, for his family. It doesn't sound good that it came out that he has that aggravated S thing on him, because apparently they don't like that in jail or in prison. But he when he got up there, he's not new to this. He's not new to this. He's not new to this. He had and he had counsel, and he had his lawyer there. He knew what he was doing. His lawyer, I'm not gonna say anything about his lawyer, but anyway, y'all, thank y'all for being with me. We've been here since 9-something. We rocked another practically almost 8-hour day, 7.5 hour day. Appreciate y'all. We're gonna go ahead and chop this up and make a video about Montung. Thank y'all for being here. Y'all have a good evening. And I guess we won't be seeing each other till Monday, so have a good weekend as well. If you haven't, please do like, comment, subscribe on today's video. We released one earlier. We'll be releasing this Montung video soon. Like, comment, subscribe, and I will see y'all on Monday. Bye-bye.